It's applications and order for twins present.
But
Have you forgotten to mention, Lordship, a
Others
hearing?
we'll take.
that this application, my lord, pursuant to my lord's direction by the previous order, needs to be tagged with this FMAT, my lord, which is due to
You have indicated there.
My lord, this order, my lord, as well as
They can hear. Yes.
My Lord, I am mentioning one matter on 4th December.
No, application or order for twins.
We mentioned matter
We mentioned also. We mentioned for what purpose?
For appeal is be ready
As per
by the
direction.
appellant,
Yes.
but has not done.
Not application or order for twins.
no, not this.
Achha, you start from there.
Have you permitted to mention, Lordship, a hearing matter for first appeal? You Lord mentioned it.
Same.
Mentioning for inclusion and land matter, my lord.
Land what? I mean, application or what?
Application, my lord.
Checkups.
No application, only hearing, my lord.
No.
Well, an appeal in
My lord,
connection.
paper book is already ready, my lord.
Understood. Yes.
Well, an appeal
Yeah.
in connection with the contempt matter has been assigned to your lordship's bench. Well, only thing, my lord, just 1 minute, my lord.
Assigned after assignment, it has never appeared before
No,
us.
no, no. It is
Let it
appearing.
appear as to be mentioned. We'll pass some
Well,
direction.
Yes,
To be mentioned.
137, 138. I think.
It's appearing in the list.
Yes, my lord. It
Then
is never, my lord, it has never been taken up.
taken up is different, but it's appearing in the list.
It is appearing in the list. My lord, only thing I should be honest, my lord, it emanates from a contempt matter itself. But in a contempt matter disposed of, certain directions were given. My lord, certain directions.
When you take up Mr. Chakravarti,
No, difficulty means another bench is taking up the first appeal. My lord, I should be candid, my lord. What happened, my lord? That's why I said.
let the first step will be decided in the meantime. This will abide by that. Why mention?
No, my lord, some
No
urgency-
mentioning.
My lord, 14
call on the
the
list,
next
please.
day.
Milord, may I approach your lordship? Milord, 400 crore workers. Milord, the renewal has not been given of a particular mine, Milord. Milord, 400 workers are out of their job for 3 months, Milord. It is appearing in the list. Milord, kindly, I had approached your
Which matter?
Milord, 1800 2025 and
Which item today's
uh,
list?
today, Milord, 46 and 47.
Why 400 workers? What have you challenged here?
Milord, actually the renewal. So the rules of 2016 that
For
gives.
the company,
I'm the company, Milord. My renewal has not been granted.
so bothered about the workers, it would not be in the such doldrums.
Milord, I have some particular judgments.
Cite
If
the
your lordship-
workers for your matter be getting. The
Milord,
company.
I am entitled for the renewal, Milord, as per the 2016 rules. Milord, I have 2 mines there. In one mine there was
Mining license was refused to be renewed.
to be renewed, Milord.
What is already up there? I mean,
Milord, it has been appearing for the
46,
past.
47, we won't upgrade. Sorry, right now.
Milord, it has been appearing for the past 2 weeks. Milord, it was 50.
2 weeks is
50.
nothing compared to
it
the
has-
time scale of high courts. Yes.
Milord, the first.
Sorry.
Milord, I beg before your lordship. Milord, it has been appearing
Say
for.
that ever before any court of law or anybody. No.
Matrimonial appeal, my Lord, but due to
We are not taking up. You are seeing that we are not adding hearing matters. Please
Milord,
don't waste time of court.
Milord, any day this week.
due to pendency of the appeal, my Lord, lower court has noted.
Please call on the list.
Milord, any day this week.
No further mention. No further mention.
Milord, any day this week.
Do you seriously think, both of you, that insistence it helps in this court? If you think so, go on throughout the day, so that the other matters cannot be taken up and other mentionings will come up, will accumulate. Let us dispose of matters, sir. We are here to dispose of matters, not to hear mentioning that throughout the day. Yes, one. এটা কি 5 লাখ দেখে নিচ্ছে সিটি কোড কিনে শুধু দেখেন সিটি কোড নয় নদী
Nodia.
আচ্ছা এই যে দেখিয়ে গেল আমাকে 50,000 করে ডিগ্রি আর এখানে ভ্যালুয়েশন মেমোরান্ডামে দেখিয়েছে 5 লাখ
শূন্য বেড়ে যাচ্ছে।
শূন্য বাড়িয়ে দিয়ে এখানে দিয়েছিল আমরা দেখিনি ও পয়েন্ট আউট করে You're appearing in this matter?
Yes, as appellant.
For appellant?
Yes, Your Lordship.
Acha, you moved the matter, you did not point out the valuation is shown in the decree of the trial court as 50,000.
It was not.
50,000. But you evaluated you mentioned the valuation in the memorandum as 5 lakh. If it's 50,000, we don't have determination to take up the matter. We'll recall that order and dismiss the appeal, saying that we don't have territorial jurisdiction, pecuniary jurisdiction, and with liberty to you to take back the certificate copy and go wherever. You should have pointed out. Even the respondents did not point out it. Past directions admitted the appeal, not admitted the appeal, but passed other directions.
No, there was a reduction for paper books.
Condoning the delay and everything.
Yes,
Yes, paper book. We'll have to recall that order because we don't have pecuniary jurisdiction. It was never pointed out to us. Do you have a copy of the plaint?
I don't have right now, Your Lordship. Can it be kept tomorrow, Your Lordship?
No, 2 p.m.
2 p.m. Yes, yes.
2 p.m. Just come back with the plaint. Just check up whether the valuation is actually the decree is wrong or you are wrong. Right? So 2 p.m. this will be the first matter we take up.
Yes.
2 p.m. Thank you. এটা কোনটা ভুল আছে ডিগ্রিতে ভুল থেকে আমরা ডিগ্রি ডাইরেকশন এটা একটা ডাউট আছে এটা প্লিজ নেক্সট
I am for the respondent number.
for the written notes of arguments
written notes, my lord.
I am for the petitioner
file your
respondent
written
number
notes we'll
1
just record
and cross object. Your Lordship.
দেখি written notes গুলো এক জায়গায় দিন appellants এর এখানে আছে state respondent আর you are for
I am for the writ petitioner respondent number 1 in
private
item
respondents in this epic right
and cross objector also.
yes absolutely written notes of arguments filed respectively on behalf of the appellants, comma, the state respondents and the writ petitioner stroke cross objector be kept on record. Since hearing has already been concluded, comma, the matter is reserved for judgment. Thank you. Thank you. এটা পাঠিয়ে দেবেন next mention নিচে ফিরে যাচ্ছে এবার হিয়ারিং হাত দিয়ে দেবো yes
So the respondent was 1 to 20.
is it appearing as to you
My learned friends for the appellants, my learned friends for the appellants, we had on supplemental written note yesterday. Very short reply to that. It's
Oh,
on
that if you have to
That prospective overruling, we had
did you take
cited,
those written notes written notes গুলো কই
I was told
but we had
filed
cited
our-
Golaknath regarding prospective overruling. It was not formally cited during the hearing. That was the only
No,
point of
hearing
objection.
Mr. Banerjee's point was the judgment is power in curia. Now he is saying it applies.
what is the answer to that
Section 2. My first answer is in the facts of the case.
let us just sort out the written notes of arguments first. This is supplementary written notes of argument respond
for
1
my
to 2 you are for 1 to 20
Yes, these are the
you are also using a supplementary note to this and your written notes original written notes are in the form of this compilation along with this supplementary
Yes.
yes Mr.
very short reply.
Yes.
My learned friend have premised their entire case on interpretation of the Delhi Airtech 2022 judgment,
right
which now they say, in as per their interpretation of paragraph 26, applies prospectively. Firstly, in the facts of our case, admittedly, no possession has been taken, and by the state's own admission in their report, where they say that sections 4 and section 6 of the Land Acquisition Act was complied with, it never reached the section 9 stage. So perhaps when I've used that language with the sanction of my senior, that it merely becomes academic discussion or a 2022 judgment. The other point that I have taken is the law was always this. 11A was introduced in 1984. So notwithstanding whatever the law they say was laid down after the lapse of the acquisition. So law has since 1984, the law has also been this. I have relied on 1991 judgment, which is also relied in the 2022 judgment, which also held that section 11A applies to section 17 proceedings. And also now to deal with the meat of their argument, if your lordship kindly reads paragraph 26 of the Delhi Airtech judgment, in my understanding of the judgment, it only applies to acquisition proceedings which stand completed. Here, there was no acquisition proceedings in the eye of law. So perhaps that prospective applicability of the judgment is only to the limited extent. We've troubled your lordship enough. I'm so grateful.
Supplemental written notes of arguments are filed by the parties. Written notes of the primary written notes had already been filed previously. Hearing is concluded and the matter is reserved for judgment.
Wait.
আজকে রাজধানী চালাবো রেডি রাখবেন পরে ফেল মেনশনিং গুলো নিতে পারছেন yes
Lord 5, my lord, I beg to appear for the defendant number 1 appellant. In terms of your lordship's last order dated 18th of September, my lord, I have served the plaintiff as well as his learned advocate. The affidavit of service page 6 and page 14 confirms that, my lord.
Affidavit of service you are filing today?
Yes, my lord.
File it. Mr. Ghosh is appearing for the respondent. One, right.
But then may I proceed?
Proceed. What is the matter, Mr.
My lord, suit for partition, injunction granted. My lord, there are
Ad
3
interim or temporary?
on contest. My lord, 3 gross improprieties in this order, my lord. First one, my lord, at what stage the plaintiff has come. The second, against who has come. And number 3, my lord, the undue hardship. Now, at what stage, my lord would kindly take the pain of looking at page 31, my pleadings. My lord, I have stated that I have purchased the plot of land and
This
I
is a
am
written objection to the injunction.
a written objection, page 31.
Yes.
প্রকৃত বৃত্তান্ত এই যে প্রতিবাদী একজন শিক্ষক হইতেছেন, নালিশি সম্পত্তি এই প্রতিবাদী জনৈক দলিল নাম্বার সাচান সাচ নিকট হইতে খরিদ করিয়া খরিদিস্তক দলিল দাতাগণের দখিলাগান স্থানে এবং তাদের দখল দৃষ্টে এই প্রতিবাদী দখলিকার হন আছে। এই প্রতিবাদী বর্তমান এলআর ও আর এ ম্যাপ ও রেকর্ড করিয়াছেন এবং স্থানীয় বিএলআরও অফিসে মিউটেশন কনভার্সন স্থানীয় পঞ্চায়েতের অনুমোদন লইয়া বিল্ডিং প্ল্যান স্যাংশন করিয়া দখলকৃত 7 শতক সম্পত্তির মধ্যস্থলে একটি পাকা বাড়ি নির্মাণ করার উদ্দেশ্য ভিত খনন করিয়া তাহার ঢালাই করিয়াছে। এই প্রতিবাদী পুরাতন বাস্তু পরিবারের সকলকে লইয়া বসবাসের অসুবিধা হইয়া নতুন কনস্ট্রাকশন করার উদ্যোগ নেন। নালিশি তপশিল সম্পত্তি 4 নম্বর প্রতিবাদী, 3 নম্বর প্রতিবাদী এবং 6 নম্বর প্রতিবাদী নতুন পাকা কনস্ট্রাকশন করিতেছে। Now my lord, the plaintiff has sought injunction only against me. He has
Or
restricted
one.
against me, against the defendant number 1. Now my lord, the kindly takes the inspection report that would appear at page well, may I just place the first the field report at page 56. My lord has found.
Yes.
Page 56, নতুন কনস্ট্রাকশন হচ্ছে কিনা। My lord has found. দৈর্ঘ্য 3.5 feet by these measurements have been given.
Yes.
And my lord, the report that appears at page 54, এই পিলার হইতে 11 ফুট 3 ইঞ্চি পশ্চিমে একটি কনস্ট্রাকশন দেখিলাম, যাহা ভিত হইতে কলম হয়ে বেস ঢালাই হইয়া, my lord, the second paragraph I am placing, হইয়া লোহার রড দ্বারা 12টি পিলারের স্ট্রাকচার দেখিলাম।
This is your construction.
Yes, my construction. This is my construction. Now,
Others have not constructed.
others have also making construction that will appear from page 54. These are the other constructions, the first paragraph and the last paragraph. The middle one relates to mine. And my lord, that is confirmed by the field report, which I have placed at page 56.
সাদা নীল রঙের building is not yours.
No, the second paragraph. Of course not.
It's a Ghos's claim.
Now, the
But
learned
you have not alleged that the plaintiff has made any construction.
No.
But some of the other
other
defendants are
defendants are making construction. My construction is at an advanced stage, and my case
You
before.
say advanced stage, ভিত হইতে কলাম হয়ে base ঢালাই.
Yes, base dhalai, my lord. That's
Base has been made.
yes, my lord. Now the building materials are lying idle, my lord.
What's your G plus? What's
The sanction plan that, my lord, I also have annexed.
how many floors?
Well, it's a dwelling house, my lord.
Dwelling house come in different shapes
Yes,
and sizes also.
my lord. 2-storied, my lord.
2 story. G+1.
G+1.
Very good. So your first contention is it they
He has allowed the construction to happen, and at what stage he has come. And the learned court, my lord, kindly takes now the order impugned ones. This was placed, the local inspection report was placed before the learned court. My lord, second last paragraph at page 57. Having heard both the parties and perusing the case record, it appears that the suit property is a HON'BLE property. It has not been partitioned between the parties by meets and bounds.
So other constructions are taken note of, but does not say who.
Who
So
has not? And but my construction is there. From the learned court also records that my
Yes, yes.
construction is there. No, my lord, my
foundation work has been.
foundation work has been done. Now, despite that, my lord, now, my lord, I have a paucity of pace, and my lord, that's why, my lord,
Before going on to Mr. Ghosh, you would be agreeable to demolish it if ultimately the.
yes, now, my lord, I have stated that in my application before your lordship at paragraph, paragraph 15, but I will construct in strict accordance to the sanction plan,
In any event,
and
without
I
any-
shall not claim any equity. And my construction, it's only limited to 2 decimals of land, and I have acquired 7 decimals of
You
land.
annex your sanction plan also.
Yes, yes,
Where is
yes. That is, my lord will find at page 49.
What would be your share if you if their suit is decreed in preliminary form? Sorry, plan is at page 40.
49.
Yes. And what would be the share approximately? We have to ascertain that you are not building beyond your area. How many co-sharers? 5 or 6 maybe.
My lord, co-sharers are 7 co-sharers, 8 co-sharers.
What is the total area? I mean, we have
Uh,
to understand that also.
My lord, total is 20 decimals of land.
So about 3 decimals per. You are constructing on 2.
I am constructing on 2.
Let us say, Mr. Ghosh.
But I have, my lord, so far as, my lord, this is my admitted position that it's a joint property.
No,
It's
no,
my,
regarding that.
that's my admitted position.
Yes, Mr. Ghosh, what do you say? There are already others who have made constructions.
Lord, your lordship, after the
And his foundation is already.
Lord, after the injunction order was passed, Lord, he has removed dissected the rods and removed all these things. It will appear from photograph, Lord, I have been sent. Second point, Lord, Lord, I have 20 decimals out of 52 decimals, 51 decimals.
You have 20.
Hmm?
You have 20.
I have 20 out of, Lord, 51.
Your share will be 20 if you get a decree in the party.
Yes. And, Lord, the construction, it is not agricultural land. Construction is being made.
There are other constructions also. As per the commissioner's report, court acknowledges that.
Lord, they were earlier construction in the old building, the old portion.
But on this property, therefore, other co-sharers must have built those.
Lord, this is this entire property. The other co-sharers had
So if the others have already built, he
Lord,
has made his foundation.
thatched
He has
house.
got a sanction plan which will
Lord,
lapse
thatched
by-
house, they have done it earlier. But now, Lord, this property is adjacent, this portion in which he is making construction, that is adjacent to my land. Lord, which is still agricultural land. I am an agricultural cultivator.
Mr.
And
Ghosh, he has to go by a sanction plan. The sanction plan wouldn't be issued if he is
Lord,
doing it
sanction
illegal.
plan has been issued without any intimation to us.
You need not be intimidated. There is no
Yes,
in law. There is no binding on one of the co-sharers to give an intimation to the
Lord,
other.
it is
And
as
others have made construction.
Lord,
they have made the foundation. Why stop them? They'll not claim any
Lord,
equity.
your lordship kindly consider this.
Yes, Mr.
Lord,
Ghosh.
they know what would be the effect.
But you waited till they made their foundation, and then because the
No,
local inspection shows.
Lord, after this order of injunction, they have removed the entire thing. The rods have been dissected and they have taken away.
The foundation is still there.
Foundation is there, but the rods which were there, they have dissected already.
That we don't know who dissected or who took away.
They have. Lord. I have taken photographs also. Lord, kindly see, Lord, the agricultural land in the side, if the
Got a
building
sanction plan which will
building is
make the building and then we'll
Lord, building is constructed, I will be seriously affected. My agriculture will be affected.
agriculture already foundation is there. Your agriculture is being affected.
No,
If it
Lord,
is
foundation, Lord, that will
foundation and story, vertical
if the
construction
building,
does
Lord,
not
if
make a
vertically
difference.
it is raised, Lord, it will affect the light, and Lord, your lordship knows.
Let it affect the light. Every building affects light.
Lord, that will not affect the agriculture.
Agricultural, vacant agricultural land, how your light will be affected?
Lord,
The plants will die for the
Lord, your
lack of
lordship
light.
knows that that I cannot cultivate my land. If there
You
is
already cannot cultivate because he has made a foundation. Unless there is a direction for
foundation,
demolition.
when
If there is a foundation, agriculture happens on the ground, not in the air, Mr. Ghosh.
Lord,
Foundation is
when
there.
he started foundation,
You cannot in any event make any agriculture there. You cannot plant trees there or whatever crops because there is already a foundation of concrete.
Lord, kindly
So let him
consider
build on
this
that.
foundation. As soon as the foundation started, Lord, we approached the learned court.
Already foundation was there. It
Lord,
does
they have
not,
done in the hot haste.
overnight it cannot be done.
Lord, in
Overnight,
hot haste they have done it.
foundation cannot be done. Dhalai and all these things cannot be done overnight.
Lord, your lordship kindly
And there are
consider.
other buildings also by other co-sharers.
Lord, that is, Lord, your lordship kindly see that is Lord much earlier. That is not
So
adjacent to my.
others have made their buildings.
And
Then
the
why
middle-
can't he?
Lord, I will no scope. Lord, even the partition is granted in my favor. Lord, declaring my share. Then Lord, I will be deprived of my land.
No, he will not claim any equity. We will make that clear in your order.
Lord, then Lord, I will take.
That is the meaning of not claiming
Lord,
any.
1% from one side, another person from other side, 20 decimals will not cover. Your lordship kindly Lord, appreciate the situation.
You are in
Covers
occupation.
in the middle portion.
You are not in occupation of the portion where he is making construction. Obviously, you are not.
Lord, it is agricultural land. One plot.
Court does not consider even not a single line. Have you stated it is agricultural land? He must
Yes,
have obtained
yes,
conversion.
Lord, that's why he has made conversion.
Then, if
He
he
has
has
made conversion of that portion.
legally, if he has made conversion, Mr. Ghosh, you cannot prevent him.
Lord, that is not behind my back.
It's no longer agricultural land
Not
now.
behind my back. I am a
Your
co-sharer.
back or in front of your back, agricultural land is now that portion has been converted already, Mr. Ghosh.
Lord,
So you cannot do agriculture there.
that has also been done. Lord, you also knows West Bengal Land Reforms Act, Section 4. Lord, he will have to give notice whether he is making
And
conversion,
you also
whether
know,
it will affect
you
me or
also
not.
know, Mr. Ghosh, very well, Land Reforms Act, that if he makes any addition to the property, any betterment of the property, if somebody gets it, he gets it with that.
And Lord, kindly consider, Lord, if 20 decimal is not by on a side, I cannot do agriculture on one side and other.
Agricultural, you now also cannot do till the suit ends because that foundation is already there.
Lord, on that portion I may not. But Lord,
That portion will make construction only, not further.
Lord, your lordship kindly
Make
see
it
in
clear.
case 20 decimals is allotted to me.
2 decimals is making construction. The plan says so.
Then Lord, his area is there, converted portion. If Lord he makes construction and use that, Lord, I will be deprived of cultivating my portion of the land, Lord, 20 decimals. One side 10 decimal, another side 10
Already you are
decimal.
being deprived. If there is already a foundation, you cannot cultivate over there.
That portion I
You
may
will
not.
make vertical construction over that. How can you?
Lord,
how can
if
it affect
kindly
this?
Lord appreciate. If this portion is constructed and this portion, my side, where I am in possession, entire portion, that here I get 5 decimals.
It's in the middle of the plot.
Yes, he has said.
You said it's the better part of the
He
plot.
said. He
Middle
said,
cannot be the better part. It has to
Lord,
be road adjoining.
Lord, kindly see. When in front of there is road. Lord, you will also kindly see. If,
Front there is a road, then it cannot be the middle. You can do
Lord,
agriculture.
kindly see this. If this portion 5 decimal I get, and this portion Lord 15 decimal.
Conversion sanction plan হয়ে গেছে সব। এখন agriculture
Lord, conversion he has done behind my back. Then Lord, I could have objected to do it. It has not been.
You should have. When he converted, you did not object. When he
Lord,
started,
converted, no notice. Kindly see Lord whether conversion order any notice has been served upon the
take the
person.
construction, Mr. Ghosh. The balance
your
of
Lord,
convenience
kindly
is in
consider
his favor.
Lord, I will be permanently prejudiced.
No, you will not be permanently.
By kindly Lord,
Nothing will permanently.
Lord, if Lord, he has not given any measurement. Your Lordship kindly see. In
It's a G+1 construction. Base is already there. Foundation, only one floor will be made over there.
Lord, kindly want appreciate this. If I am not get a plot of 20 decimals.
If you get it, you get it along with that construction. But that conversion is already there, and
But if construction is allowed, Lord, total building, then if I
not total building, 2 floors.
2 floors, Lord, in that case also, if this portion is allotted to me, Lord, your Lordship not settle principle of partition that in possession should be maintained. Lord, if it appears that in one side I am getting 5 decimals, in other side I have no intention to make construction, I have purchased agricultural land, I am performing agricultural activities there. Your Lordship kindly appreciate this. Let the Lord would be directed to be disposed of at an early date because they appeared, they have filed their written objection.
No, Mr. Ghosh.
Within specific time limit. Otherwise, Lord, I will be seriously prejudiced. Your Lordship kindly consider that. Consider my case.
Has been preferred by the defendant number 1 in a suit
and
for
he has
partition.
removed already. He has removed. Lord, upon
এখানে এসো শুনতে
he is appreciated. He has removed.
In a suit for partition. Next para. The learned advocate appearing for the appellant submits that the appellant, within bracket, who is the defendant number 1 in the suit, comma, is a teacher and purchased his share of the suit property by a registered deed. Subsequently, conversion of the portion which is in occupation of the defendant number 1 stroke appellant was obtained duly from the concerned authorities Full stop. Thereafter, mutation was also done and sanction plan was obtained by the appellant to make a construction. Full stop. Next para. After such sanction plan being issued and the construction having commenced and the foundation work having already been concluded, comma, the plaintiff stroke respondent number 1 filed the suit and obtained the impugned order of injunction. Push up, it is pointed out by learned counsel for the appellant that in the written objection, such position was clearly pleaded but overlooked by the learned trial judge. Push up, even the commission work which was held in connection with the injunction application culminated in a report which showed that there are other constructions over the suit property as well. First up, next para, it is submitted that the plaintiff waited till the foundation work was done and after obtaining conversion and sanction plan as well as mutation by the defendant number 1 stroke appellant and only thereafter to harass the appellant, comma, obtain the injunction from the learned trial judge. Full stop. Next para, it is submitted that as such, comma, the balance of convenience and inconvenience lies in favor of refusal of injunction, comma, since the appellant, comma, being a teacher, comma, is of meager means and with the said limited financial capability, comma, he has already accumulated construction material and obtained a sanction plan. Full stop. Next para, learned senior counsel appearing for the plaintiff stroke respondent number 1 vehemently opposes the appeal and submits that in the event the appellant is permitted to complete the construction work, comma, the agriculture which is being conducted by the appellant over the rest of the land would be adversely affected. Full stop. Next para, learned senior counsel further submits that the conversion was obtained by the defendant number 1 stroke appellant behind the back of the plaintiff stroke respondent number 1. Full stop. Furthermore, comma, it is argued that if a building is constructed on the said foundation by the appellant, comma, the light of the appellant, the respondent number 1 would be affected. For some next para, furthermore, comma, in the event a building is permitted to be constructed, comma, apart from the agriculture being affected, comma, since it is well settled that in a partition suit, possession has to be honored, comma, the appellant would suffer irreparably and it would be extremely difficult to do cultivation in the scattered balance portion of the land. For some next para, upon a perusal of the materials before us, comma, we find that the commissioner report clearly indicates that even apart from the construction being made by the defendant number 1, comma, there are several other buildings on the suit property. Since it is an admitted position that the suit property is a joint property of all the parties, comma, it is prima facie evident that some of the other co-owners have also made construction over their respective occupied portions. Although notionally, comma, every co-sharer has right over every inch of a joint property, comma, at the practical ground level, comma, there are people who are in actual physical possession of disparate DISPARATE portions of the suit property. Next para, considering the balance of convenience and inconvenience, comma, we find that the defendant number 1 stroke appellant has already obtained a sanction plan and has invested in getting a conversion and mutation of the portion occupied by the appellant and only thereafter has commenced construction. Full stop. After such commencement, comma, foundation level work has already been done. Full stop. Only at this stage was the injunction obtained by the appellant, by the respondent number 1, although the respondent number 1 was sitting tight over the matter till all the above paraphernalia were being completed by the appellant. Next para. Moreover, comma, it is submitted that the sanction plan is limited to 2 decimals of the land, which apparently would come within the share of the defendant number 1, comma, even as per the admitted position of the plaintiff in the suit. Even otherwise, comma, since the foundation has already been laid and conversion of the land as well as mutation has been done in the name of the defendant number 1 stroke appellant, comma, there cannot be any further uh, damage done to the agriculture than what has already been done, comma, which cannot be overturned unless the suit is decided otherwise. Full stop. Next para, keeping in view such situation, comma, we are of the opinion that there is no irreparable injury which could be suffered by the plaintiff if injunction is not granted, comma, which could not be repaired by either granting possession to the parties according to their allotments over the entire property and stroke or granting royalty money accordingly. Full stop. Next para, even otherwise, comma, the appellant has in writing within bracket in the present application bracket closed stated that the appellant shall not claim any equity on the construction and shall only construct strictly according to the sanction plan, which is of about G+1, which contemplates a G+1 construction. Full stop. Next para. In view of the above, comma, we find that the learned trial judge did not take into consideration any of the above aspects of the matter and, comma, in a mechanical fashion, comma, merely observed that a prima facie case has been made out, and since every co-sharer has equal right over the suit property, the preservation of the property is required, and as such, restrained construction. Full stop. Accordingly, FMAT 381 of 2025 is allowed on contest against the respondent number 1 and ex parte against the others, comma, thereby setting aside order number 37 dated June 30, 2025, passed by the learned civil judge senior division at Arambagh district Hooghly in title suit number 37 of 2022. Full stop. Next para. It is made clear that the merits of the suit have not been gone into by this court, and the learned trial judge shall decide the suit independently on its own merits without being influenced in any manner by any of the observations made above. Can 1 of 2025 is also consequentially disposed of, no address to cost.
Well, kindly consider
Affidavit of service filed to be kept under
that condition that in case it will be demolished.
without any equity will suffice. Without any, you get along with the construction.
My lord, there is one report of the learned Logima, my lord, that my lord, the name of the learned judge is not incorporated. May I
প্রথম লাইনে একটা অ্যাড করে দাও, leave is granted to the learned advocate on record for the appellant to rectify the
Well, I
defect
think
pointed
Lordship
out
has
by the additional stamp paper.
recorded his submission, but your lordship's order that equity, he is not claiming any equity and subject to.
I've said that. You've said that. আচ্ছা আরেকটা লাইন অ্যাড করে দাও। Yes, Mr. Ghosh, you are right. It is made clear যেখানে বললাম যে this court has not gone into the merits of the matter, তার আগের লাইনে একটা অ্যাড করে দাও। Needless to say, comma, as per the statement made by the appellant, comma, the appellant shall strictly adhere to his sanction plan while making the construction and shall not claim any special equity for such construction at the final hearing of the suit. I've made it very specific. Thank you. Yes, next matter. এটা পরেরটা কত এটা 6
I am for the appellant, my lord. This is the impugned order is not an appealable order, my lord, filed by mistake, my lord. Kindly grant me liberty to, my lord,
You
withdraw.
committed this mistake.
My lord,
You committed this mistake. You're
my
suffering
lord, it has been
experience.
filed by mistake, my lord.
Oh, the impugned order is what? I mean, under which
Impugned order is, my lord, arising out of proceeding under section 24 of CPC, my lord. Order of stay of all further proceeding, my lord.
learned counsel for the plaintiff appellant fairly submits that the impugned order is not appealable and as such seeks to withdraw the appeal. Full stop. Accordingly, FMAT 447 of 2025 along with Can 1 of 2025 are disposed of as not maintainable with liberty to the appellant to prefer an appropriate challenge before the appropriate forum against the impugned order. Full stop. The learned advocate on record for the appellant is granted liberty to take back the certified copy of the
Grateful.
impugned order upon furnishing certified photocopies thereof for the records.
Grateful,
No
my
address to cost. Thank you.
Sir, my lord, in this matter, my lord, I am appealing for the plaintiff appellant.
Yes.
Refusal to grant identity order of injunction.
No caveat, Mr. Rai.
There is no caveat.
No.
I am a tenant, my lord. Subsequently, development agreement was entered between me, my landlord, and the developers. where I am drawing lordship attention only to the clause 1 regarding my entitlement and my status in respect of the property in question. If your lordship may kindly turn to page 62 once.
Ad interim has been refused.
Refused on the ground that defendants' names are appearing in the agreement. My case is that I'm a tenant. I'm in settled position.
See the clause first, then we'll.
Yes, that is what precisely, my lord.
Page?
Page 62, if your lordship kindly turn to page 62. It is no, 62, 1. First party and third party cooperative.
You are which party?
I am the second party.
Right.
Tenant.
What injunction are you asking for?
They are
And what
started
is the suit-
demolition.
What is the suit for?
Suit for declaration not to evict without due process of law. This is the agreement on the basis of which there are certain conditions has been mentioned that upon fulfillment of this condition, I may be vacated and I'll be shifted to another place.
Injunction restraining them from?
From demolishing the nature and character of the property. They have started demolition suddenly.
Unless there is demolition, how can
No, that
developer-
is why, my lord, precisely, my lord, that is why. What is the clause mentioned, my lord, if your lordship kindly consider that locality cost of the third party to be paid 15,000, I have to be shifted apart from that 500 rupees. Apart from that, there has been delineation in the sanction plan regarding my
they have not given you
Nothing.
alternative accommodation, not this money.
not the money. Apart from that, the sanction plan has not been produced also. That's showing my occupation. This is the
Sanction plan?
sanction plan. There is the third party developer will make construction of the new building at the said premises according to sanction plan be to obtain on mutual undertaking. My lord, why it is necessary, my lord?
Which clause?
Clause 2, my lord, you will lordship find, and clause 2.
They have not obtained this.
Because they have to show my after now
Which portion will
which portion will be allotted.
How did the court deal with it?
Court, my lord, is of the opinion the agreement consists of 3 persons, so their presence is necessary. Precisely that will be my ground that I should not be evicted or no construction can be made. Last paragraph. This is the only
Both the
consideration.
landlords and the developers are the defendants.
Defendants. And annex the photographs showing
The present appeal has been preferred against the refusal of an ad interim injunction in a suit filed by the present plaintiff stroke tenant for declaration that the plaintiff cannot be evicted from the suit premises without due process of law and for permanent injunction as well as other ancillary reliefs. So next para, the case of the plaintiff is that a tripartite development agreement was entered into between the landlord, developer within bracket, both defendants in the suit bracket closed, and the plaintiff stroke appellant within bracket tenant bracket closed full stop. In terms of clause 1 of the same the landlord and the developer will cooperate the second party within bracket the appellant bracket close for vacating the ground floor of the said tenanted room measuring about 275 square feet to enable the first parties and the third parties bracketed the landlords and the developers bracket close for construction of new building and demolishing the existing structure. Push up more importantly, in clause 1, it is mentioned that during the period of construction of new building, the second party within bracket present appellant stroke tenant bracket closed is to be given sufficient accommodation in the same locality at the cost of the third party to be paid at the rate of rupees 15,000 per month. And the second party bracket appellant bracket close according to his desire and requirement with the said cost shall make arrangement for shifting his accommodation and said tenanted room in another premises according to his choice. Push up next para. Furthermore, clause 2 of the agreement provides that the third party stroke developer will make construction of new building at the said premises according to sanction plan to be obtained from the Kolkata Municipal Corporation on mutual undertaking. Push up next para. The appellant alleges that neither any money at the rate of rupees 15,000 per month or otherwise was given to the appellant, nor has any alternative accommodation been arranged till date. Moreover, no sanction plan has been obtained or produced by the developer. As such, in the event the appellant is evicted at this juncture, the same will be utterly unlawful and in stark contravention of the clauses of the agreement between the three parties. Full stop. Next para. However, comma, we find from the impugned order that the learned trial judge, comma, without adverting to any of the above facets of the matter, comma, mechanically observed that since the agreement was executed between three parties, comma, the others are also required to be heard before an interim order is passed, comma, thereby patently overlooking the extreme urgency involved, comma, in the event the appellant is ousted without due process of law and or adhering to the agreement, comma, it might result in a travesty of justice and irreparable injury to the appellant. Full stop. Thus, comma, we are of the prima facie opinion that the learned trial judge erred in law in refusing ad interim injunction by overlooking the necessary parameters for grant of injunction. Full stop. Accordingly, FMAT 461 of 2025 is admitted and shall be heard on the grounds taken in the memorandum of appeal and the observations made above and the questions indicated above. Full stop. Next para. The respondents and or their main agents shall remain restrained by an order of injunction from disturbing the peaceful possession and or ousting the peaceful possession of the appellant, comma, from ousting the appellant from the suit premises and or from alienating, encumbering, creating any third party interest in the suit property or changing the nature and character of the suit property till disposal of Can 1 of 2025. Full stop. The appellant shall serve copies of Can 1 of 2025 as well as a copy of the memorandum of appeal on all the respondents, indicating that the appeal and the application shall be listed together for hearing in the monthly list of December 2025, when an affidavit of service shall be filed by the appellant. Full stop. Next, by the appellants. Full stop. Next para, it is made clear that in view of the short ambit of the appeal, comma, the records need not be called for, and formal preparation of paper books is dispensed with. Full stop. It is understood that although the matter shall next be listed in the monthly list of December 2025 under the heading application, comma, the appeal along with the application shall be taken up for hearing. Full stop. The notice as indicated above, comma, if successfully served, comma, shall operate as the notice of the appeal as well.
Liberty to file the compilation of the documents which have relied upon by the court below.
On the prayer of learned counsel for the appellants, comma, liberty is granted to the appellants to file a compilation of the other relevant documents which are not annexed to the injunction application at the time of hearing of the
Which are relied upon by the court.
appeal and the application. Full stop. Next para. In the event the appellant relies on any documents, comma, however, comma, a compilation, copies of the said compilation shall also be served along with the present application and the memorandum on the respondents as directed above.
As in, so grateful.
Next.
Hello,
Yes, Mr. Shur, what is the matter?
yes, my lord.
You are for the respondent?
Wife. I'm for the appellate.
No,
The
no,
first time
yes.
I'm appearing for the respondent.
Yes.
Just a minute. The can has not been supplied to us. Only the FMA application is.
You lost the caveat.
Yes.
No, there was no caveat, my lord.
But the can has not been supplied.
Serve the as well as the memo and come back to. You have served a memo. You have got nothing.
Only appeal. This application.
Memo has been served.
Memo.
I'm serving the.
Serve the can.
Is it
Come back tomorrow. Learned counsel appealing for the respondent submit
And
that
file
no
the
copy of the.
position also.
No, we'll dispose of the appeal.
My lord, this is a custody application has been turned down by the court below.
Then we may require affidavits.
Yes.
What is the since there is no caveat? Let us hear you prima facie. Yes.
My lord,
You are the
my lord,
father or
I'm
the mother?
My lord, I'm the father. My lord, I filed an application under section 25. My lord, that was turned down by the court below. And my lord,
Age of the child?
age of the child, my lord, at present, my lord, he's 13 years. He's a boy.
Boy.
My lord, he's 13 years. Now, my lord, if your lordship kindly takes up.
There is no matrimonial suit between you.
My lord, there is a matrimonial suit, my lord, a suit filed by the husband for restitution of conjugal rights. As of now, it is pending. My lord, but
how long is the child along with your wife separately living from?
My lord, for about last 8 years, they stayed together for a considerable period of
The
time.
ground of challenge? No visitation has been given?
No, my lord, that is my primary grievance before your lordship for challenging the impugned order, my lord. The visitation right that has been given to the father is, it's in my humble submission, is vague, my lord. No.
Let us see that.
Yes, my lord. If your lordship kindly sees the last portion of the order, my lord, it is at page 6 of the impugned order.
Yes.
that the application in section 25 be the same is dismissed on contest. The respondent mother is allowed to continue with the custody.
Whenever the child approaches is also not beneficial to you, because it has been directed whenever he approaches with a gift, you have to give him visitation. So that will be troublesome for you and the child also. So why don't you agree to some
Well,
arrangement?
specific modalities, my lord.
Appreciate one thing, in the trial court also, the visitation right was given and the child was just
You're not,
appeared.
we are not being clear to
Then
you.
I can demonstrate it.
Here it
Why
has been
proceed?
directed, respondent mother will, however, allow the petitioner father to meet the child and accept gift whenever the petitioner father approaches the child for the said purpose without any hindrance.
Right.
So if he wants to harass you and the child, he can go twice a day even.
No,
You
my
have
lord,
to permit him.
my lord, I may kindly be permitted because I don't have the knowledge to that effect, because my client on the way come to the court, he became senseless. So
Not
I
a
need
question of knowledge. It's the order we are speaking about. Please look at the order,
to,
page
okay,
6.
okay, in the order portion, last part of the, I got the.
That gives him the right to visit whenever, wherever, whenever he likes. Even 5 times a day he can go there and ask for the child. You have to give her.
Yes. we
So
don't-
probably for your benefit also, we should fix a timeline and arrangement. So we'll make it fortnightly, 2 hours per weekend, so that there will be a structure to this visitation
lord,
and
what I-
dispose of the appeal itself.
My lord,
Take instruction from your
my lord,
client.
Yes.
my lord, what
I-
I humbly, my lord, I'm just proposing the suggestion because my lord, the boy has the grandfather is also not is want to see the child. So my lord, 4 or 5 hours on every Saturday or Sunday.
What is the distance between your
My lord, the father stays in New Barakpur and he's in Behala, my lord, Mohestala. My lord, the father will go and take the child
my lord,
in the morning and in the evening he will drop
for
it.
my knowledge goes as per instruction that there is a long dispute between the parties and there's so many proceedings
That
is
is
pending.
there, definitely.
So unfortunately, the wife has brutally tortured by the husband and the inmates of the maternal. 498 is pending
You
there.
cannot bring your troubles to the son.
No, definitely, definitely.
You are
not.
very clear
But
on this.
I may kindly be
Our view is very clear on this.
yes, I may kindly be permitted to take instruction only.
Take instructions, and the grandfather has a right also to see, so that he may take the child. Say we'll make it maybe once a month. He can take the child for 4 hours to his house, return it to your house, return the child to your house once a month. Proposal, not final. And fortnightly he'll go there and meet him.
So right, Your Honor. But my
Please
lord,
take instruction. Come
I-
back next week. We'll put it next Monday.
Much obliged.
We'll admit the appeal right now. The appeal has been preferred against an order whereby custody of a 13-year-old child of the parties has been given to the respondent mother. Full stop. Next para, learned counsel appealing for the appellant submits that the appellant father is primarily aggrieved with the nature of language in which the visitation right has been couched. Full stop. We find from the ordering portion of the impugned order that the respondent mother has been directed to allow the petitioner father to meet the child and accept gifts. Double inverted মধ্যে whenever double inverted close the petitioner stroke father approaches the child for the said purpose without any hindrance. Full stop. Next para, we are of the prima facie opinion that such a vague arrangement would not inure to the benefit of either party, comma, including the mother and the child as well, comma, since it permits the father to visit the child at any point of time, comma, even multiple times a day if he so chooses. Full stop. Next para. Instead of such arrangement, comma, it would apparently be appropriate if a structured arrangement is made, comma, preferably permitting the father to take the child once a month to his house for certain hours on a particular day at the weekend and return the child after the said period, and for the father to visit the child fortnightly at the residence of the mother. Full stop. However, comma, we offer such suggestion to the parties in order for the parties to take appropriate instructions from the to the learned counsel for the parties, for them to take appropriate instruction from their clients. Full stop. Next para. For such purpose, comma, the matter shall be listed next on November 24, 2025. Full stop.
my lord, kindly allow me.
The appeal is
Instead of
admitted and
24
shall be heard on the above questions and the grounds taken in the memorandum of appeal. A copy of the application shall be served on the learned advocate appearing for the respondent by the appellant during the course of the day.
Much obliged.
Yes.
Can it be possible instead of 24, it is 25 or 26?
Yes, yes, absolutely.
So
We'll put it on 2026 then,
Yes.
2 more days. 24th tak or 26th. Take instruction, come back. We have already given the proposal in the order itself. server copy and show it to your client so that
Much of
No,
it.
get this over with. Nothing, no
No,
further
I'm-
fees.
I'm also
One
on that.
further fee on the next day.
I am also on that
Much of
one.
We know that. Yes. Yes, Mr. Bhattacharya, what is the matter?
Milord, I'm praying for
Expeditious hearing.
expeditious hearing, Milord. If your lordship,
2016, why pen you must have done some mischief there.
Milord, kindly see dates, last few pages, Milord, of your lordship's brief from Milord 108.
What about the previous pages?
These are the order sheets.
So why was time granted? Just tell us.
Milord, time was granted, Milord, either, Milord, yes, in some occasion. we
Obviously, some
prayed,
occasions you have to.
learned government representative prayed for time. Then, Milord, reports were called for.
What is the challenge against?
Challenge. If your lordship would kind enough to come to page 96.
Presentation.
There was an earlier, Milord, order of this honorable court. Kindly see the writ petition is disposed of by passing the following order. The district collector, being the respondent number 1, is directed to consider and dispose of the representation being annexed G to the writ petition by passing a recent order in accordance with law within 8 weeks after the puja holidays of government department upon hearing the writ petitioner. In the event the prayer of the writ petitioner is allowed, steps must be
You are the
taken.
writ petitioner.
I was the writ petitioner.
What was the representation about?
Yes, kindly see, that is much clear, Milord. If your lordship would kind enough to keep page 118. This is the crux. Order dated 19th May 2025. Kindly see the third paragraph. The simpliciter grievance of the applicant is that the compensation available under the Estate Acquisition Act 1953 has not been disbursed to the applicant, though there has been a specific direction passed by the Honorable Court to dispose of the representation claiming compensation under the Estate Acquisition Act. In such state of affairs, we need to be
After that, did they say what they have
No,
done?
nothing. Milord, what, Milord, I propose, instead of going back to the tribunal, let them file this report before your lordship. Whether I get compensation or don't compensation, we may be disposed of.
The limited grievance of the appellant petitioner is that the petitioner's original application before the tribunal is not being disposed of for an inordinate period since 2016. The genesis of the grievance is that the petitioner made a representation before the respondent authorities seeking, primarily seeking compensation in respect seeking compensation available under the West Bengal Estate Acquisition Act 1953, which has not been disbursed to the petitioner, despite a specific direction of a learned single judge of this court to dispose of the representation at the earliest. Next para, learned counsel for the petitioner submits that in the event the respondents are directed to file a report instead of the tribunal before this court, as to what steps have been taken for disbursal of such compensation in favor of the petitioner, the matter may be resolved from here. In such view of the matter, the petitioner is directed to serve notice on the respondents indicating that the application shall be listed next on November 24, 2025, next week, next Monday.
Next Monday.
When an affidavit of service to that effect shall be filed by the petitioner. Compensation, your right has been ascertained. Do you have a right to get compensation? That also has to be.
That has to be, but that was my representation.
When they come, we can direct the representation to be disposed of.
Definitely, this is for the Milord. Milord, in addition to the, may I serve upon the office of the learned government pleader, Milord, that will suffice. All our government authorities.
On the respondents, along with a copy, along with a notice to the office of the learned government pleader.
I'm grateful.
Of the state.
24th.
I beg to appear on behalf of the
10 and 11, Mr. Sumitra Bandyopadhyay is
No, on the last topic.
I am praying only not this because
No.
last my
Sorry,
yesterday
we discussed your report.
Yes. I am appearing for the Calcutta Municipal Corporation.
Yesterday you are asked for time, we had granted you readily.
Yes,
No further.
but he has not come. That is the problem.
Why did you mention the matter then?
Not means it automatically come.
Automatically.
They want the matter to remain pending. My project is ready 1 year before it has been.
Are they enjoying any interim order?
They are not enjoying any interim order, my lord, but this is being shown as a lease pendants. They are saying that you upload it in REDA.
We'll make that clear that pendency of this matter shall not affect any whatever language you want.
Any of the rights of the,
shall not operate as a stay of the order imputed here.
shall not operate and shall not affect any of my rights and otherwise available under the law. If kindly say that.
This is the second occasion when an adjournment is sought by the state petitioners. Next para, learned senior counsel appearing for the respondent submits that due to the pendency of this matter, comma, the respondents are being deprived of their legal rights otherwise, full stop. Next para. In such view of the matter, comma, we adjourn the matter on the prayer of the petitioners till when?
Monday, my lord.
Till November 24th, 2025, as a last chance to the petitioners to move the matter, full stop. Otherwise, comma, ex parte orders may be passed in the absence of the petitioners. Full stop. Next para, we make it abundantly clear that the mere pendency of this writ petition before this court shall not operate as a stay of the order impugned herein and or affect the rights of the respondents, legal rights of the respondents, which are otherwise available to them.
But I am appearing for the Kolkata Municipal Corporation, my lord. With me, Mr. Gopal Das.
Yes, Mr. Banerjee, ask him to just give a slip.
Yes,
And একসাথে মানে? Can with one sentence? তাহলে আজকে আসেনি কেন? দুটোতে কমন অর্ডার হবে. Matters.
But in this matter also.
Both matters. Both.
Yeah.
Same appearance গুলো both matters এ দিয়ে দিও. Next. নাম যদি না পাও আগের দিনের নাম দিন. Please.
12, my lord.
My lord, I am appearing on behalf of.
One second. আগেরটা যদি সৌমিত্র বন্দ্যোপাধ্যায়ের নাম দেয় তাহলে দেবেন. ওর গ্রাউন্ডে টাইম চেঞ্জ যাচ্ছে রোজ. ওর নামটা ঢুকিয়ে দিচ্ছি. Yes, sorry. Please, Mr. Banerjee.
12, my lord. I am for
You are saying something, sorry.
She is for the respondent.
I'm for.
You are saying that.
No, my lord.
You are saying something else.
I'm start to proceed this matter, my lord. But he is saying.
But I am for the appellant.
Move it.
My lord, the difficulty is, my lord, the client is, my lord, client is not very interested, my lord. I have, my lord, talked to him. My lord,
Dismiss for default.
taken instruction for, my lord, that is good.
Non-prosecution then.
My lord, non-prosecution.
Non-prosecution, my lord, I need an instruction. My lord, that is the difficulty. I need a written instruction for non-prosecution.
Fault I will suffer, my lord.
Right?
My lord, after getting a position full satisfaction of decree, my lord, I have started cultivation, my lord. And since thereafter, my lord, they are starting same problem, creating, disturbing me, my lord. Therefore, I have filed this application to
So this appeal has been
protection,
filed against what?
to some protection, my lord.
Preliminary degree.
No, eviction suit. My lord,
No,
my lord, I was directed, my lord, to be evicted. Against eviction.
This is against eviction suit.
Eviction decree. Decree of eviction, my lord, I have already suffered.
declaration and
Declaration eviction. No, restoration of position. My lord, I was, my lord, directed to, my lord, deposit a cost of 10 lakhs, my lord.
Even if the client does not pay you, Mr. Banerjee, when you appear before the court, you have to go through the brief. Even if you do it
since
gratis, it is for the court because you are an officer of the court.
Certainly, I ought to.
Declaration that they are owners of the property. You get a declaration that you are owners of the
Yes,
property.
yes.
And eviction also. Directed to hand over. He is also right, you are also right. You have already levied execution.
Yes, my
What is the
lord.
stage of the execution?
Execution has got a position with the full satisfaction of decree, my lord.
Then what remains in the appeal?
My lord, thereafter, my lord.
Dismiss it for default. That's why they have lost interest.
My lord, I will suffer, my lord.
How?
I got thereafter I started cultivation, my lord, in that field.
How will you suffer if their appeal is dismissed for default?
My lord, they will create a problem in my harvesting at the time of harvesting.
Then we are allowing the appeal. That will not create any problem. Setting aside the decree. We are allowing the appeal. That will save you. We are allowing the appeal. Dismissal of their appeal operates against you. You have got a decree. You have executed that. You are in possession. You say if you dismiss their appeal, that will affect you adversely. Then you are allowing their appeal so that you are benefited?
No, my lord. Sorry, my lord.
What sorry? What did you think we are going to do? Why are you saying that if you dismiss their appeal, it will affect you?
My lord, they will again, my lord, create problem in my cultivation, my lord. That is the problem, my lord. I started.
So then we won't dismiss their appeal, even on merits, if you want to.
My lord, your lordship, as lordship.
No, how?
But give me some protection, my lord.
We'll send a set of armor to you. Wear that and go to the field and help your client. Learned counsel for the appellant submits candidly that despite efforts, he has not been able to get instructions from the appellants, his clients. Full-stop accordingly, it transpires that the appellants are not interested to proceed with the appeal. Hence, FA 214 of 2022 along with যা যা application আছে লিস্টে অ্যাপিয়ার করছে তন্ময় can such and such can 3 of 2023 and can 4 of 2025 are dismissed for non-prosecution without any order as to cost. Interim order, if any, stands vacated. Next.
Milords, I appear for the plaintiff appellant, Milord.
সকাল থেকে কি কি দেখতে হবে কি হয়ে যাচ্ছে কি ভুল করছে
Milord, I appear for the plaintiff appellant, Milord. Milord, I'm led by Mr. Thakkar, Milord. Milord, before your lordship goes into the merits, Milord, I was the plaintiff. My suit dismissed. Decree passed. Milord, from that the appeal, the first appeal.
What suit? Suit for?
Milord, suit for declaration and injunction that I am a tenant. I was in occupation, not to disturb my possession.
No
not
counterclaim
to-
for eviction?
No counterclaim for eviction here. There was a separate suit that they filed later on for eviction.
So that is still pending.
That is pending. That is pending.
He doesn't know.
That is pending. Milord, before your lordship goes into the merits, Milord, there are two applications which are
25 days
procedural.
delay.
Yes, Milord. One is delay. Before the delay, Milord, there's a substitution. The plaintiff, the sole plaintiff appellant, has died after preferring the appeal, Milord, in September 2025. Milord,
When was this filed?
Yes, Milord. This was filed in May.
September 2025, you are saying?
Yes, Milord.
Oh, within time.
Within time.
Has to be in time. We are still in time.
Yes, yes. Within time.
Which can is that substitution?
Can
The
number 3.
substitution is can number 3. The delay is can number 1. Delay of
First of all, my lord, will kindly allow this substitution application.
And then what should you do? Tell us. We'll just
Thereafter, my lord.
you just dictate the order. We'll just
No,
sign.
no, no, my lord. This is my humble submission.
We are, no, not your mistake. We are allowing the substitution. We are allowing this section 5 also. Section 5, what is the ground?
Milord, 25 days, Milord. The ground is that if your lordship takes one paragraph, Milord.
Medication, very well.
Paragraph 6.
Twice medication section. Can 3 of 2025 is an application for substitution of the heirs and legal representatives of the sole plaintiff stroke appellant. First up, since the application is in time and otherwise in form, comma, can 3 of 2025 is allowed, comma, thereby directing the heirs and legal representatives of the deceased sole appellant, comma, as mentioned in paragraph number 2 of the application, comma, to be substituted as appellants in place and stead of the said deceased. First up, next para, the necessary consequential corrections to the cause title of the memorandum of appeal shall be carried out by the learned advocate on record for the appellant during the course of the day.
Yes.
Next para, can 1 of 2025 is an application for condonation of delay in preferring the appeal. First up, we find that the delay is of about 25 days. First up, upon hearing learned counsel for the parties, comma, we find that sufficient explanation by way of the illness and continuous medication of the petitioner's wife during the relevant period have been made out for the delay. Full stop. Accordingly, can 1 of 2024 is allowed?
2025.
Can 1 of 2025 is allowed, thereby condoning the delay in preferring FAT to 24 of 2025. Full stop. The appeal is deemed to stand registered and admitted. What else?
Milord, can 2 is my injunction application, Milord. I was enjoying an injunction all through the hearing of the suit, Milord.
Is your main ground in the appeal?
Milord, yes. Milord, main ground in the appeal is, Milord.
Indicate to us.
Yes, Milord. Milord, the appellant was in possession since 1979 in one of the residential places in a society which is a welfare society for the Buddhists. Milord, the appellant's brother was a founder trustee. There's no dispute. He stayed with him after his death, continued staying. Thereafter, it is our case that there was a lease agreement entered into 5 years. After expiry, another lease agreement of 21 years. I kept tendering rent. Milord, here the interesting question comes in, Milord, on the tendering of the rent portion, Milord, where we say that we have been tendering rent month by month, which has been accepted.
Accepted. Then what? Then Mr. Thakkar come.
Milord, the only issue at
Rent
hand
was being tendered?
Yes, the question was the phraseology of the rent. Because we were tendering, they were accepting as donation, with donation receipts being one of the societies. Milord, that the learned trial judge came to a conclusion that that could not or did not tend.
Is any of the receipts annexed?
Yes, Milord.
Show us.
Mr. Thakkar.
Yes, yes. Just show us any one of the receipts.
Yes. Kindly come to page 56.
Can you have 56?
You are a tenant in respect of first floor, entire first floor? No.
My lord, a room,
Entire first floor.
entire first floor, shop room on the ground floor, which is used as a library and car parking space.
This donation was at the same rate every month.
Yes. And kindly see page 55 once, please. The demand for donation. I can understand there's a donation, but there cannot be a demand for donation. Kindly see, as decided in the governing body meeting, we have to inform you that the donation for your car parking space has been raised from so-and-so per month with effect from 1st January. This is the donation. And the same letter is at 54 and the same letter is at 53.
Interesting legal advice. So,
this
so
is
it was held to be a donation, therefore you are not a tenant and therefore you have been evicted.
Yes, I've been evicted. It is held to be donation.
Not evicted, sorry.
I'm sorry, my
dismissed.
declaration was declined, and it was held that my case was I'm a declaration that I'm a tenant. The defendant
Injunction only by they cannot evict you without due process.
Yes, my lord, I was also enjoying two more further protections. One was not to disrupt my electricity and water supply, which was continuing during the pendency of the suit. Third was, my lord, I was directed to deposit the monthly donation 1650 with the trial court. So that may be restored, my lord.
What do you say?
My lord, first of all, my lord,
The donation should be at the current market rate.
current market rate, my lord, my lord, in earlier suit, my lord, I don't have to make any further my lord, with due respect, my lord, in earlier
You are allowing the appeal.
My lord,
we will increase your donation, allow the appeal.
My lord,
What sort of donation?
No, there.
Increase the donation at the rate of such and such rate per month. This is ridiculous.
My lord, that suit filed by this appeal plaintiff for ascertain of.
Just like a rose, a thorn also remains a thorn, whatever name you give to it.
Yes. My lord.
So it's a thorn for them, this range.
My lord, kindly fix up another date.
For disposing of the appeal. We are disposing of the appeal, lock, stock, barrel, everything we are allowing the appeal.
And direct them to remove the room, to vacate the room.
No. If we allow their appeal, they cannot be direct. We cannot. Your eviction suit is pending. We will say that this donation is actually rent.
No, my lord.
From every perspective.
My lord.
We will rely on these documents and these are exhibits in the trial.
Yes, my lord. And my lord, there are two unregistered, unstamped lease agreements which have the exact same amount. 21 years lease. So it's a monthly tenancy. I agree. After expiry of the lease, what?
You filed an eviction suit. Have them evicted. You cannot evict them without due process.
But till then, my lord, kindly protect our interest. They are enjoying the thief.
What interest can we protect before we get an eviction decree? We are because what we are proposing was that we would declare that they are tenants, lessees. One, secondly, that you cannot evict them without due process of law.
Application kind.
Your due process of law is already pending because you have already filed an eviction suit.
Yes.
So that will be subject to that eviction suit. We can also clarify it and dispose of this appeal. If you don't want a disposal of the appeal at this stage, then they get an injunction till disposal of the appeal. So this is a fantastic choice which you have. Either stay injunction till disposal of this appeal and this appeal gets ready and we hear it if we feel that we can add it. Or we can dispose of the appeal itself. Take instruction, come back tomorrow.
Monday. To get ready. My lord, fact and grant me some time.
Very. To take instruction also. Take instruction that this is falling from the court, that we are bent upon granting them injunction till disposal of the appeal, subject to their paying donation to you regularly, so that you can pursue your religious practices and irreligious Buddhism. So your secular practices, irreligious, not anti-religious. But then the appeal will get ready and be heard and regular course.
No, I don't want.
We also don't want. So that's why we are giving you this option. The appellant has made out a prima facie case that the remuneration taken on a monthly basis at fixed rates, that too in exact terms of two unregistered lease deeds executed between the parties, tantamounts to rent paid by the plaintiff stroke appellant for enjoyment of the suit premises. However, the learned trial judge proceeded on the premise that those are donations, merely by proceeding on the nomenclature, without considering all the facets of the circumstantial evidence as well as the true nature of the said payments. For sub next para, we also find from the records, apart from the unregistered lease deeds and the donation within double inverted donation receipts, that there are demand letters for enhancement of the said remuneration on the part of the respondents, which further make it clear that the nature of the payment was not mere donation, which has to be voluntary by definition, but rent for the premises, lending the character of a tenancy stroke lease to the juror relationship between the parties. For sub next para, hence, a strong prima facie case has been made out for grant of injunction. Accordingly, we restrain the respondents and their men and agents from disturbing the possession and or enjoyment of the appellant in respect of the suit property, substituted appellants in respect of the suit property in any manner whatsoever, including restraining the respondents and their men and agents from disrupting the electricity supply, water supply, and or other essential amenities being enjoyed by the appellants at the suit premises till disposal of the application. Full stop. We further now, as a condition for such injunction order, the appellant substitute appellants shall
Continue to pay.
you pay directly to them, Mr. Thakkar.
I can do that. The order, there's an order of this court, my lord, in the suit, in the civil revision, which directed me to
That is merged in everything.
That is merged in the up.
Deposits won't help anybody. They won't be getting the money.
I will pay them, my lord.
As a condition of the injunction, the appellant shall go on paying
the last
an amount of rupees 1650 per month to the respondents, directly and or through their learned advocate appearing in this court by account pay check in the name of respondent number 1.
Yes.
Mohabadi. Name of respondent number 1 by the 15th day of each current month. The first, when did you last pay?
My lord, that was prior. So, one second. So there's an arrear, my lord, between from the date of the decree till today. So kindly provide along with arrears.
The first such current installment shall be paid for the month of December 2025 by the 15th day of December 2025, and thereafter by the 15th day of each succeeding current month. Push up next para, the arrears, if any, from the date of last payment till the month of November 2025 shall be paid by 2 equal monthly installments, payable by the first of which shall be payable by December 31, 2025, and the next by January 31, 2026. Push up next para. However, since learned counsel for the respondents, you are for all the respondents.
All one respondent.
For the respondent number 1,
Mohabadi Society of India
seeks some time to take instruction as to whether the respondent number 1 would be agreeable to disposal of the appeal itself, let the matter appear under the heading to be mentioned on November 25, 2025 for passing further orders. What the other respondents?
Well, they were the other tenants. They were the other tenants. No. They were tenants recognized by them who were making my occupation.
Relief did you claim against them?
No, nothing. There's no serious. They were set ex parte also.
In view of
only contesting defendant was 1.
No substantial relief having been claimed against the respondent number 2 to 9, as well as the said respondents having not contested in the trial court, service of notice of the application and the appeal on the said respondents is dispensed with. In view of the appearance of the respondent number 1, service of notice of the appeal on the respondent number 1 is also dispensed with, and the appeal be treated ready as regards service. We are not passing any further orders regarding this special messenger cost and all these things on the next day.
But all points are kept open.
No, whatever, there are no points. All points are closed.
No, my lord, kindly consider the judgment delivered by the trial court. There are 5 points. My lord, they obtained the lease before obtaining their citizenship.
We'll keep all points will be kept open if you don't agree to the appeal being disposed of. If you agree to the appeal being disposed of, then we'll pass that order on Monday.
My lord,
no, we are not forcing you.
My lord.
Then let the application
kindly give directions for expeditious hearing.
Yes, we'll dispose of the appeal application then.
Yes.
Why to dispose of the
My lord, kindly next.
What will happen next Monday? You are not agreeable to disposal of the appeal on the next day.
My lord, next Monday, in the meantime, I shall take instruction from my client. But this is not the rent. Two courts have successfully held their this trespass.
Two courts. Two courts. This is the first appeal.
My lord, in 84, they have filed another suit claiming that they are the licensee.
No.
Thereafter,
You have to look into those documents.
my lord, pleadings are required to be.
Then why do you agree to we'll dispose of the application here and direct the expeditious disposal of the appeal?
Yes,
We're
kindly.
not putting
Fix up on 29th.
4th.
24th.
He has forgotten already.
My lord,
You're asking 24th.
my lord, I got to get ready, my lord, for some time.
Not to get ready to take instruction whether you are agreeable to the disposal of the appeal itself along with the application.
My lord, the occupation charge is very small. This is a religious charitable trust. They are
These are, you forget, these are not occupation charges. These are donations.
The donation.
donation that they are.
Donations cannot be increased.
My lord,
Donation is absolutely fine.
my
So
lord,
whatever we were bent upon passing an order, identity order that conditional upon their paying whatever they wish to you, because your case is it's a donation.
no, this is not. We have not received any. Sometimes they deposited some donation. Thereafter, we refused.
What
to,
are these receipts for? Monthly, same amount.
This is also disputed, my lord. At this stage, I cannot. Satisfy your lord.
Admitted
My lord, can you fix up a date to get ready and to bring the brief? I have no brief also today. All on a sudden, the matter has
not served. Served किया तो?
Next.
Served किया? They don't
Grateful, my lord.
I appeal for the appellate's matter. And this is happening for the first time. I have to serve the copies of
Section 5.
Section 5 and also injunction application. And also memo of
The
appeal.
appellant shall serve copies of both the of two applications.
Two applications and memo of appeal. Two applications, yes, my lord.
Memo also will serve first appeal.
Yes, sir. 1 and 2, my lord. Can 1 and can 1, can 2.
Shall serve copies of both the applications bearing can 1 of 2025 and can 2 of 2025 on the respondents, indicating that the applications shall be listed on December 8, 2025, when an affidavit of service to that effect shall be filed by the appellants.
Number 15.
I am for the appellate, my lord. This is the matter regarding, my lord.
I appeal for respondent numbers 1, 2, and 3.
You've got a copy. Caveat is only respondent number 1. What
1,
about the
2, and
others?
3. 1, 2, and 3.
I think he is all the respondent.
Why not 4? 4
is
telling with you.
There's a dispute regarding the succession certificate which has been raised by the appellant here. And
all the, my lord,
I am.
All of you are children of Om Prakash Jha.
Yes, there's a claim of another wife. Their sons and daughters are there.
That is them. But you want to 4
1,
must
2,
have
3.
appeared together.
1, 2, and 3.
Please look at the cause title.
My lord, I have seen. I don't know who 4 is.
Oh,
Om Prakash Jha residing.
Ritu Jha is the name of a son. Could be son or daughter.
That is typographical error, perhaps.
Daughter, I think.
Ritu is a bit different name for a son. Maybe.
I think son.
Exceptional, yes.
Insofar as
not surprised by anything, yes.
Insofar as my name is concerned, when I
You are 1, 2, 3, so you are safe.
My name in Delhi, if I don't write
Your own
Mr.,
name.
my name, if I don't write Mr., they write Mrs. Because in Punjab or Delhi,
Punjab is
Kamlesh is the name of a lady.
that umpteen people in the same family with the same name. That we saw that movie. The phone came and everyone was Jasvinder or something like that. Not this Jasvinder, the other.
That other one.
So, but it's good. I mean, they're so jovial. Yes. What about your matter? Is it
Matter
also
is,
jovial
my
or
lord,
sad?
challenging the succession, my lord.
You are
Fortunately-
challenging a succession certificate.
Yes, my lord. Fortunately, unfortunately, we are the, my lord, first wife child, my lord. So they are challenging
No,
this.
that's
my lord.
fortunate.
Yes, my lord. And the Hindu Succession Act, my lord.
So you are deprived by the will.
Yes, my lord.
By the
Succession certificate.
no, citation was given.
Yes.
Why were you claimed not up?
Claim only, my lord, pensionary benefit, my lord. We are the, my lord, first.
So what was the premise of the trial court judgment?
Trial court judgment,
Why?
they are denying this and other thing that.
They are denying that you are the son of that person.
Yes, my lord. That first point. Number 2, my lord, there some res judicata has been arised, my lord.
How?
Because, my lord, 2013, some application has been, my lord, filed.
What do you mean with some? Some res judicata, some application. What
For
application?
revocation of succession certificate.
So revocation of, my lord,
Dismissed.
revocation of, my lord,
No, this is against the succession certificate, grant of succession. What
They
is
took
this?
out an application for revocation of the
The
succession.
revocation was rejected. Against that, this has been filed. So why res judicata?
Earlier, they had taken out an application which was dismissed
For revocation.
for revocation.
Dismiss for default. So order and rule line principle comes in.
That is not laid down in the application. Your Lordship, kindly come to my
We'll lay that down.
Yes, sir.
We'll lay that down. It's not been laid down.
Lordship, kindly come to my lord. Their rejection, my lord, decision, my lord. Lordship, kindly come to my lord. Page 13, my lord, of the order, my lord.
Internal page.
The court thought that the petitioners have failed to cement his structure of contention. So you are lacking in cement, so you go. No difficulty. Yes.
So, my lord, there page 14, Mala. During the argument, it was agitated before the court that the one settlement was initiated before Joint Commissioner, Commercial Tax Office, Raiganj, Uttar Dinajpur. The appearance of the petitioners in miscellaneous success case, the settlement case was further referred to the Commissioner Taxes, West Bengal. It is alleged that during the settlement procedure, the opposite parties, especially the opposite party number 1, that is their opposite party, obtained a succession certificate by practicing fraud upon the court. Now some documents have come before the court as declined by the landed court for the opposite party. In the certified copy of the order sheet dated Ato, it is clear that the order which has passed court miscellaneous court, that is case number Ato, is not at all interfered. In another order dated 14/8 WPST 116/2000 passed by the Honorable High Court, Calcutta, is reflected that the writ petition paid by these petitioners was dismissed. As all these documents are certified copies of the order, Tribunal, Honorable Court of the find no impediment to exhibit the same and adjudicating the matter. The exhibit G, H, therefore, from the two exhibit documents, it is clear that the succession certificate which was obtained by the OP through OP missions is still subsisting and beyond any blemish. Another point, Malad, that is also very much prudent, that is there. You will kindly come to Malad, that is Patna High Court judge order, Malad.
That is application which they took out in Patna.
Yes.
My basic claim is they are trying to imposter with the documents of the name of my husband. They have approached the court and they are saying that I am.
But all the documents as far as this Mala, this document
Despite
is
the
concerned,
fact from 2017, after obtaining the succession certificate, I have not been able to withdraw money which is lying in the bank.
You produce some proof of your marriage.
Yes.
What proof did you produce before the court?
I proved Malad.
What a proof of your marriage?
One document from Patna
High Court. Patna High Court order, Malad. That is 498 against my.
That does not.
Yes.
That is not.
No,
proof.
that is admitted, Malad. That is admitted by the Patna High Court, Malad. In the year, Malad, 2013.
Because Patna High Court did not marry you.
No, that is one question, Malad. On that point time, I have no documents. As far as this marriage is concerned,
498 order does not operate as res judicata because this is res judicata section 11 language. You know, both have to be competent.
Now they are admitting. Opposite party.
I am not.
Although opposite party also admit that we have. You should kindly come to Malad.
Admitting what? That you are the wife.
Yes, Malad. First wife.
Where have they?
Yes, you should kindly come to Malad. Page 22, Malad. That is the order. And that is page 24, Malad.
Stay application.
22.
Nirmala Jha also Malad party, Malad.
This is
page 22, Malad. P3.
Yes.
Stay petition.
Yes.
Nirmala Jha, Malad. Om Prakash Jha, that is husband.
Which paragraph? Page 24?
Page 24, Malad. This is Malad. Middle portion, the complaint came back to the Sashuri.
You are Nirmala Jha. Who is Nirmala Jha?
Nirmala Jha, Malad, that is second wife, Malad.
Your client. Huh? Your client.
Nirmala Jha, our client.
You are not Nirmala Jha.
Yes. I am Dolly Jha.
Nirmala Jha, my mother name, Malad.
So she was the first wife, not the second wife.
Yes, Malad. First wife, Malad.
So this was, she was Dolly Jha was a party there.
Yes, madam.
Let us see. Where have they admitted? Petitioner number 2 is praying for caution.
Page 23, my lord. Second page.
Yes. Second wife. Right.
Para 4, my lord. The petitioner 2 is second wife of one Om Prakash Jha. Petitioner 2, since this is the opposite party number 2 who filed the present complaint case number ato, the court learned additional Chief Justice Magistrate Jhanjharpur alleged that she was married, accused number ato, according to Hindu marriage. After marriage, she started living in ato. This is malad completely malad.
Started living in a sasural.
Yes.
Yes.
After her marriage, complaint was living with her husband and had
Not interested
given
in the
birth
family
to
life. Let us see what has been found.
Ajay Kumar Jha and Ajit.
Show us where they have admitted that the second wife, this
Yes, ma'am.
statement.
Second wife, malad, that is
Petitioner number 2, that is Om Prakash Jha, the husband died
yes,
during pregnancy of this.
yes,
So she was pressing this quashing against you.
yes.
Show us the paragraph where they admit your marriage.
For
That the petitioner number 2 has admitted that.
This paragraph is about
Although she says she's the second wife.
Yes, ma'am.
But where she has admitted that you are the first wife.
That is malad para 6, malad, page 3 of the malad order, malad.
Yes.
Actually, page 22.
Para
It is
6.
further alleged that at Raigon, it was suggested to the accused number 1 to send half of his salary to the complainant, and name of the complainant should be entered in the records of the government for getting all facilities. But the
Yes,
accused number 1,
mother-in-law of the complainant. So mother-in-law of the complainant means
Mother of the deceased.
mother of.
Yes.
So that's an admission.
Yes.
Yes.
That is not denied as per this case concern, malad.
So
Because
why-
I have malad Aadhaar card.
So why was succession certificate in the original succession certificate? You were not given a notice.
Yes, malad. That is that.
Not given a
Not
notice.
they are fraudulently.
Mr.
malad,
Jha,
I don't
they are
think so.
procure, malad.
I have asked for that instruction.
But
Yes.
how
Citation was issued
can you
or
get
not?
a succession certificate all by
Yes,
yourself?
malad. That is main question.
Although it has been held by the Supreme Court, it has been quoted here that succession certificate can be given to the same. Understand? But the first wife has to be given a notice. She has to be cited.
That is relying also on trial.
So far as that part is concerned, I have asked for instructions, but I have not been able to obtain because she's in hospital. My client, she's in hospital.
Saja, we'll take it up next week. We can dispose of the appeal. suppose.
I'll beseech your lordship to take the matter Tuesday week, your lordship. because of the elections
Interim
and
stay, malad.
forthcoming elections. my lord.
25th November.
My lord, the week thereafter.
Very well. 2nd December.
Interim stay.
What sort of stay?
Malad, because malad, they are some fund has been malad generated in the government office, malad. They are praying, malad, for this.
Yes, Mr. Jha, we have to stay it.
Well, I undertake that.
A prima facie case has been made out inasmuch as the appellant, the first wife of late Om Prakash Jha challenges a succession certificate granted to the respondent number 1, who is allegedly the second wife of the husband of the appellant. Husband
not malad.
No, not
claiming, my lord.
Husband.
Ajit Kumar Jha, who is Ajit Kumar Jha?
His son, malad.
Oh, your mother has died.
I am elder son, malad.
আচ্ছা এটা কেটে দাও যেটা বললাম A prima facie case has been made out. Full stop. Ajit Kumar Jha, the appellant, claims to be the son of late Om Prakash Jha through his first wife, what was the name that the lady?
Nirmala Jha, malad.
Namely Nirmala Jha. Full stop. Next para. The grievance of the appellant is that succession certificate was initially granted to Dolly Jha, the respondent number 1, purportedly the second wife of late Om Prakash Jha, without citation on the mother of Ajit Kumar Jha, the appellant, being the first wife. Full stop. Next para. When a revocation case was filed, comma, the same was dismissed by the learned trial judge, against which the present appeal has been preferred. Full stop. Next para. Several arguable questions are involved, comma, particularly as to whether the learned trial judge was justified in granting succession certificate exclusively to the second wife of the deceased without considering that the succession certificate was granted without citation upon the first wife, who also had a legitimate claim to the estate of the deceased. Full stop. Moreover, comma, it is also to be considered as to whether a purported previous rejection of a similar revocation case at the behest of the said Nirmala Jha would stand in the way of the present revocation case, which has now been dismissed by the learned trial judge. Full stop. Next para. Since the ambit of the matter is short, comma, learned counsel for the respondents 1 to 3 seeks an adjournment, seeks some time to take instructions whether the appeal itself can be disposed of along with the application to cut short the agony of the parties of prolonged litigation. Full stop. Next para. Accordingly, let the matter be listed next on December 2, 2025. Full stop. In the meantime, the appellant shall serve a copy of the application on the respondent number 4, indicating the returnable date. Full stop. Service on the pro forma respondent 5 and 6 are dispensed with for the present. Full stop. Next para. There shall be stay of operation of the impugned. Stay does not mean anything. Revocation has been refused.
Exactly.
So the succession certificate has to be. What prayer have you made?
Yeah, my lord.
Yes, you are staying all further proceedings of.
No proceedings are there.
That is the order.
No proceedings are there.
Yes.
There shall be stay of operation of the order passed in miscellaneous succession case number 2 of 2019 till December 24, 2025, or until further order, whichever is earlier.
Deep level.
Right.
I appear for the respondent number 1.
That I am appearing for the petitioner.
Yes, sir.
There is a delay of 3 days, my
But
lord.
before my learned friend begins, but I was on caveat, my lord, the memo has not been served upon me.
Memo need not be under the law.
That so far as this matter is concerned, my lord, there were 2 suits. One by the present
Mr. Mitra, 1 second. The memo valuation statement in the appeal is stated to be incorrect in the report. What is the actual value?
value, my lord, so far as this present suit is concerned, valued, my lord, there was a deficit stamp that I have also.
No, not that. 300 rupee was the value. Declaration, recovery portion, and injunction 300.
300.
From the decree it appears 300. You have just stated 200. Just make it 300.
My lord, that I shall make correct.
We'll give you liberty right now. 3 days delay. Any section 5 is there?
Yes, my lord.
What is the reason for 3 days delay?
3 days delay, my lord, there were 2 suits. So far as the present suit by the defendant and my lord, owing to some miscalculation on my part.
Upon hearing learned counsel for the parties and perusal of the explanation furnished, we are satisfied that sufficient grounds have been made out for condonation of the delay in filing the appeal. Accordingly, can 1 of 2025 is allowed, thereby condoning the delay in preferring FAT 295 of 2025, which of the appeal is deemed to stand registered and admitted. The appeal is against what?
Appeal is, my lord, against an order allowing their application for eviction on the ground that I am a trespasser.
You have not filed any stay application?
My lord, I have filed another appeal. This appeal was heard along with my appeal, my suit for praying for declaration and in both the suit, my lord, I have that appeal is required to be placed where, my lord, I have prayed, my lord, these 2 appeals should be heard analogously.
So why didn't you mention that along with this?
My lord, that mistake I have done, my lord. I shall make, my lord, some prayer, my lord.
No, this we are directing. So that has to be because there will be composite paper books and all.
Yes.
So give the number. What is the number of that other can?
294.
Acha, let
294 along with 2 applications, my lord, can 1 and
let this appeal be placed, be listed along with can 1 in that.
294 and along with can 1 and can 2 of that.
With can 1 of 2025 and can 2 of 2025 filed in connection with FAT number 294.
FAT
Number 294 of 2025 on November 25, 2025.
But instead of 20, can it be a day before my lord?
24th, November 24th.
Great.
Mr. Mitra, please ask your junior, or you also can just give on a slip of paper. Please give the those cans. It will be easier for her to requisition. Can 1 2 FAT number. তাও আপনি না দিলেও আপনি করে দিন 294 এর যে দুটো ক্যান আনিন এটার সময় দিয়ে দেবেন
Here and now, my lord, I am giving.
Yes, next. Thank you. 17. Yes, Mr. Chatterjee.
I took the instruction, what I found, because this is well, your lordship directed me to take instruction with regard to occupation charge. Now, the property.
This is against an eviction degree.
Eviction degree under the TP Act.
Yes.
According to the plenty, it is under.
You say the valuation.
So decide yes. Although the
Strategies
property
also.
is at
strategies now.
Yes, although the property is at Charu market, but it is well within a short passage, my lord. You have to go, my lord, for at least 7 to 10 minutes, and thereafter you will find the. My case is that, my lord, in this property in 2016, already 20 lakhs we deposited to the earlier landlord. They did nothing. Subsequently, again, my lord, 5 lakhs, my lord, they demanded. We paid, my lord, 3 lakhs as security deposit. Now question is, and that is admitted in the evidence also, they didn't controvert it. My humble submission to your lordship is that in that case, whether again I am to pay occupation apart from the rent. Already, my lord, my rent is 10,000.
20 lakh, you say?
20 lakhs. Your lordship, if your lordship kindly come to the.
For what purpose? As salami?
No. For renovating, my lord, they took that money from me.
But
I invested it.
But Mr.
But they
Chatterjee,
didn't do
there was
anything.
no agreement that would be adjusted with rent. Then we cannot.
There was
adjust that.
actually, my lord, difficulty.
But there has to be an agreement that
There
whatever
is
you
no
spend,
agreement written anything, my lord. Neither
then
rent
we cannot
receipt nor
adjust that.
anything.
We cannot adjust that with the land because
No, I am not asking for adjustment.
then you have to pay occupation charges at the current rate.
That your lordship kindly minimize. My humble submission is
Shadow
that
market minimize.
because already, my lord, as soon as my lord, this money has been paid, they did
Brought
nothing.
something probably.
This is the schedule.
Yes.
I'm not, Milord, kindly excuses me, Milord, just have one copy.
The schedule should be there in the decree.
Yes, it should be there, Milord, in the degree itself. But just for the sake of, Milord, your lordship can, Milord, look into it. He's got a 3-bedroom flat, Milord, and using it commercial. It's not a
For
residential.
commercial purpose, it was given to me.
Absolutely. That's what I'm
Yes,
saying. So the
yes.
monetary aspect will go higher.
Yes.
He's exploiting it commercially.
No, the
Bedroom flat.
Mr. Chatterjee, Mr. Bhudev Chatterjee, on the north premises number 4C, all on Charuchandra Avenue.
Yes.
Yes.
Deshpan, on the other side, Deshpan Shaspan Road. Time location.
Yes.
What are you saying? What should be the occupation charges you say?
We have, Milord,
3 bedrooms and all. Huge occupation. What was the last rent? Last rate at which?
10,000?
No, that is the dispute.
No, I have the, yes. Even after filing of the suit, they accepted it.
Even after filing of suit, you accepted. That is Mr. Chatterjee's case on the last one.
Yes.
Lord, here your lordship will find that they've admitted 20,000 rent. There is an admission on
No.
record.
What should be the proper occupation charges? Then we'll direct you to file opposition to disclose all documents
In the
contemporaneous.
meantime, Milord, kindly directs, Milord, at least 50,000.
If you direct in the
50,000,
meantime, then it has to be on the at the last paid rate.
Milord,
No, you file your affidavit quickly. We'll put the application 2 weeks hence.
Yes.
File it within
I'll take 3 days. 3 days.
3 days.
Yes.
You also 3 days, and then we'll put it next week.
Yes.
Milord, we just for the sake of, Milord, what I had, Milord, the valuation of the property as per the government, Milord, is about 73
We
lakhs.
put all of those in your opposition. Unless those are supported by oath, we cannot look into that. And you take this, you give it back to your learned junior. He'll bind it and hang it on his wall. You already have a certificate copy. The present appeal has been preferred against an eviction decree. Push up, since questions of fact and law are involved, we find prima facie case for grant of stay. Push up, execution has been levied.
Execution has been levied.
Yes.
Accordingly, there shall be stay of all further proceedings in. There shall be. You have not given the number.
No, my lord. It was filed just on November, my lord. It is 79.
Stay of operation of the impugned decree, as well as all further proceedings in connected execution case, comma, if any levied, comma, till December 24, 2025, or until further order, whichever is earlier. Full stop. The application shall be listed next on December 8, 2025 for hearing. Full stop. Affidavit in opposition thereto shall be filed by the respondent within November 24, 2025. For sub reply, if any, shall be filed by the returnable date.
Yes.
On 8th of December, stay till 24th December or until further order, whichever is that. Affidavits.
কি দরকার একসঙ্গে করে তো এরিয়াস পাবি এখন না লাস্ট পেমেন্ট শুধু দেবে ব্যাপার
My lord, I beg to appear for the defendant, respondent number 1. My lord, Mr. Banerjee's
one thing.
advocate on record did not serve me a copy. I lodged a Okalatnam on 6th of November, asking
Lord,
them
my
by a letter.
clerk is
My
saying
junior,
that-
my lord, 6 times my clerk went there.
Mr. Banerjee, this is not.
My clerk, Lord, went there. Lord, then he
6:30
he told
6:30
yes.
PM yesterday.
When he called the telephone, he told me tomorrow I will take it. So I have brought it.
Give it today, then we will take
Yes, they have
it on
plenty.
next Monday.
Only one indulgence, Lord, I crave leave to a Lord.
Yes, Mr. Banerjee.
Lord, indulgence is, Lord, I'm.
Tolobana and all, you have to file. Put in those.
Lord, that it need not be because the entire appeal can be heard.
You are for
Lord,
one,
on
respond
seven-
of
yes,
one.
and 2 is also.
Only 2.
No, I am for 1.
1, 2, 3, and 4 have to be served.
3 and 4 can be dispensed to it because no relief is claimed. And Lord, 2, Lord, has filed an application under Order 7, Rule 11 of the Code of Civil Procedure for rejection of the plaint.
That was allowed.
Plaint is
against my
for
Mr.
1 minute, please. Sir.
What are you doing, Mr. Sinha? Yes, Mr. Banerjee.
Lord, that was allowed. Lord, it is a suit for declaration of title and injunction. Lord, whole case is that
In the will, my lord, the Priyoranjan Jana was the testator. Priyoranjan Jana, son of late Prasanto Kumar Jana, is the will. Lord, our case is that Priyoranjan Jana, son of late Prasanna Kumar Jana, not Prasanto Kumar Jana, he is a different person. Therefore, my title has not been affected. And, my lord, a declaration was claimed, Lord, for the purpose of a status declaration. Now, my lord, a status declaration, my lord, cannot be given by a probate court. Or declaration of title cannot be given by a probate
Why
court.
was it rejected? Plaint was rejected?
Lord, it was rejected ex parte. It was rejected on that ground that the probate has been granted and the application ex parte.
Subject to correction.
Application ex parte. Ex parte.
Solemn form it has been.
No, solemn form. What solemn form?
Witness was
1 minute.
examined in box.
May I complete my argument? Lord,
And
solemn form.
the title is not disputed. Why he is prayed for revocation?
Solemn form ex parte. They cannot deny.
Our simple question is, why was it?
Now, my lord, we submitted application 263. Your lordship's query was why it was rejected. That is the reason I am telling your lordship. Lord, 263, my lord, was rejected. Again, that appeal is pending. Appeal has been preferred. Now, my lord, that fact we have stated in the plaint. Otherwise, it will be a suppression of fact. Now, my lord, the trial judge, based on the basis of that, when this matter is pending there, therefore, this plaint is liable to be rejected. Therefore, this is purely a question of law. Your lordship, read the plaint and the order of on the impugned order. I shall serve the copy.
The court says that even though the plaint is drafted in a fashion designed to hide the real facts from rendezvousing pernicious consequences flown from the provision.
Interest already created.
Set aside this order on the language.
Section 34 says
On the language.
not deeded, my lord.
The language
My lord,
is not
cancellation of the second deed has not challenged.
That is to be
From whom
decided.
the
No,
second
need not be
711 has
challenged.
been filed.
Need not be challenged, my lord.
I have filed
Need not be challenged. If
on 2 counts.
blood
For the limitation, and he approached the court with unclean hands. And we have submitted documents that what he tried to lordship, just to get a blanket order from the court, he made a false cause of action.
No, it was rejected on the ground of limitation.
no, it was rejected on the ground.
Lordship, limitation point is also
No.
See the-
His
see the
limitation
observation
point
power
was not considered.
Page 5, it is considered. Article 58 is considered.
Yes.
Lordship.
Lordship, here the appeal itself. Next
And
week.
against do that,
appeal, lordship,
we'll dispose of the appeal itself.
Yes.
Yes, that is the reason I am telling you, lordship. That is the
Not
reason. my
now.
lord.
Today they
Yes.
may not be ready.
Yeah, I have been
and
given.
lordship, I would like to file an affidavit, lordship, on the
No,
point
no,
of
not
maintenance.
done. Appeal টা শুনে নিন না, কি
আচ্ছা,
আছে?
ঠিক আছে, আমি-
Lord, on the basis of the documents before the trial court.
The plaint is annexed, that is sufficient for.
That is sufficient.
And we may look into your 711 application also.
Yes.
That is also annexed.
Yes, 711 I have annexed.
Are you prepared in the appeal?
No, we have given to you.
Oh, can you are getting right now, sir?
Today is for can.
The appellant shall.
Can we are giving to you for injunction.
For injunction, my lord, lordship knows Justice Nagaratna's present judgment. Order 7, Rule 11 allowed in appeal. There is no scope for injunction.
Lordship, may I hand over the judgment, lordship? Clearly.
Oh, my lord, what I am want to say. If your lordship, my lord,
We also want to say something. We are saying that.
lordship.
Since the scope of the appeal, which has been preferred against the rejection of a plaint, is limited, and the primary documents required, that is the plaint and the application under Order 7 Rule 11 of the Code of Civil Procedure, have been annexed to the injunction application, we are of the opinion that the ends of justice would be served if the appeal along with the application are taken up and decided together. Since respondent numbers 1 and 2 are represented through their respective counsel, service of notice on the said respondents is dispensed with, insofar as the other respondents are concerned, since learned senior advocate for the appellants submits that no relief has been claimed, and we also find that the plaint was rejected on the prayer of the respondent number 2, we dispense with service on respondent numbers 3 and 4 with regard to the appeal as well as the application. The formal preparation of paper books is also dispensed with, and we shall decide the appeal on the papers before us. Next para, the appellant shall serve copies of the application and the memorandum of appeal on the learned advocates appearing respectively for the respondent numbers 1 and 2 during the course of the day.
Lord, I have already served, Lord, application, only the memorandum of appeal. Your
Stop,
Lordship
next para.
kindly say that.
The appeal and the application shall be taken up for hearing together on November 24, 2025, when the matter shall be listed under the heading application. Application is again as
Cancer service.
Memoda পাই।
Lord, memo we shall only we shall.
If it's not annexed, the revocation order, I may be permitted to show your lordship.
whatever you rely on, Mr. Sinha, what is relevant, whatever is relevant, you show on the next occasion.
Sufficient copies.
Advance copies.
Yes.
Lord, practically revocation order, my Lord, that is neither here nor there, because
We'll
one minute, please, my Lord, that is
We'll look into
that is, my Lord, no finding can be recorded by this court, because the appeal
We'll
is
decide that.
pending.
Let us decide that.
Appeal is pending.
Whatever document you want to rely on,
They let them rely, but my Lord, that document.
Please take the copies if those are given to you. Whatever Mr. Banerjee says.
Then, my Lord, we have to sort paper book, my Lord. Then 3 days.
This is the paper book, the application.
Oh, yes, my Lord. Yes, my Lord.
That's why we directed to give copies of 24th.
24th.
Next
24th, my Lord. Lordship.
Next. 19.
19, my Lord, I beg to appear for the respondent.
Yes, you showed your fairness, but on what we forgot.
My Lord, this is a
These are during the pendency of an suit for divorce. Subsequent suit was filed.
Yes.
And
You
there
need
was
to break down. That was your fairness. So should we take judicial notice of that? I mean,
yes, but we have these records on records. We have filed the document certified copy.
you have remarried.
No.
You have not.
Nobody is.
No, then but something has to be on paper.
Yes, that we have annexed.
in the supplementary affidavit.
Supplementary affidavit we have annexed.
Let us see.
Your Lordship will
I
find
also filed my exception to that.
page 9 of the supplementary affidavit.
Your suit for divorce was dismissed.
No,
my Lord.
ex parte.
Ex parte allowed.
Ex parte divorce decree was granted to you.
During the pendency of the earlier divorce suit. The subsequent divorce suit was filed without disclosing the same.
Just remind us again.
Initially,
You are the
wife.
Wife, yes.
The initially suit for divorce was filed in the year 2020.
You filed against him.
No,
I filed.
he filed
You filed.
against me. That was pending. Subsequently, another divorce.
Another suit.
Another suit was filed on the
degree obtained.
Degree obtained. Expiry.
You have a section 5 here also.
Yes, challenging that while not the expiry degree.
Section 5 is still pending.
Still pending.
Section 5, your ground is that you are under the impression that the previous.
Yes, previous suit, which was because I was staying at the residence of the opposite party herein, along with my children. So there is no occasion on my part. And the question is cropped up for consideration before your lordship. Then why did you accept the subsequent summons? Because at the relevant point of time, I was there in the native village. That is why my father used to. During this time, my lord, it cropped up that the suit was pending at the time of filing of the subsequent suit. That your lordship was directed to file a supplementary affidavit disclosing all these facts. And it appears, my lord, the plaintiff I have annexed page 9p3 to the supplementary affidavit.
Page
9 to the supplementary affidavit. My lord, got it?
This is the second suit.
No, this is first.
Sorry, first suit. Yes.
This is the first.
What happened to this? This is still pending.
No, subsequently, my lord. Page 19.
Non-prosecution.
Page 19. Page 19 on 13/12/2024.
And when was this degree passed? This
12/12/2020.
12/12.
1 day prior to. But I admitted in my exception. I didn't, my lord, the explanation given by my client, my lord, I am aware that in law has no reason to that. But his case is that I gave it wakalatnama, signed on the papers on the pretext that 9.
Sir, if it will be broken down, then why agree to some alimony? And
My lord, I am staying with the children at Delhi, in the residence of the opposite party. There is no occasion on my part to say.
So the permanent alimony can include arrangement for that. That residence can be given to you.
Yes.
Consider that at least.
That
or in lieu of some, the money will be less than.
Because my lord,
Permanent
the two children. So far, me is concerned, it is.
Husband is residing where?
There.
My lord, no. My lord, my
Same
permanent
place.
residence is over here. But due to my workplace, I used to visit over there.
Delhi.
Oh, Delhi.
Now you are not in Delhi.
No, my lord, right now he is over
You
here.
can consider, I can have a talk with your client.
I also, my lord,
if that residence can be given to them along with the child, and
because it is
you are doing something, you do something. Must be doing something. In Delhi, How can you survive?
My case is that adultery, my lord. In both the time, mistake is on my part. That
Got a decree on adultery.
Adultery and desertion. And I even, my lord, yesterday, the advocate on record of the appellant, I made an offer, my lord, to speak with their client that if they are agreeable, I told 15. I can afford it till 15, my lord.
15 lakh.
15 lakh.
One time.
One time. But I
said I agree to that.
I see, so, my lord. It's not in my hand, my lord.
You'll get regarding that flat.
Daily
And, my lord, I don't know that subsequently whether he has that in his name or not. I need to take instruction. And my lord, in adultery, perhaps, my lord, I also speak with him flat, perhaps, my lord, he will be agreeable to that. Money, my lord, I spoke with him. He is
Can send you to mediation.
Yes, my lord.
Fit case for mediation. We'll allow the section 5 and send it to mediation.
Your lordship.
Supplementary affidavit and exception there to file today be kept on record. Full stop. Next para.
My lord, yesterday we filed.
Acha,
already filed.
Filed today na kore, filed in court be kept on record. Full stop. Next para. Can 1 is the section 5?
Yes. 2. देखिए बाबा.
Can 1.
Can 1. Can 2 stay?
What is the delay of about?
159 days.
159 days.
Can 1 of 2025 has been filed for condonation of the delay of about 159 days. 159.
159
in preferring the appeal. Push up next para. The explanation given is that the respondent husband previously filed a divorce suit against the appellant wife. Push up during pendency of the same and while the wife was residing in her matrimonial home, comma, the second suit was instituted, comma, allegedly behind the back of the appellant, and an ex parte decree was obtained against which the present appeal has been preferred. Push up. For the purpose of the application under section 5, deciding the application under section 5 of the Limitation Act, comma, we find sufficient prima facie case having been made out for there being justification in the appellant wife not being aware or supposed to be aware of the subsequent suit, comma, particularly since she might have been secure in her belief that the previous suit was still pending and since she was already residing in her matrimonial home. Full stop. Next para. Upon hearing learned counsel, comma, we are thus of the opinion that sufficient explanation for the delay has been made out. Stop. Accordingly, can 1 of 2025 is allowed, thereby condoning the delay in preferring FAT 387 of 2025. Full stop. Next para. Will injunctive from remarrying. Can 2 of 2025 is an application for stay of operation of the decree. However, comma, since the impugned decree is a matrimonial decree in the nature of a judgment in rem, comma, we are loath to grant stay, comma, since the same might have larger ramifications. However, comma, the respondent husband shall remain restrained by an order of injunction from contracting any remarriage during pendency of the appeal. Next para. In view of the nature of the allegations between the parties and the circumstances of the case, comma, it might very well be that the marriage has broken down irretrievably, which can only be resolved by the parties parting ways, P-R-T-I-N-G, parting ways, subject, comma, of course, to adequate order of permanent alimony stroke right of residence being passed in favor of the appellant wife. Full stop. Next para. As such, comma, since the parties transpire to be reasonable, comma, as are their advocates, comma, we refer the matter to the High Court, Calcutta High Court Mediation Committee for the purpose of resolution by mediation. Full stop. The file be immediately sent to the said committee. Full stop. Liberty to the parties to mention the matter for inclusion in the list in the event the mediation fails.
We can approach for also virtual presence because wife is at Delhi. That is why sometimes it is.
Let the file be sent there. We can work that out with the mediators.
As your lordship.
Mediation is being encouraged, so probably will be permitted also.
There is because otherwise she has to come down from
1 or 2 occasions she may have.
Yes, 1 or 2
have to come, but otherwise you can work out something.
Yes, yes. That would be.
Lordship, I for the appellate. Lordship, This appeal arises from an order rejecting the application for grant of a probate of a will. Lordship, kindly come to page 12 of my CAN application, CAN 1, last paragraph.
CAN 1 is order for 27.
Lordship.
Acha, probate has been rejected. Yes.
Lordship.
Yes. Why rejected?
Rejected that, I need to read out. On the basis of the evidences and documents on record, it appears that there is no mention of the assets in the will.
Which page? Which page?
Lordship, page 12 of CAN 1, last paragraph. It is the order, impugned order. Last paragraph.
Yes.
On the basis of the evidence and documents on record, it appears that there is no mention of the assets in the will. The testator has only stated in the will that the will was executed for his all immovable and movable properties, but there is no details of specification of any such property in the will.
No, but then you have to file affidavit of assets.
Lordship, affidavit of assets have been filed, but
the court says that the petitioners have not filed any documents to substantiate affidavit.
Lordship, affidavit of assets have been filed, but no documents have been filed. Lordship,
documents are to be filed. Otherwise, any third party's property you can.
Lordship, I have annexed the photocopy of the documents. That is the partition deed.
This was uncontested.
Lordship.
Uncontested.
Lordship.
Any other heir is there?
No, Lordship.
You are the only heir.
Only heir, nephew, and another is neighbor who looked after the testator.
Is not an heir. You are the beneficiary.
Lordship. Executor.
And you are the executor.
Lordship. Both.
So we can order for 27. What have we produced? Those documents.
Lordship.
Where we are allowing the appeal itself, remanding this order for 2020. What documents have we produced? That is,
Lordship, I have annexed. I have mentioned
his title, the testator's title to those properties.
Lordship. Lordship, it is specific.
These are the title deeds. What are these?
Lordship, kindly come to page 5. Paragraph 5A. Photocopy of the deed of partition registered before additional district sub-register Sadar Hooghly being deed number
showing that this portion was allocated to him.
Lordship. Another is a passbook of a bank statement, bank passbook, and another is front.
We are allowing,
another
allowing the appeal and the application together.
Lordship.
The application is taken up along with the appeal by dispensation of calling for the trial court records. First of the proceeding is not adversarial in nature, inasmuch as the petitioner, number one is the nephew.
Lordship. No, or 2 is the nephew.
Inasmuch as the petitioner number 2 is the nephew of the deceased and the sole heir, whereas appellant number 1 is a neighbor of the deceased, first of the deceased testator, by virtue of the will in question, bequeathed his entire property, movable and immovable, in favor of the present appellants. First up, the appellants were also nominated as executors. Both are executors.
Okay.
First up, next para, the learned district delegate rejected the probate application since the will did not mention specifically what are the assets of the testator, and no details or specification of and no documents to substantiate the properties mentioned in the affidavits of assets were produced by the appellants before the district delegate. First up, by way of the present application under Order 41 Rule 27 of the Code of Civil Procedure, bearing CAN 1 of 2025, photocopies of documents have been annexed which indicate prima facie title of the deceased testator to the immovable property as well as the movable property comprised of bank accounts, etc. of the testator. First up, next para, as such, since a probate court is in the nature of a court of conscience and the wishes of the deceased are to be honored to the utmost, this court is of the opinion that by exercise of its powers under Order 41 Rule 27 within bracket 1 within bracket small b bracket close of the Code of Civil Procedure, we are of the opinion that the documents sought to be produced are germane for a comprehensive and complete adjudication of the probate application. First up, accordingly, CAN 1 of 2025 is allowed, thereby permitting the appellants to produce the documents mentioned therein in original as exhibits in the probate case pending before the district delegate. Footstep accordingly, FAT 390 of 2025 is allowed in part, comma, thereby setting aside the impugned judgment and deemed decree dated April 17, 2025, passed by the learned district delegate at Hooghly in Act 39 case number 38 of 2022 and remanding the matter to the district delegate for a fresh adjudication of the probate application on merits upon allowing the appellants to produce the additional documents which have been permitted by us in evidence. For next para, it is expected that the said exercise shall be concluded by the learned district delegate as expeditiously as the business of the said district delegate permits. No address to court, urgent certificate করো। এটা judgment form এ করে দিও, disposal হয়ে গেল। I'm grateful to you. Thank you.
Yes, my lord.
Yes.
My lord, I was under an impression that the obtaining of the copy of the decree shall be the date. That's why it has been come up.
The decree shall.
The decree was drawn up later on because the first application.
You did not file the certificate copy of the decree.
Yes, sir.
So
Section 5 not filed. Section 5 application not filed.
Sir, actually, my lord, actually, if you come to the
file a section 5, how what is the delay?
My lord, actually delay. I thought that the leave will be granted from the date of obtaining of the certified copy of the decree because first application I had made, then it was the judgment was only passed. Decree was not drawn up. So I obtained the judgment. Thereafter, the record was again sent back and the decree was drawn up. So I got the decree later.
You applied for the decree also later?
Later stage because that was not drawn up firstly.
6 days delay. Yes, Mr. Bhattacharya, we are allowing on oral prayer. Heard learned counsel for the parties. The minuscule delay of about 6 days was occasioned, comma, according to learned counsel for the appellant, comma, due to the initial misapprehension that the limitation period would not commence since the decree was not yet drawn up. However, comma, it transpires that the decree was applied for later, comma, leading to such delay. Since the said delay is not much and it was due to the apparent erroneous appreciation of the law on the subject, comma, we are of the opinion that the said delay ought to be condoned. Accordingly, on the oral prayer of learned counsel for the appellant, comma, upon hearing learned counsel for both sides, comma, we condone the delay in preferring the appeal. The appeal is accordingly deemed to stand registered and admitted. Yes, what is the challenge against?
My lord, during the pendency of a title suit for declaration of rejection of gift deed, cancellation of gift deed, a sale deed was registered in the year 2011.
Who executed the gift deed to whom?
My lord, gift deed was executed by one Jhumur Mukhopadhyay to one Boshanto Pramanik and Rituparna Pramanik. And that has been challenged because it was his assertion. The suit is still pending before the trial court.
Shelly Mukhopadhyay, how is she related?
Jhumur Mukhopadhyay, wife of Jhumur Mukhopadhyay, because Jhumur Mukhopadhyay has died intestate.
So very well. Shelly claims through Jhumur.
Jhumur.
And that gift deed.
Yes, sir.
You have challenged that.
Yes, my lord. That was challenged. My lord, in the meantime, this conveyance was done during the pendency of the suit.
By whom?
By a third party. This Ram Prasad Kaur, the respondent one, the respondent.
You are Shelly.
I am Shelly.
All right. You got the property by.
I did not get the property. I have challenged by that suit.
No. You are challenging the gift deed was executed in favor of your husband.
In favor of my husband.
Yes.
In the meantime,
who executed the sale deed?
The sale deed was executed by my defendants to a third party, Ram Prasad Kaur.
How is
Ram Prasad Kaur now came up after demise of my
Ram
husband.
Prakash claims through whom?
Ram Prasad
The
Kaur.
donor of your husband.
Yes, donor of my husband.
Donor of your husband. Your husband received the gift.
Yes.
The person.
No, my husband did not receive the gift. My husband gifted the property to Boshanto Pramanik and Rituparna Pramanik. This Rituparna Pramanik and Boshanto Pramanik, during the pendency of that suit, handed over the property to one Ram Prasad Kaur.
So you are challenging that gift deed.
Yes, I had challenged that gift
On
deed
what
by
ground?
another title suit. My lord.
Another title suit?
Yes, by another title suit. Now, this that title suit was filed in the year 2011, and the gift deed title suit was filed in the year 2004. Those two are pending.
When was the gift deed executed?
Sir, in the year 2002, I think.
2002 gift deed, 2004 suit challenging that. What happened
Yes.
to that suit?
That is still pending.
And
My
this
lord, in
second
the
suit?
meantime, my husband died.
So the second suit is for?
After that, this Ram Prasad Kaur came up with a title suit for eviction.
That has been decreed?
That has been decreed against this.
What is your ground in the appeal?
My lord, he has admitted, he has preferred the suit by stating that I am a licensee under him. But
Yes,
which,
if the gift deed exists, then you are.
my lord, that is still pending, my lord. My prayer was before the trial.
Pending does not mean that you have a decree.
No, I don't have, but this was the
Did you ask for?
sentence.
You could have asked for. You could have asked for stay of this suit.
Yes, I had asked for stay.
Section 10.
Section 10.
What happened to that?
My lord, that was not granted.
You challenged that in revision?
No, my lord.
Yes, why shouldn't we? Why shouldn't that be a ground?
No.
Section 10 not being allowed, that can be challenged under Section 105.
At least, my lord, nothing on record. Kindly come
Nothing
to
on record.
page 10. No, nothing. I'll show to your lordship, my lord, the statements, my lord, are completely from the bar. Record seems otherwise. Kindly see, my lord, page 10 of the impugned judgment, issue number 6. My lord, they don't. I am on the prima facie case for grant of stay. Now, my lord, kindly see issue number 6. PW1 is affidavit in chief stated that it is issued legal notice to quit on 12th February 2018, which was served upon the defendant under registered post. In the cross-examination, defendant did not dispute the same. PW1 marked such notice postal receipt AD card as exhibit 2/1, 2/2. The AD card exhibit 2/2 contains signature of the defendant. The defendant is served with notice notice to quit. Therefore, my lord,
this is a lease pending transfer. Sale in your favor. That lease was pending regarding their suit challenging the gift deed.
Exactly. Kindly see, my lord, the first paragraph in that page at least.
Which page?
10.
10.
Kindly see, my lord.
Yes.
Yes, kindly.
No, if the court says assuming that plaintiff could or could not.
No, they did not produce before that is the specific finding.
No,
they
if
did
the
not,
previous, what could not they produce?
what is the present status of the suit? Even their Millard predecessor had expired. That specific finding, since the suit has abated as of today.
No.
As of today,
then you had to, if you say suit had abated, you had to show something to the court.
That is their responsibility.
Page 6.
Allegation of abatement is yours. They say suit is pending.
No, for
that is the last position. You have to show that it has abated.
Yes, kindly.
Kindly come to page 6.
Judge will come back to you.
Kindly see, my lord.
Section 10 says if directly and substantially in issue, then although you may say not directly and substantially in issue, but your title has to be established first for getting this.
Kindly comes to, my lord, page. Page 7. Page 7.
Outcome of the gift deed is sub judice, and you claim through the donee.
Yes, kindly see, my lord. Kindly see page
7.
Page 7.
Yes.
Kindly see, my lord, this paragraph. Tenancy. Yes, the Peruse DW1. My lord will kindly see. She stated that in the same line of the WS that she stated Rituparna Pramanik and Boshanto Pramanik on 7th April to the addicted Jhumur Mukhopadhyay with 4 bottles of alcohol with undue influence and fraud and forcibly
That is the merit of the suit.
executed.
That is still pending.
deed of gift on 7th April 2004 in the name of Rituparna Pramanik and Boshanto Pramanik. DW1 stated that Jhumur Mukhopadhyay was unconscious and no knowledge about the execution of the gift deed, and returning to his senses inquired about the said signature and papers, but Rituparna Pramanik escaped for false pretext. Boshanto Pramanik obtained signature of Jhumur Mukhopadhyay on a paper with the help of the poster office agent. Agent withdraw 5,80,000 for the purpose of opening MIS account in the name of Boshanto Pramanik, which was stolen by him. PW1 Jhumur Mukhopadhyay obtained certified copy of the deed of gift deed dated 7th April 2004 on 13th March 2008 and filed title suit number 4737 of 2008. During pendency, the plaintiff applied for being adding party, and Jhumur Mukhopadhyay filed another title suit number 136 of 2012 so that Boshanto Pramanik does not sell out the same, and in the meantime Jhumur Mukhopadhyay died, leaving behind the defendant. Defendant fined electricity bills, the telephone bills and property tax bills. She was cross-examined. She also does not know the plaintiff. She stated she does not know what about who brought the 4 bottles of alcohol. She personally did not.
Yes, whatever that suit is pending.
Ultimately,
this is an arguable question. We'll admit the appeal. The
yes,
appeal
kindly see, Milord, the second
pay, but they'll pay, put in some.
Kindly see, Milord, the next page, Milord. The second line, it starts with both.
My lord, kindly.
The issues involved in the other suit cannot be decided in this by this court.
No, these are their statements in the written statement, Milord, which has been, Milord, quoted by the learned trial judge. Yes. Ultimate finding
they have made out a case, alcohol or otherwise, they have made out a case.
That is not the case.
They have to prove that in that.
Yes, kindly see
the 2 suits could have been clubbed.
Kindly see, Milord, this line. Both sides does not file any document of the same in title suit number such and such, stated that in affidavit in chapter the date of Milord, page 100 last.
Page
the
10,
first
10.
Page 10. Oh yes, page last 10. Both the sides. First
page 8.
Page 8.
Page 8.
Page 8. Page 8.
Yeah.
Page 8 of the impugned judgment.
Both sides.
Yes. Both sides did not file any documents of the suit, namely such and such, and and PW1 stated in his affidavit in chief that after death of Jhumur Mukhopadhyay, the above suits were abated. Milord, it was their duty, Milord, to bring it's on record.
Jhumur's death is admitted.
Therefore, they are claiming, Milord. And Milord, kindly see, Milord, another thing, my lord, Milord, one observation fell from your lordship, the lease pendants transfer. Milord, that has also been dealt with. Kindly see, Milord, with very well written judgment, Milord, kindly precondition.
No. If it abated, then there is no lease pendants.
No, my lord. Miss case is pending till now.
Why didn't you produce any document? Even before us, you have not annexed anything?
Yes, my lord. I have filed the suits.
No.
Page 4 of the
substitution application?
My lord?
Your husband has admittedly died. He was the plaintiff there.
Miss case I have filed.
Miss case
I have filed miss case. Order 9, Rule 9.
Order 22.
Order 22. Order 22 rule.
Have you annexed that here?
No, my lord.
Then you did not produce it before the trial court. You did not produce it here. Why should you grant to stay?
My lord, leave.
Have you got a copy of that? Order 22 line or whatever.
My lord.
It must be 9 or 4.
Order 20 rule 9. Rule 9. Rule 9.
Order 22.
Order 22 rule 9.
What is that application? Without that, there.
My lord, give me a day. I'll
give you a day.
My lord.
No,
tomorrow.
The present appeal has been preferred against a decree of eviction passed
For
against
second half, if it is fixed, I can.
Passed against the appellant. Proceeds of next para. Learned counsel for the appellant submits that allegedly a deed of gift was executed by her husband, late Jhumur Mukhopadhyay, in favor of 2 persons who, in turn, sold the property purportedly to the plaintiff stroke respondent herein. Whose the next para, it is argued that the said deed of gift was challenged by way of a suit which is still pending. During pendency of the said suit, a lease pendants transfer was effected by the by the alleged donees of late Jhumur Mukhopadhyay in favor of the present plaintiff respondent, and as such, by virtue of operation of section 10 of the Code of Civil Procedure, the eviction suit from which the present appeal arises ought to have been stayed during pendency of the previous suit challenging the gift deed. Full stop. Next
My
para.
lord, may I say one thing? My lord, kindly come to page 6 of the judgment.
We'll come to that. Learned counsel for the respondent submits that the original plaintiff Jhumur in the previous suit, having admittedly met his demise, comma, the said suit abated. Full stop. The learned trial judge, comma, it is pointed out, comma, in the impugned judgment observed that no documents regarding the previous suits and or any steps being taken by the present appellant for substitution in the said suit having been furnished, comma, the previous suit was deemed to have abated, and as such, comma, the principle of lease pendants as enumerated under section 52 of the Transfer Property Act could not be applied to an abated suit. Full stop. Next para. Yes, page 6, what?
My lord, the issue numbers 3, 4, and 5, my lord. It is admitted by both the sides that Jhumur Mukwada filed suits, namely such and such, peruse the cross-examination of PW1.
No, their case is that it has abated.
He purchased the suit property from Boshanto Pramanik and Rituparna Pramanik. He admitted that Jhumur Mukwada was neither a licensee nor a tenant under him in the suit premises, and there is no scope of revocation, either licensee or tenancy.
Yes. Your husband was never a licensee under him.
Exactly.
You are a trespasser after the transfer.
My lord.
Next para. At this juncture, comma, on the query of court, comma, learned counsel for the appellant submits that the appellant is ready to produce the
Rule 9
application for substitution filed in connection with the previous suit challenging the gift deed. Push up. Next para. Accordingly, the matter is adjourned till November 24, 2025, when it will be listed under the same heading for the purpose of production of such application. Even if you produce that, ma'am, you have to file a proper order for
supplement. Yes.
Bring that for the time being. Yes, an advance copy of the same shall be handed over to the learned advocate for the response.
Much obliged.
Well, I am for the appellant application, my lord. There is an order passed by this honorable court on 19 September 2025 to deposit 20,000 each 10,000 check to the respondent, and there is
Section 5 was allowed.
Yes, my lord, that is allowed. I have deposited the check.
This is against an eviction decree.
Yes, my lord.
That's why the check was for security.
Yes, being a trespasser, my lord, on the ground of trespasser. But my case is I am a tenant, my lord.
So, interim stay was granted to you, subject to
my lord. Expire, my lord, for
you will dispose of the stay application itself and grant that stay till disposal of the appeal. They'll prepare the paperbooks and trial court records.
My lord, there's one more thing I need to point out before this
Yes,
learned
yes.
court. That, my lord, firstly, there was an order upon me to file an affidavit in opposition, but it seems that my affidavit in opposition has some minor inconsistencies.
Need not file it. We are saying that it is deemed that you are not admitting any of their allegations. And since they've already put in a check, they have paid to you that check.
Directly client.
To
Directly
my
his client.
To my
His client.
It is
So
that.
for the timing, that's some security. So we'll direct the appeal to be
Yes,
expedited.
that is the check, my lord. They one check they have encased, but another check till date, no report, my lord, from the bank.
You have done your duty.
I comply the order of this honorable court.
Very good.
One indulgence, my lord.
Yes.
In view of Atmaram properties, may there be an order for them to deposit some occupational charges with regard to the property.
20,000 was directed to be paid.
Yes, my lord. I prefer a monthly occupational charges.
What is the area? Which location?
The location is opposite Lake Mall in Raspberry Avenue Road.
Then you have to file your opposition and show us what is the contemporaneous rent.
Yes, my lord. I'll file the opposition before the next.
File it. You are already enjoying the stay till disposal of the application.
No, my lord, limited.
We'll extend that till disposal.
Well, kindly extend it.
The interim order granted earlier is extended till disposal of the application bearing can 1 of 2025. Full stop. Learned counsel for the respondent seeks to use and affidavit in opposition. Full stop. Although previously a direction was given for filing affidavit in opposition, comma, learned counsel for the respondent submits that there is some discrepancy in the draft affidavit and as such seeks an extension of time to file the same. Full stop. Accordingly, the time for filing affidavit in opposition is extended for a week. Extended till November 25, 2025. Full stop. Reply finish shall be filed by December 2, 2025. Yes. The application shall be listed thereafter on December 8, 2025. Thank
Yeah, I did
you.
that.
Thank you. Okay.
23, my lord.
Yes. What is the matter? You have to put in Tolaban and written up notice form and all these things. Do that by
Yes.
tomorrow. Yes. What about the
My lord, Your Worship, kindly say. Preliminary degree suit for, I am the defender.
no caveat for the first time?
No, caveat for the
Usual order. Usual order.
Your
The
Worship,
applicant.
my lord, I will pray, my lord, the stay of the impugned order because, my lord, the suit for declaration, partition and injunction.
All suits for partition are that.
Now the
Declaration is inbuilt in the preliminary degree.
here, my lord, the point is very short and simple.
Declaration, you have challenged some deed in their favor.
Yes. Because on the basis of
It has
the
been
wrong
turned
recording.
turned down by the learned trial judge. So
Yeah, no,
let
Your
the
Worship.
final degree proceeding. Preliminary degree is there. Final degree proceedings will continue, but no degree shall be drawn up.
But here, my lord, Your Worship, just 1 minute, my lord.
Yes.
My lord, the plaintiff claiming on the basis of the my lord, the entry in the record of right, which has been defeated, my lord, in a 44 to a proceeding earlier. And my lord, in spite of that,
How did the court deal with that?
Yes, my lord.
How did the trial court deal with that?
Well, Your Worship, kindly see what I have said. Your Worship, kindly see.
No, let us see the judgment, impugned judgment.
Your Worship, kindly come the Your Worship, kindly page 2 of the trial court's judgment.
Yes.
We have said that earlier objection was there. They have defeated.
No, how did the trial court deal with it?
The trial court has not dealt with this matter. As their name has been recorded, so they have acquired their right. The title has been declared. That is the only.
Ahmed Mir is them. Ahmed Mir, your man or their man? Ahmed Mir.
Mir, my lord, my yes. Your Worship, kindly see.
They did not produce a single no registered deed has been produced.
But
56.
the registered deed, well, here Your Worship, can see registered deed in respect of plot number 278. Actually, the plot number is 228. Now, my lord, they have not corrected it on the basis of my lord the wrong, my lord, the recording. Now the several, my lord, the transfer has been made. Thereafter, my lord, they have
several transfer deeds are
Yes.
there.
Well, it is recorded. It is recorded that
Stay.
the wrong recording is there. They have not corrected it. Everything is there. And apart from this, my lord, they have filed a 44-2A proceeding. They defeated. We filed a 44-2A proceeding. My lord, we have win the game. We have win. In spite of that, the trial court, my lord, I have specifically stated in the written statement.
44-2 of the land reforms.
No, 44-2 the Estate Acquisition.
Sorry, Estate Acquisition Act.
Yes.
So you won that and they lost.
They lost. I have annexed.
But court says that their names have been recorded.
Recorded. So as erroneously recorded, court held that
one in the 44-2A, your name should have been there.
Yes, accordingly it has been recorded. Since the date of CS, RS, my name has been predecessor.
They produce the CS records.
Yes, CS record. I have annexed all.
And you produce the RS record.
RS record.
And you also produce the documents regarding 44-2A.
Yes, I have annexed all. And in the written statement, I have stated in paragraph 28, 23.
Their name was initially not, their name was also not recorded. Why did they file a 44-2A?
They 44-2A because our name is recorded in the record of right.
Initially it was.
They withdraw it. They withdraw it.
In the CS records, your name was recorded.
Yes.
They filed 44-2A, withdrew.
They withdraw it. I have annexed it.
So why did you file 44-2A then?
44 because one certain portion was recorded in their name. That is why I filed a 44-2A.
All covered by the suit properties.
Suit property, yes. That is the, and as they managed to record in the LR record of right, the court held that yes, on the basis of the recording, they have acquired the right.
It's it's arguable, but let there be the usual direction.
So that is why, my lord, I am praying the because unless and my lord, the
title
You
is
understand it
decided.
will be a futile exercise, but
I have annexed, my lord, your lordship kindly say, I have even the B form I have submitted. My predecessor interest filed a B form that has been accepted. 244 2A proceeding, our 44 2A, we have win. They filed 44 2A, they have withdrawn it. Thereafter, the RS record of has been prepared. I have annexed all.
and the deeds were never rectified.
No, they have not rectified. They have it is recorded in the judgment also. Your lordship kindly see.
A strong prima facie case for hearing of the
Yes.
appeal has been made out. Footstep next para.
Admitted the position of the plot number has not been rectified.
No,
Your lordship kindly
you had
confess.
no. Sorry, it's their suit.
Their suit, yes.
So you did not challenge their title deed.
No, because the
Well,
plot is other. Yes.
Learned counsel for the present appeal arises out of a preliminary decree passed in favor of the plaintiff's respondents. Footstep next para. Learned counsel for the contesting defendant stroke appellant submits that the learned trial judge proceeded to pass the decree on the basis of faulty title of the plaintiffs, inasmuch as the title deeds produced by the plaintiffs, including subsequent chain deeds executed on the premise of the initial title deeds, were in respect of a different plot of land than the suit property. Footstep next para. Although such error was noticed in the impugned judgment, the learned trial judge, it is contended, glossed over the same and relied on certain record entries in the LR records of rights. For sub next para, learned counsel for the appellant places reliance on the relevant portions of the impugned judgment, where it was discussed that the plaintiffs that the defendant stroke appellants had produced documents to indicate that there was a proceeding initiated under section 44 within bracket 2 small a of the West Bengal Estate Acquisition Act 1953 by the defendant stroke appellants, where the defendant stroke appellants came out successful and their names were directed to be recorded in place of the plaintiffs. Footstep next para. On the other hand, a similar case filed by the plaintiffs under section 44 within bracket 2 small a of the 1953 Act was subsequently withdrawn. Footstep as such, the entries in the LR records of rights do not reflect the correct position and go contrary to the forward presumption carried by the CS and the RS records of rights. Footstep next para. In such view of the matter, it is submitted that the preliminary decree, based on erroneous appreciation of title deeds and records of rights, ought to be stayed. Footstep next para. In view of a strong prima facie case in that regard having been made out, we are of the prima facie opinion that at this juncture, if we permit the final degree proceedings to continue, it might be rendered a futile exercise in the event the title and the possession of the parties are found out to be contrary to those recorded in the impugned judgment. Footstep. Hence, there shall be stay of operation of the impugned decree till disposal of the present application. Footstep. The appellant shall serve copies of the application on the respondents, indicating that the application shall be listed next on December 15, 2025, when an affidavit of service to that effect shall be filed by the appellant.
Yes, I'm developing.
The appellant shall put in the Tolobana postal cost and written up notice forms in terms of the office report by tomorrow.
Then I have to
7 rupees. 7 rupees, it will be difficult to get. Otherwise, please ask him junior to come that side.
Yes.
Come on. Yes, Mr.
May I please, Your Lordship, this
You also Tolabana, the 40 rupees for.
This Naki.
No, they don't even know that there is such a report. We will leave to put that in. What is that?
It arises out of a suit for specific performance. Suit has been dismissed. We preferred an appeal here and filed an application for injunction. That has been, interim order was passed by Justice Somen Sen just before the vacation. But a limited interim order, that has to be extended.
What about service on that?
My service. Well, on that day, my lord, some learned advocate appeared, but he himself didn't appearing in the suit. He says that somebody else will appear, but we don't find any, my lord. Vokalatnama, we serve the.
So why was the stay application not disposed of?
My lord, we serve the respondent, my lord, who have sent copies.
What is the endorsement?
Endorsement, yes.
Insufficient address for two and for
Two have been served.
Right.
Two have been served and
they contested together in the trial court.
Yes.
Mr. Ghosh will just come back after decision and take up this matter. No, there's another 2 p.m. fixed matter. It's a short matter, 2 p.m. fix. After that, we'll take up this. In the meantime, please ascertain this. First of all, whether they contested together. If they contested together, we'll deem this service on 2 to be sufficient service. And we'll proceed. Just take this information, ask your learned junior. After 2 p.m. fixed, we'll take up this matter.
Yes. Your Lordship, the valuation is 50 lakhs, as will be evident from the plaint and also the judgment. The decretal amount, which is being reflected there, has been wrongly incorporated.
The decree has been then wrongly.
Yes, yes, Your Lordship. I have flag marked the pages of the plaint and the judgment portion, but in the correction,
Thank you very much. That's of nice assistance to us. As you said, 50. Okay. After we had passed an order dated November 4, 2025, in the appeal, it was pointed out to us by the department that the valuation of the suit as reflected in the certified copy of the decree of the trial court was 50,000, taking the matter beyond the pecuniary jurisdiction of this court. Full stop, next para. Accordingly, the matter was listed today. Full stop, learned counsel for the appellant rightly points out from the plaint as well as the other materials on record that the actual valuation of the suit was rupees 50 lakh, thereby conferring pecuniary jurisdiction on this court. Full stop, next para. In fact, the valuation statement reflected in the certified copy of the decree was erroneous. Full stop. Accordingly, let the certified copy of the decree be sent down to the trial court immediately for effecting necessary corrections in that regard.
Grateful.
Thank you very much. We thought we'd have to recall our entire order. Yes. To be so, however. চলে আসবে ও কল করুন ইয়েস প্লিজ অবশ্যই
In the trial court, written statement was filed by dependent number 1, 2, and 3. And when we served the copy here, 1 and 4 has accepted. 2 and 3, my lord, along with 1, filed the written statement.
So we'll consider this to be good service and there was a previous ad interim order was passed.
Yes, yes. That's sometime before the vacation.
This you said arises from what suit? You just said in the morning. We just
my lord.
It arises from what sort of suit?
Specific performance of contract.
Oh, that was dismissed.
That was dismissed.
An injunction was granted in terms of your prayer.
Yes, my lord.
We'll just check up.
Yes.
Alienating, encumbering, disposing of properties in question. We have prayed for. You also prayed for nature character, in fact.
Yes.
So we'll grant that also. Affidavit of service, you have filed the affidavit, file it. Affidavit of service filed to be kept on record. Full stop, next para. We find therefrom that service has been effected on respondent number 1, numbers 1 and 4. Full stop, since the respondent numbers 1 to 3 contested jointly in the trial court, we deem the service on respondent number 1 to be substantial service on the other 2 respondents, that is respondent numbers 2 and 3 as well. Full stop. Next para, that apart, we find that the service was sought to be effected at the address of the respondent numbers 2 and 3, where they were served in the trial court, and as such, there is presumption of good service. Full stop. Next para. In such view of the matter, we take up the injunction application for hearing. Full stop. Upon a perusal of the materials before us, we find that that a sufficiently strong prima facie case has been made out for hearing of the appeal, more so since questions of both fact and law are involved in the appeal. Full stop. Next para. Accordingly, can 1 of 2025 is allowed, thereby granting injunction restraining the respondents and or their main agents from selling, transferring, alienating, and or encumbering the suit property in any manner in favor of third parties and or changing the nature and character thereof, both till disposal of the appeal. Full stop. The appellant shall put in Tolovana written up notice form and postal cost for service of notice on the respondents within by tomorrow, because there was a previous direction which by tomorrow. Full stop. Next para. The trial court record shall be brought by special messenger at the cost of the appellant, to be deposited within a week from date. The appellants shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellants. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is made ready.
My lord, in 25, my lord, I am for the defendant number 1, plaintiff, suit for partition.
I am for respondent number 2, my lord.
Pursuant to my lord's direction, I have served. This is my affidavit of service.
One has received, Mr. Mahato.
Yes, I am the defendant number 1.
No, respondent number 1 has
Respondent
received.
number 1, yes, my lord. Respondent number 1, he has, my lord, filed an independent appeal. That is item number 26.
You are for respondent number?
No.
Yes, my lord. Just a copy of the appeal file served upon me.
That is the
Just-
26.
just-
That is
that is
item 26. But so far 25 is my matter. I am the appellant.
26, who is the appellant?
21, the defendant number.
You are appellant in 26.
He is the plaintiff. He is the plaintiff.
So why 2 appeals? What is the background?
My lord, suit is for partition. Preliminary decree passed declaring 1/4 share of each 4 brothers and sisters. 2 brothers, 2 sisters. My lord, that was accepted. It was not challenged. 1/4 share, therefore no challenge.
Yeah.
In preliminary, a final decree, my lord, it was during COVID period. The preliminary degree the report was accepted on, my lord, in the first half of March 2022. My lord, 28th of February, there was, my lord, I was not aware about that. I could not file any objection to that. I could not take any step. My lord, subsequently, when the execution was filed, I took step, prayed for stay, prayed for expertise, recalling. But my lord, those have been dismissed. But therefore, my lord, when he came to me, my lord, I advised him that unless the final degree proceeding is applied for, then no relief can be granted. Therefore, my lord, this appeal has been filed. In this event, my lord, there is a delay of about 3 years, 8 months. My lord, the delay is, my lord, delay is around 1239 according to stamp reporter.
What is the explanation for that, Mr.
Explanation for, my lord, I have stated everything in the application for stay. I have stated everything in the application for section 5.
My lord, COVID ended in the year 2000.
Mr. Mahato knows that very well. Let us see what
This
he has.
is my affidavit of service.
Yes.
Order passed 2020.
My lord, kindly come to page 4, paragraph 10.
When was the execution levied?
My lord, 27th is the date fixed for, my lord.
No, execution, when was it filed? Execution case?
Execution filed in, it is, my lord.
39, 2023. By the
Then
defendant.
by then you must have got
Respondent number 3.
by then you must have got intimation.
Yes, after that, my lord, I filed the application before the lower court, my lord, the executing court for give some accommodation. So,
Please wait, let him finish.
Recalling of the ex parte orders, my lord, I filed those applications. My lord, if you will also kindly come to page 4, paragraph 10, that on January 21, 2020, as such date was fixed for commissioner's report in view of the order dated 21st August 2019. Both parties filed Hajira. My lord, kindly mark this. It has been recorded in such order that no commissioner report has been received and May 30th, 2020 was fixed for commissioner's report. Then, my lord, in the order it has been recorded that commissioner's report already filed. This, my lord, I have got the entire order sheet. My lord, I am handing over to your lordships, my lord, those orders. My lord, entire the preliminary degree as well as the all order sheets, my lord, I have handed over to your lordship.
Again, it was recorded, no commissioner's report.
Yes. Not only that, subsequently, my lord, it has been again recorded that the no commissioner report has been filed.
How did you ultimately become aware?
My lord, when execution has been initiated, my lord, I came to know about the final decree. That I have stated, my lord. But if your lordships kindly come to the order dated, order number 87 of the certified or copy of the order, order number 87, 21st of August 2019.
No, that is fine, Mr. Mahato, but after that also there were several orders.
Yes, that's true. But why I was not aware, these are the reasons.
You are defendant number 1 in the suit.
Mine. Well, from the order sheet, it is 87, it is 21st August 2019. Then, my lord, handwritten 88, 21st of January 2020. Then again 88, order number 2, order dated 2nd of September 2019. And my lord, kindly see, On 2nd of September, it was put up by the defendant number 3, who has applied for the final degree. Defendant number 3 has prayed for final degree. Well, these steps was taken on his behalf, on her behalf, on behalf of the defendant number 3, without my knowledge. And well, on that day, according to this order, commissioner has submitted the report. Well, next date has been fixed as, well, kindly see, date was initially written 21st of January 2020. Subsequently, it has been overwritten. Well, kindly come to the back earlier page. Well, it is 21st of January 2020. Order number 88. How it can be? It says today is fixed for commissioner's report. Both parties files are here. No commissioner's report is received as yet. Fixed 30th May 2020. For commissioner's report, it appears that commissioner report has already been filed. Can it be passed, my lord? For it is fixed on 30th May commissioner's report, then it is written, it appears that commissioner's report has already been filed. And next order is, my lord, 2nd September, which is earlier order. Which should be, my lord, it should be, my lord, in between these two. And my lord, even, my lord, on 4th of December 2021, it has been
this was handwritten was inserted later.
Yes. It is clear from the order sheet. And my lord, again.
You are defendant number 3.
No, he is for the different one.
I am the respondent number 3.
Yes, what was that this business about this order number 88 appearing twice and handwritten inserted?
88.
Order number 88, there are 2 88 orders. It's fishy.
Well, commissioner's report was filed. And thereafter, my lord, 16, my lord, on 16.
On 21st of August, 21st of January 2020 was fixed as the next date.
Well, in the meantime, the commissioner report was filed. And well, thereafter, in the para number 16, my lord, petitioner has filed objection to the partition commissioner's report. It was well within his knowledge.
No. Earlier paragraph 15 I have stated. Paragraph 15 I have stated. Petitioner is not aware about the submission.
After knowing, then he filed written objection. It was not maintainable apparently.
Then he filed, and which was time barred accordingly. It was
obviously it was
after final degree.
That's why he has now advised to go.
Yes, my lord. There is one order. It is clear, my lord.
And not only that, again, my lord, on 4th of December 2021, it is written that no commissioner's report has been.
Yes, we have seen that. Let us hear him. Yes.
Yes.
What was within his knowledge?
My lord, kindly.
How do you derive his knowledge?
My lord, kindly see, my lord, an order, my lord. Order dated, my lord. That is 27/10/2025.
27?
I'm reading, my lord.
27?
27/10/2025.
This is in the execution case.
Yes, my lord. My lord, second part, my lord. On perusal of the case record, it could be found that the present execution case has been filed on 30/9/2023 by the petitioner, degree holder, and defendant Ajanta Ghosh, and providing ample opportunity to the judgment debtors. This court has passed an order issuing the writ of execution of the decree dated 23/3/2022. As obstruction has been faced while executing the order of this court, petition for police help has been passed by this court as per order number 16 dated 37/2024. While passing the said order, this court has elaborately stated that Alok Mitra, the appellant herein, the judgment debtor has no locus standi to file any petition for staying the execution of the order of this court, as his prayer for filing written objection has been turned down as per order.
No, rightly turned down, but then now he has preferred this appeal against the ticket.
After 4 years came here.
Yes, but it is sufficiently explained because the order sheet is not.
The very next line, madam.
Does not inspire confidence.
Next line, madam. And it appeared that the first appeared after passing the preliminary degree, my lord, 18/11/2025, and for a period of almost 9 years, he remained silent about the matter and did not come to the court. That is the petition, the appellant here. Come to the court and 9 years and remained silent about the matter. He himself has not filed any written objection against the commissioner's report submitted on 23/3/2022. The commission work has been carried out in the presence of each on 25/3/2016, and the knowledge of each is also apparent from the field notice that bears his signature there. He put his signature in the said notice. And now the question is.
This is 27th of October 2025.
Yes, ma'am.
The very same date he has filed this appeal. No, he has filed the appeal before that.
Yes, that was dismissed, and my lord, but the suit properly, but in spite of Jamie's case, 14/2025, and other Jamie's cases already filed, considered, and rejected. And my lord, stop and repeatedly and harassing the degree holder, but till date, neither any cost nor has been paid or conducted by the advocate. Among their cost already imposed, they have not paid. My suit was filed in the year 2009. 2015, the preliminary degree was passed. And thereafter, after 10 years,
But they were
execution order was
not
passed.
advised correctly because they had also.
My client is 65 years old. How long he will have to stay?
But here they had
Being prejudiced by the commissioner's activities. The distribution was not properly done. We have that is being the reason that the commission has been challenged.
revisional application was also filed by them.
That is
So apparently there was wrong advice. It's apparent. We are allowing this section. You have anything to say regarding section 5?
Section 5, my lord, I am for the appellant. My lord,
Yeah, then you are also with a section 5.
yes,
What is your ground?
same ground, almost same, my lord.
You are selling with him. I mean, selling with him, that's not wrong.
Adopting is something. Absolutely.
No, but you contested with him together.
Yes, yes.
Just I have been.
No, both of you contested together.
Division application was filed, both the brother and one sister. Both the brother and one sister. That
The appellant and the respondent both are brothers and sisters. And now they are in number in 4. Each will get 1/4 share. And that has been done.
They are not.
That distribution is not properly done. That
Allocation.
distribution is not properly done.
How?
That is the reason. That is the
That
reason
is
this
what we
particular
have-
commission's report has been challenged. That is the perversity. That is.
So you also have a section 5 which is can 1.
My lord, yes. Well, I cannot find any irregularities of the said order.
We'll
And that
check that.
challenge.
Can 1 of 2025 to the two applications for condonation of delay bearing can 1 of 2025 in each of the appeals are taken up for hearing together, comma, since both appeals arise out of the self-same final decree of partition. For next para, the petitioners, the appellants in both the appeals submit that there were several discrepancies in the orders passed by the learned trial judge in the partition suit after the preliminary decree was passed. For next para, although the parties had no qualms with the preliminary decree and the shares allocated thereby, comma, appropriate opportunity was allegedly not given to the appellants to file written objection to the partition commissioner's report as well as to cross-examine the partition commissioner. For next para, learned counsel for the appellants in each of the matters, please hand over a photocopy of the certified copy of the order sheet of the suit for the relevant period. From there, comma, we find prima facie several discrepancies. Next para, for example, comma, the COVID-19 pandemic intervened during final decree proceedings. On December 4, 2021, it was recorded that no commissioner's report had been filed. However, comma, prior thereto, comma, there are two order number two orders, comma, both bearing number 88, comma, respectively dated January 21, 2020 and September 2, 2019. Full stop. Whereas the order dated September 2, 2019 ought to have preceded in chronology the order dated January 21, 2020, comma, we find from the order sheet that the order dated January 21, 2020 was incorporated by hand in between order number 87 dated August 21, 2019 and order number 88 dated September 2, 2019. Full stop. Hence, comma, it is quite clear that the said order dated January 21, 2020 was incorporated subsequently by hand. Full stop. Next para. Also, comma, in the order dated September 2, 2019, comma, we find the next date to have been fixed initially on a different date, comma, which was subsequently manipulated by hand by putting May 30, 2020 as the next date, comma, apparently to suit the chronology of events. Full stop. Next para. That apart, comma, we find from the applications under Section 5 of the Limitation Act that there was sufficient reason for assuming that the petitioners were not properly advised, comma, since even after coming to know of the execution case levied on the final decree of partition, comma, the petitioners in each of the appeals, the appellants in each of the appeals were advised to file written objection to the commissioner's report and seek recall of the order whereby the commissioner's report was accepted, comma, even after passing of the final decree. Full stop. Next para. Upon such prayers being refused by the executing court, comma, a revisional application was even filed under Article 227 of the Constitution of India before this court. Full stop. Next para. Such turn of events clearly go on to show that first, comma, there was severe discrepancies in the orders passed by the trial judge, learned trial judge, and secondly, comma, the appellant in both the appeals were not properly advised initially. Full stop. Thus, comma, we find that applying the principle, liberal principles applicable to condonation applications, comma, since no evident malafidez or negligence on the part of the appellants has been made out, comma, as they had all along pursued the proceedings in the trial court, comma, the delay in preferring the appeals ought to be condoned. Full stop. Accordingly, Can 1 of 2025 in FAT 433 of 2025 as well as Can 1 of 2025 in FAT 479 of 2025 are allowed on contest without any orders to cost, thereby condoning the delay in preferring the said appeals respectively. Full stop. The said appeals are deemed to stand registered and admitted accordingly. What is the interim order? Application? Stay.
Stay.
Yes, you are granting stay for a limited period. They'll file paper books and all. In view of a sufficient prima facie case having been made out regarding the allocations of shares by the final decree of partition, Can 2 of 2025, Can 2 of 2025 in each of the appeals. Can 2 of 2025 filed in each of the above appeals are allowed, comma, thereby granting stay of operation of the impugned decree, stay of all further proceedings in title execution case number. What is the number?
2023.
Title execution case number 9 of 2023 pending before the learned civil judge, senior division, second court, Sodor, district, Paschim Medinipur, till disposal of the appeal. Full stop. Next para. The appellants shall, the appellants in both the appeals shall prepare composite paper books in respect of both the appeals within the requisite number of prepare and file the requisite number of composite paper books for both the appeals within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant in each of the matters, whichever is earlier. Whoever is served first, you will coordinate with the other.
Sorry for indulgence, in my appeal, Can 2 is the application for condonation of delay, and Can 1 was the stay application.
দিয়েছি। কেন ওয়ানটা সেকশন ঠিক আছে।
যেখানে বলেছি না অনেক যে ক্যান ওয়ান ইন বোথ দি অ্যাপিলস, ওখানটা চেঞ্জ হবে। সেকশন 5 এরটা বেলা ক্যান ওয়ান অফ 2025 ইন FAT 433 না কত বললাম ওইটা, আর and can 2 of 2025 in FAT 479 of 2025, ঠিক উল্টোটা হয়ে যাবে পরেরটা। can 2 in 33 টা, can 2 in মানে স্টেটার can 2 in 433 of 2025 আর can 1 in 479 of 2025 স্টেটার স্টেটার
My lord has
liberty to the parties to mention the appeals for hearing analogously as and when the for hearing as and when the same are ready for hearing, the appeal shall be heard analogously.
My lords have been
Condonation can 1 433 te আর 2 অন্যটায়, আর stay te can 2 433 te আর 1 অন্যটায়। Yes, sir.
My lords have been pleased to grant stay of all further proceedings. My lord,
Of execution case.
It includes, my lord, the order by which, my lord, 27th of November has been fixed for giving possession by police. This is the order.
Writ of possession if issued pursuant to the impugned decree hereby stands recalled.
My lord, I am good.
May I be permitted to file
In the department. Leave is granted to the learned advocate appearing for the respond number 3. Respond number 3
and 2, my lord.
3 and 2, huh?
2.
You have also not filed your wakalatnama.
I have the Vakalatnama but not filed in.
2 and 3 to file their wakalatnama, respective wakalatnamas in the department.
Extremely grateful.
My lord, one thing more, my lord.
Quick,
My
quick,
appeal, my lord. In advance, my lord, I could not plead them the parties proceeding.
As a copy has been served properly, my lord, I may be
Leave may be granted, my lord.
Liberty to the appellant, liberty to the learned advocate on record for the appellant to implead the necessary parties in the cause title of the memorandum of appeal in FAT number 479 na kota bolo, of 2025.
I'm grateful.
Copy has been given, so you can appeal.
Yes, my lord.
Acha, all of you are appearing.
Another Vakalatnama, my lord.
Yes, আরেকটা line add করে দাও যে in view of appearance of the parties, service of notice of the appeals on the respondents is dismissed with. All the parties are before us. File another Vakalatnama, take another.
My lord, I appear for the appellants.
Yes.
This is my affidavit of service, my lord.
Here also Talabana not filed and whatever. What is the application for?
My application, my lord, the appeal arises out
There was
of
a direction for service.
Oh, my caveator.
I'm the caveat.
You are the caveat.
My lord, the wife before it, my lord, suit for
Divorce granted or refused?
Granted. I have filed my the counterclaim that was not considered, my lord, by the learned court, my lord.
Counterclaim for divorce also?
Divorce as well as the, my lord, the permanent alimony to the tune of rupees 20 lakhs, my lord. Nothing has been considered, my lord. Only 4
His
lakhs.
divorce decree was granted.
Divorce decree was granted. Only, my lord, the 4 lakhs has been granted. Kindly sees the ground of.
You should send this to mediation.
Yes, your lordship.
Both of you asked for divorce, so it's irreparably broken.
Yes.
Grounds are different.
But
so
the
you agree probably
but
to
the affidavit
for the
also
ground-
was not considered. Was not ever called for, my lord. Affidavit of assets as has been directed by the Honorable Supreme Court in the Honorable.
No, because you may have a good case in the appeal, but should we send it to mediation? Because then it can be resolved once and for all. Instead of going around the courts. And in any event, if mediation fails, you can come
Regarding the
back.
quantum, that can be settled there. Lord.
Exactly.
Yes.
Quantum can be settled and there may be mutual agreement that you withdraw the allegations made against and the usual things.
Kindly, Lordship.
So we think that should be better.
Lordship.
So in the meantime, we are passing injunctions so that you don't remarry.
Get.
But you should want him to remarry. So
Right,
that
he has filed an application for reconstitution of conjugal right that has been mentioned in their.
In the counterclaim pre-array 32 page, he admitted he wants divorce. She wants divorce. She got that.
So you filed a divorce suit.
I have
He filed a divorce suit and in your divorce suit filed a suit for
Lordship,
restitution.
may I? I have filed the divorce suit in counterclaim. She also prefers for the divorce regarding the quantum of maintenance. She asks for 20 lakhs and the court granted 4 lakhs regarding.
Not two suits. In your suit.
In one suit.
Acha, they have filed a counterclaim for divorce.
Lordship.
So
if
he's
somebody-
saying you asked for restitution?
Yes, ma'am.
That restitution was then I have withdrawn, and the contested matter was filed, and
suit was originally for restitution of conjugal rights.
that suit was withdrawn, and the contested
Sit
suit
down.
was filed in
That's
that
not
suit.
considered.
The subsequent suit, she filed the counterclaim.
Even on facts, you cannot agree. Who filed the suit?
Well, the page
his
39
application, kindly
Who filed
see
the suit first?
But the husband.
For what?
For
divorce.
Restitution was filed first by me. Then it has been withdrawn, and thereafter
Suit was
desertion and
filed in
desertion.
2018. The restitution was filed in 2023, ma'am.
Kindly see the page number 32.
Kindly see page 20.
Kindly see. In counterclaim, she also sought for divorce, and the divorce was granted with alimony 4 lakhs. And now her contention, she must get 20 lakhs, which has not been considered. The matter may be remanded back. And your lordship rightly pointed out that the matter may be settled in mediation. If both the parties on the last occasion wants for the divorce and the divorce has been granted, then what remains?
What happened to his restitution suit?
But that I do not know, my lord.
That has been withdrawn by me. That has been withdrawn by me.
The facts of the case are peculiar. Full stop. The husband, the respondent husband, filed a suit for restitution of conjugal rights, which, it is submitted on behalf of the husband, has subsequently been withdrawn. Full stop. The genesis of the instant appeal is a suit for divorce filed by the respondent husband, where the appellant wife also filed a counterclaim for divorce, albeit on different factual allegations and grounds. Next para, whereas the husband's suit has been decreed, the wife's counterclaim, including the claim for permanent alimony, was dismissed. Full stop. Next para, we find that since the marriage between the parties has been irretrievably broken down, since both parties seek divorce, although on different grounds, the matter is fit for mediation, in order to resolve the dispute regarding allegations and counter allegations between the parties, as well as the quantum of permanent alimony, if any. Hence, the file be sent to the Calcutta High Court Mediation Committee for the purpose of settlement of the disputes between the parties by mediation. Liberty is granted to the appellants, to the parties to mention for inclusion in the list in the event mediation fails. Affidavit of service filed.
In meantime, injunction.
There shall be injunction as a Can 1 of 2025 is allowed, thereby restraining the respondent husband from contracting remarriage during pendency of the appeal.
Also, it would be punitive for me because what they wanted, they have already got the divorce. Both parties wanted divorce. Counterclaim partially allowed. The wife also wanted that. If I can't remarry, that is the point. To giving the endorsement by the court to enhance.
But yes, you also want a divorce degree, right?
Yes, madam.
So you have preferred a challenge against that.
Don't give me 20 lakhs. I will not
Yes,
give you.
let him remarry. What is the difficulty?
What is the difficulty? You don't want to be with me.
Precisely. What is the difficulty?
But if he the remarriage, then he will not pay.
The amount.
Amount.
Hey, injunction jeta iye korlam ota puro kete daw. Injunction no injunction.
I have stopped him from remarry. Don't do that because the copy has been served. Deeply obliged, Lordship.
I leave it to mention.
Item number 28.
That I am looking for the appellate petitioner. Last question, Your Lordship, regarding the visitation of the child regarding
Previously,
I am for the respondent.
You are appearing for this. Good.
Last question, Lordship, granted us so that we both consider the place and the time of the
the Delhi. You work in Delhi.
His allegation is that, Your Lordship. I as opposed.
You say now, no, you're here.
No, actually,
you went for your work there, but primarily you stayed.
Yes. For at present, work from home, Your Lordship. Sometimes, as office calls, I have to go there. Regarding the visitation, Your Lordship told us to consider both the.
Yes. If there is a count, have you agreed to anything?
Yes, well, Lordship. My client said that it should be Sunday, my lord, instead of Saturday.
The child is how old?
12 years. In class 7, she is studying, Your Lordship.
She is studying in class 12.
Yes, sir. Class 7. 12
Sorry, class 7. Class 7.
12 years.
So, Sunday suits you?
Sunday from 4 to 6, Your Lordship, there is a open public space beside Kachapar railway station. A park is there, Your Lordship. There it can take place, Your Lordship. Yes, my client also proposed another cafe, but I agree with this.
Cafe better park than
Okay,
cafe.
okay, my lord.
What is the name of there has to be a name?
Ganesh Park.
Ganesh Park.
Ganesh Park. Just beside platform number 1 of Kachapar.
Every Sunday 4 to 6.
During this period, mother may be allowed to take her to shop for gifts and
You'll take the child from there and
he can bring the gifts there also, your lordship, because previously also lordship you directed.
I'm just
there.
praying for only for these 2 hours, nothing else. I will hand over the child.
but you cannot stay there, lingering there, I mean, creating disturbance. You have to give the child to the father. Father will return to you.
And let him, your lordship, before coming, at least 1 or 2 days, let him inform me, because accordingly this the tuitions are there. I will arrange, your lordship.
I will.
But we are making it. We are fixing the hours.
Means on whether he will attend on every Sundays or not, because he has also work, your lordship. For that,
If he doesn't come, he'll inform you.
Yes, your lordship.
No, ওরা agree করে গেছে 4 to 6. 3 to 5 কেন? Good sense has prevailed, and the parties have agreed to the visitation hours and venue. Full stop. Accordingly, as per convenience of the parties, we direct the respondent mother to produce the minor daughter of the parties for the purpose of visitation by the appellant father at Ganesh Park within single inverted near the Kachrapara railway station every Sunday between 4 and 6 p.m. Full stop. At 4 p.m., the child will be handed over by the mother to the appellant father. Full stop. The appellant father shall spend time with the child, during which the mother shall not intervene in any manner. Full stop. Next para. The appellant father may, for the purpose of visitation, take the child to nearby places in the vicinity of the park within a radius of 1 kilometer. Full stop. Next para. However, sharp at 6 p.m., the appellant father shall return the child to the respondent mother on each and every occasion of such visitation. Full stop. Next para. In the event the appellant father cannot, for some purpose, visit the child as per the scheduled hours, the appellant father shall inform at least 24 hours in advance about such inability to the respondent mother in order to organize the schedule of the child's studies and extracurricular activities accordingly. Full stop. Next para. In the event both parties agree, the visitation may occur instead of Sunday, on some other pre-scheduled date, strictly in accordance with the consensus of the parties on any of such occasions of visitation. If by any chance on any Sunday he cannot visit, unless both of you agree, it cannot happen. It has to be, can be some other day.
May I prefer one instance? Liberty
Yes.
may be given just as your lordship given the liberty to the husband also.
Yes.
To inform to the wife also.
No, the moment you do it, you will say
No, my lord. Your lordship can limit. Means only on one occasion, not 2 consecutive days. Only not on 2 consecutive days, your lordship. Only one can give him.
If there is any serious exigency for which the child cannot be produced, the mother will similarly inform the appellant father about the same. Full stop. However, the last above rider shall not be abused by the mother for avoiding the direction of visitation.
Well, last 2 occasions.
Maybe something, the child may be ill, the mother may be sick. Don't get sick on every occasion.
No.
Once or twice, it's all right.
Good. Well, Can 2 is disposed of.
This was Can 2. Can 2 is accordingly disposed of in the light of the above observation. This arrangement shall continue till disposal of the appeal. Full stop. Liberty to the parties to mention in the event there is some difficulty in such visitation. Sorry. Regarding the paper books and all, the directions have been given.
No, I think
so. We're passing those directions also. Very well. In view of the appearance of the parties, in view of the appearance of the parties, Service of notice of appeal on the respondent is dispensed with. Full stop. The appellant, the trial court record shall be brought by special messenger to be deposited within a week, costs of which shall be deposited by the appellant within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival on the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Thank you. Next. Not today.
Lordship.
You are for the respondent?
I'm for the respondent contemner, Lordship. Lordship.
Oh. Did you direct personal service?
No, it is dispensed with. Things
Lordship,
are this matter is being adjourned for the second time.
Oh.
It's a contempt petition. It's a contempt petition.
No, but every time. Yes, contempt of sword is hanging over their head, Mr.
Lordship, and now they are taking the.
Tomorrow we'll do it.
Tomorrow, I believe, is the original side day.
Tomorrow, from 2 p.m. we take up this.
Lordship, let the matter be fixed in that case. Lordship, I'm being harassed.
We understand.
They are taking this queue of this contempt petition before the lower
court. Disposed of today, so this is already appearing quite up, and it has become 29, so it's going up only.
Yes. Okay.
We'll give them a last chance. This is the last chance. Yes. We'll make it clear in our order.
Okay.
An adjournment is sought on behalf of the appellant, Fullstop Learned Counsel, on behalf of the petitioner in the contempt application. Fullstop Learned Counsel for the respondent / alleged contemner submits that the alleged contemner is being unnecessarily harassed since this is the second such occasion when the petitioner is seeking adjournment. Fullstop. Appreciating the difficulties of the alleged contemner, we grant a last chance to the petitioner to move the contempt application. Fullstop. It is made clear that if the petitioner remains unrepresented and or seeks adjournment on the next occasion when the contempt application is called on for hearing, ex parte orders may be passed in the absence of the petitioner. The matter is adjourned for the day.
Item number 30 and 31 related matters, my lord.
Yes.
The matter is
31
appearing in the list on my instance. I have filed similar application. 30-31. Sir, একটু বলে নি স্যার 30-31.
তুমি 31 এর appellant?
31. I'm the appellant in 31 and my petitioner respondent in 30. I have filed one application with a similar prayer in both the appeals, and that's why the matter is appearing before your lordship.
You have both appeals challenge same order?
No. The related matter, my lord.
Order. 30 become then 30 become infractuous. 31 become.
What is the context?
May I submit or my lord? 30 he is the appellant. So if your lordship allows me to 31, I am the appellant. If my lord allows me to submit, my lord, in that event I can explain the fact, my lord, what happened. My lord, if your lordship allows me, subject.
You submit, then we'll decide whether to hear 30.
My lord.
Yes.
My lord, the 3 mining plots were allotted to the petitioner.
Yes.
In a one particular.
Appellant is the same in both the matters.
Appellant is no. There is state appeal. 30 is the state appeal.
Oh, right.
31 is the appeal.
How can you say?
Yes. 3 mining plots were allotted to the petitioner. Number.
You are not the writ petitioner. You are for the writ petitioner.
I am writ petitioner in both the matters.
So your petition was dismissed.
In one matter, my lord, the petition was allowed in my favor. The state preferred an appeal. This is the first one. And second one, the learned single judge, my lord, declined to pass an interim order, and there is some observation which ultimately affect the final relief. That's why the second matter, the appeal has been preferred by me.
No, we don't understand. The first
one matter went in my favor.
Petition itself was allowed in your favor.
In my favor, the state preferred an appeal.
The same writ petition.
No. In the another matter,
So then it's a different matter.
No, my lord, the issues are correlated to each other, my lord. Let me explain, my lord. I will not take more than 5 minutes of it. Three mining plots were allotted in my favor. MCHB 2, 3, and 4. Now, my lord, after went there, I found that no mineral reserve is there. So, my lord, whatever they have, my lord, auctioned, whatever they have offered to me by an auction, my lord, I found it is incorrect. So, no mineral reserve was there. I made a complaint.
Mrs. HON'BLE
Abasan.
So you deal with mines?
It's a mining company. Sand mining company.
Achha.
My lord, I went
For
there.
their own project.
And I found that, my lord, there was no sand, no mineral reserve was there. I made complaint in respect of 3 plots. Now, your lordship, the inspection held. In the inspection, it was found, yes, my complaint was correct. So, my lord, I paid for, my lord, substitution of the plot by giving an alternative plot which is potential for sand mining. In the identical report came in 3 plots. Say no sand is there, the plots are
the provision in the contract that you can do that? No.
My lord, no, not expressly.
Very then.
And then, my lord, in respect of one plot, they have shifted to a plot, my lord, which is in the same district, which is my potential for sand mining. That is MCHB 2. My lord, what happened, my lord, in respect of MCHB 3 and 4, I came up before this honorable court and said that in the identical situation, one plot has been substituted. So other 2 plots will be shifted to a plot potential for sand mining. Those 2 kept pending. I came up before this honorable court. This honorable court said to decide my representation. The representation was negatively decided. No, I cannot give you the plot. Then I again came challenging that order. This honorable court said
that was regarding MPM for both
3 and 4. 2 was shifted.
No. This representation consideration was regarding MPM.
In respect of 3 and 4, since 2 has been shifted.
The negative came up again.
This honorable court said that yes, when an identical situation, one plot has been shifted, other 2 you have to. But that against that order, they preferred an appeal. In the appeal, that what has been found that MCHB 2, which was earlier shifted, that order has been recalled.
How?
That has been recalled. That was not informed to me. No hearing was given.
They have recalled because you are seeking parity on that.
That we cannot blame also state fairly submitting, but that was done prior.
Even prior. So
but
then the premise of your order was bad.
The thing is, the state, when the state appeared in the writ application, a report was shot for by the land single judge. In the report, nothing was stated. And I was also unaware of wherefrom I found it when a district survey report was published.
But if that was there, then your premise, the premise.
But why I have filed this application? Why I have filed this
don't
application?
Have a right in
I am not on that, my lord, right now. Now I am not on that. I filed an application that, my lord, what I said, my lord, the plot was shifted to other place. So I handed over the previous plot. The previous plot originally allotted to me.
Then it was
let that be given to me, because now
the previous plot.
Because
it does not have sand.
No, my lord, because in 2018 these things were going on.
Now
in 2025, some replenishment has been done. What I have informed that I am pleaded in my application. In that point of time, the report was there.
Replenishment by whom?
Replenishment, natural replenishment by the course of the river has changed.
Within 7 years.
It happens, my lord. Because the thing is,
you must have found gold there now.
At that point of time,
sand.
Sand was there. What happened, my lord?
Not sufficient.
No, the plot was submerged under the water. The water was flowing on the sand bed.
Now it has moved.
Now, my lord, heavy rain was there at that point of time. The course of the river has changed a bit. And that's why, my lord, now the sand is visible. I can do my mining work there.
So the present writ petition was for that allocation of
not for present.
In this appeal, you were asking for that.
The application I have filed.
Or that interim application.
Interim, or my lord, if that prayer is granted, my lord, in that event, the appeal can be disposed of. If the agreeable to consider my representation on that prayer.
Their challenges against
the 3 and 4 has been shifted.
3 and 4 has directed to be shifted. Their case is that that order, which was the premise of this, has been recalled. Therefore, you was not entered.
Against that recalling, I have filed another writ application.
Suppose we allow their appeal, because apparently they have a good case there, because if that has been recalled, you don't have a case here.
I have preferred
parity cannot be claimed.
No, against that recalling order, I prefer a writ application. That writ application is my appeal. The learned single judge in that appeal said, my lord, that declined to pass an interim order, saying that it is a contractual violation. So, my lord,
I agree with that.
My lord, now, so at best, my remedy is by way of compensation and damages.
Absolutely. Who passed the order, right?
What I am saying at that point of time, without going to that complications, my lord, if my country, in 2018, 19, 20, it was substitution order. I was not holding. Now, on a sudden one fine morning, I found in the district survey report, it has been recorded that it has been cancelled. No hearing, nothing.
Order, the writ petition, your challenge, that appeal, in that writ petition, actually, you want the relief that the original plot may be returned to you.
No, that cancellation order was challenged. That the endorsement regarding cancellation.
The recall order itself was challenged.
That was not an order even. The order was not supplied to me. I found it in the district survey report in the last column. It has
been recalled. I mean,
what I am now, I am not praying for that even. I made a representation to them, my lord, seeking that my original plot may be returned to me, because I have given the entire bid amount to them.
It is beyond the writ petition even. That is beyond your writ petition, because in your writ petition you want that recall to be cancelled, which would be contrary to now what you're paying. Because if that recall is cancelled, then you get the plot.
If the recall is, the moment it has
Your
been
writ
recalled,
petition seeks setting aside of the recall order.
then I have to come from.
If you win the writ petition, then the present allotment in the second plot remains in the alternative plot. That is exactly contrary to what you are now asking. You are asking for the old plot to be returned to you. So we cannot grant mutually contradictory ad interim reliefs in a writ petition.
If in the moment it is upheld that yes, the cancellation order is good in law, that cancellation.
Don't interfere with the ad interim refusal. We can say this much.
I am only praying
because it's we are agreeable with the learned.
Can you visualize the situation? I handed over the plot to them. Sudden,
yes, undoubtedly, either you have to get the previous one or the
yes, my lord. Well, but the previous one, my lord, I get the entire bid amount. I was allotted a plot.
Understood.
The plot was surrendered by me.
So we allow their appeal regarding the other M3 and M4 because parity ground is now gone.
But if that is,
and we can direct them in this appeal also to
consider my
direct them to return your original plot. We can do that.
Not bid amount, the plot. To return the plot, he is saying that bid amount, return of the bid plot. Because the moment
get them on that.
Because the moment, my lord, I surrendered the plot on the basis
they cannot have it both ways.
Yes, man. It will
cannot have it both ways.
Yes, man.
This plot will also go because you have already been allocated a different
plot. And in respect of 3 and 4, also this honorable court, my lord, directed to my lord plot citing 2. So, my lord, in that event
but
also
3 and 4, you have already been allocated a plot.
No, 3 and 4, the plot is original plot is with me, my lord. There no sand was there. I didn't.
No, not an alternative plot. The original plots are there.
Yeah, but
so you retain those.
But
the
5 years has been
allowed,
lapsed,
you retain those.
They will say that 5 years has been lapsed. The matter was pending before them for 4 years. They didn't decide my
cannot
application.
rewrite the contract. How can you
rewrite the contract? There is a division bench judgment of this honorable right now, not with me. My lord, the commencement of the lease, my lord, the date of commencement of the lease is the date of giving possession.
Shows the contract.
My lord, that is in the contract. It has been written, my lord, that date of registration of the lease. But this honorable court, my lord, time and again, my lord, division bench, they decided on a single bench and time and again deciding upon
maybe on the facts of that case.
My lord, that is exactly that because usually it takes 2-3 years to, my lord, allocate the plot, to make the pillar, to fencing the plot, and to hand over. The 5 years lease, 2 years lease.
As we say, we cannot rewrite the contract because those cannot be.
May I cite that judgment tomorrow if you have to
that cannot be a precedent for a different factual.
Relying upon a division bench.
Any precedent is a precedent. Any judgment is a precedent for the facts of that case.
My lord, in that event also there was a delay in giving possession. Here, my lord, also the
let us see the terms of the contract. It depends on
the terms of the contract will go in.
We cannot rewrite the contract, even if a coordinate bench has done. That cannot operate as
the
a
alternative plot was given after 4 years. In that event also, it should commence for 5 years. It should continue for another 5 years. But they in the 18, the original registration was done. They gave the alternative plot in 2 years. After 2 years or 3 years, my lord, I can show to your lordship.
You come prepared with all your judgments. We'll hear the appeal along with this application. Application, there is no scope of any interim order.
Interim order, I'm not asking for. My lord. What I'm
so we'll direct appeal. Both the appeals will fix for hearing on these papers only. All the papers are here, more or less.
Only one thing, the writ petition, what they have managed is the incomplete one. My lord, that entire writ petition.
So you bring the complete writ petition,
and another thing, my lord, our writ petition. It is another writ petition which has been decided in my favor after perusal of the report filed by them.
You do this. You prepare a composite paperwork for both the appeals.
And then you can take it next week, my lord.
Can you do it within a week, or should you keep it the week after?
In Friday, next Friday.
Friday we sit singly. We'll put it then.
No, Monday week, my lord.
Monday week then. Monday week we'll circulate advance copies of the paper. Since these two appeals
Monday week
arise out of similar contracts, the appellant in your appeal is which one? MAT
31. Only one.
MAT 2249.
Section
MAT
application is there. Let it be, my lord, condemned.
1741 is their appeal, and my lord, my appeal 2249 is my appeal.
The appellant in MAT 2249 of 2024.
Yes.
2024 shall prepare composite informal paper books incorporating all the relevant papers and circulate advance copies of the same to the learned advocates appearing for the other parties in both the matters. Condonation in which one? Your appeal. What is the delay? What is the delay?
Can one.
What is the delay?
How much? 103 days.
Why?
Due to my lord to
Cannot be red tapeism, green tapeism.
departmentally
Green tapeism.
procedure. Knows by lord departmental.
That is can one.
Can one of
Very well. যেটা বললাম
Item
সেটা
number
হবে তার আগে অ্যাড করে দাও।
can one of item number 30.
Upon hearing learned counsel for the parties, we find sufficient reason for the delay in preferring MAT 1741 of 2024. Accordingly, can 1 of 2024 is allowed, condoning the delay in preferring the said appeal without any orders to cost. তারপরে যেটা বলবো।
In this matters, madam, late by Mr. Soumya Mujumdar.
He is in court.
And in 31, when I appear for this case, it should put in court.
You give the item numbers and whoever is appearing in court, yes. Give the names of everybody appearing for the state, but he or she must be in court. Legs or doing handstand, we don't. He has to be in the court precincts. Sorry, the appeal shall be listed for hearing next on December. No, December 1. It will be the combined list then. We'll keep it on 2nd December. On December 2, 2025.
Instead of second, can it be the 9th? That is the subject to lordship.
I have no difficulty. We have no difficulty. Second and 9th. December 9, 2025.
Not
কালকে 3:30 স্পেশাল তিনটে
এই এটা ফার্স্ট এরটা রেসপন্ডেন্ট নাম্বার 1 সেকেন্ড এরটা
কালকে থাকবে
Your Lordship, Mrs. Munmun Tiwari is appearing for state, Your Lordship. She is not available today at court, Your Lordship, as she went to hospital for her son. Her son had stomach infection. She is in ILS hospital.
Yes.
Praying for not today, Your Lordship.
Strongly opposed, but
No.
on the prayer of the appellant, the matter is adjourned for
Not today, Your Lordship.
for the day.
Gratefully, Your Lordship.
But please don't give her name.
Of course not. Of course not.
Yes. Next. Give your appearance.
Yes. I am not in state, Your Lordship.
What is your full name?
Rahul Kumar Saha.
The appearance of Mr. Rahul Kumar Saha for the state for the purpose of today's appearance be regularized by the state. Given name. It will be regularized.
I'm not in state panel, Your Lordship.
We can direct the state to regularize your appointment for this matter for today, even if you're not on the state panel. Give your name.
Item number 33 to 35.
Yes. You are for the appellant?
Yes, my lord. I am my lord.
No, nobody is appearing for the respondent.
I'm not seeing.
They've played away after seeing you appear. Some section 5 is still pending.
Yes, my lord.
Have you served? Did you direct it to serve copy? No, for the first time.
I am not direct. I am served the
So should we direct you to serve copy of the application first?
only first. I direct. I served the copy,
You have served.
but not section 5. 2 days delay.
We'll direct you to serve copies of all the applications, both the applications on the respondent.
Oh, other two are not delayed. There is no delay. my lord.
No, we are taking. Oh, acha, there are 3 appeals.
3 appeal.
Oh, acha.
Only one. First one.
So these are connected.
Connected.
Then the condonation application should be decided first. Then we shall take up 3 together. The appellant shall serve copies of Can 1 of 2025 in MAT 1326. No. Can 2 of 2025 in MAT 1326 of 2025 on the respondents, indicating that the matters shall next be listed together on November on December 2, 2025, when an affidavit of service shall be filed by the applicant.
Within November, your lordship kindly consider this.
Is that time you can serve within that period? Today we are on 18th.
Yes.
November 25 করে। Returnable next Tuesday. November 25, you file your affidavit of service on that. Next. তিনটি একসঙ্গে আসবে।
এটা oh.
My lord, I am for the petitioner, my lord, led by Mr. Bikash Ranjan Bachchan, my lord. Yes, this is my lord. Share of compensation was not given due to acquisition of land, my lord, for railway line, my lord.
Not given at all.
My lord, my share was not given.
Not given. So you.
But the brother's share has been given.
So you filed a writ petition for that.
Yes, my lord.
Refused on what ground?
Refuse means?
Bolo.
Refuse, my lord. Case is.
Railway is the answering respond in this matter.
Railway. You have served a notice on the railway?
Yes, ma'am.
My learned sister.
Appearing on behalf of the Union of India, led by Mr. Brajesh Kumar Jha. He's not in court right now, lordship.
Not in?
Not in court right now, lordship.
Why?
Lordship, could not able to take the instruction why he's not here. But I tried to contact with him, but no answering.
Affidavit of service filed today be kept on record on the prayer of the railways. Let the matter stand adjourned for the day. Come back tomorrow. Come back tomorrow. Rail is the main answering respondent.
Yes, my lord. Correct, my lord. But
You have granted adjournment to them.
You do it to get my senior. Larnet senior is always not available. This is that today.
Oh, also is not available.
He is also led by Mr.
Yes, my lord. Not today, my lord.
No, even if he is not Faka, we'll take up tomorrow. You will have to do the matter. Today also he is not Faka, so what? Yes. Don't give his name today.
No, my lord. No, never. Never can.
Yes. Same applies to you also, ma'am. Just your name.
Yes, sir.
Yes. 37, you are for the apple day.
Well, may I file the lord affidavit of service?
There was a direction for service.
No, we have served.
Pursuant to a direction of court. Otherwise, this is not good service. You have to serve.
We generally
yes,
serve.
mandamus, you are right.
We generally serve.
No, we'll in any event we will consider grant of ad interim injunction. So what is the matter about?
Well, it is my lord declaration of wetland, the land of the petitioner, my lord, which was recorded in CS record of right as well as Sali agricultural Danga. In the RS record of rights also same thing. In the LR record of rights same thing. But in the year 2006 the land has been declared as wetland. My lord, I have challenged the decision, but the making of the decision I have challenged in the writ petition. How a high land can be declared as a wetland.
How did the learned single judge proceed?
My lord, may I place the judgment? My lord, in the memo
generally the other way around. The wetlands are converted.
That is section 10 is there. Section 10 is there.
Generally it's the other way around. So activists are very high on this.
My lord, impugned order is at page 414 of the injunction application.
You can refer to the internal pages of the impugned order so that it will be easier.
My lord,
yes.
Internal page from 2.
Yes. Your submissions.
My submission. May I read or your lordship?
Yes, you can. You can read from page 3, para 8.
My lord. It is submitted by Mr. Chakravarti that in the schedule of the said act, the purchase property as mentioned here has been included wrongly, since the said lands purchased by the writ petitioner by no stretch of imagination can be considered as a wetland or water body. It is submitted that despite submission of representation by the writ petitioner, the respondent authorities did nothing and practically sat tight over the matter. It is thus submitted by Mr. Chakravarti that it is a fit case for granting the reliefs as paid for by the writ petitioner. Par contra, Mr. Mittal, learned advocate, duly assisted by Kolpita Pal, learned advocate, appearing in behalf of the respondent authorities, draws attention of this court to the report as filed in connection with the WPA number such and such. It is submitted by Mr. Vito that he is relying the said report in connection with the instant writ petition being WPA number such and such. In course of his submission, Mr. Vito draws attention of this court to various pages of the instant report More specifically, from page number 9 to 13, it is submitted by Mr. that from the report as submitted before this court, the following would reveal. In the year 1992, in the case of people united in better living, Kolkata Public and another versus the state of West Bengal and others, the Honorable Court passed the following direction. There shall be an order of injunction restraining the state respondents from reclaiming any further wetland. There shall also be an order of injunction prohibiting the respondents from granting any permission to any person whatsoever for the purpose of changing the use of the land from agricultural to residential or commercial in the area as indicated in the map annexed to the petition and marked with letter C. The state respondents are further directed to maintain the nature and character of the wetlands in their present form and to stop all encroachment of the wetland area as indicated in the map annexed to the petition and marked with letter C. The state respondents are further directed to take steps so as to stop private alienation and if required by extending the statutory provisions in regard thereto. In the Ramsar Convention, wherein India is a signatory and intergovernment treaty on global environment as executed, pursuant to the said treaty and the above mentioned judgment in the case of public, the government of West Bengal constituted a high-level management committee headed by the Chief Secretary of the government of West Bengal, which was entrusted for demarcation of the limits of East Kolkata wetland, preparation of maintenance of a map and a land schedule showing the boundaries of the wetland area.
So what about this act the court is speaking about? The on such and such date, the government of West Bengal enacted the said act.
This is the act of
Kolkata Wetlands.
Kolkata Wetland Conservation and Management
So
Act.
if your plot falls within Schedule 1.
My lord.
So then how can we, unless the virus of the act is challenged, how can
No, my lord, so far my land is concerned, my lord, I have challenged because, my lord, I will rely
statutorily it has been made a wetland?
But I will rely upon the judgment of the Honorable Supreme Court in Tata Cellular. Well, I am not challenging the policy adopted by the government, but the making of that policy.
No, but the schedule of the act itself says that this is a substantially water-body oriented area which comes within, even if it's marked as Danga, but it's substantially water-body oriented area. So the state has the legislative power to bring it.
That is, my lord, that policy is, my lord, wrong, because, my lord, if, my lord,
state policy report cannot interfere.
My lord, in that event, my lord, my humble submission before lordship, my lord, kindly, my lord, I will rely upon the judgment of the Tata Cellular that how, my lord, the government can make the policy. My lord, if wrong, my lord, method has been adopted, because, my lord, in that event, all the agricultural land should be treated as wetland. My lord, kindly appreciate, my lord.
No, only under these measures. So you have not challenged the virus of the act.
My lord,
this is not a matter of policy, Mr. Chakraborty. If it was only policy, we could have still understood. This is not a policy only. The policy has been crystallized into a statute. It's a statute now. So you have to challenge the virus of the legislature. We'll give you that liberty.
But otherwise, I have challenged, my lord, that by way of the writ petition, the challenge of the virus. So far, my land is concerned.
Your land. So
because, my lord, I cannot.
You have to challenge the virus, and we have to. Virus is tested, on different grounds. I mean, there are certain grounds. Virus challenge to a virus is on a much higher footing than executive action.
My lord.
That very
my
much.
Lord.
You are sufficiently experienced.
My lord.
So we have to see double proportionality. Those tests in the electoral bond case also, those tests were propounded. Double proportionality where two fundamental rights are in conflict, which should be given precedence. So the tests are different. But your writ petition is only on your land being demarcated. So court is, learned single judge is correct. We'll affirm this order, but give you liberty to challenge the virus. We'll say that because this order is absolutely justified. The court has, in fact, categorized what have been given, and your plot falls.
It is only on the basis of the reasonable expectation, but I am not only.
Reasonable expectation cannot be a good defense against statute. Not against statute.
I did not challenge the.
Not even reasonable expectation, Mr. Chakraborty. You have a higher ground that your land was already being marked as a danga or some other category.
Agricultural. And not only that, my lord, the government, my lord, authority, my lord, recorded my name. My lord, collected tax on commercial basis.
That was the position prior to the enactment of this act, which changed the entire scenario with retrospective effect from 2020.
And not only that, my lord, section 10 of this act also, my lord, statute also says that the conversion can be made, just like 4C of the Land Reforms Act.
Conversion can be made.
Conversion means that, man, I prayed for that. I prayed for that. Lordship, can you have a look, my lord, section 10? But I prayed that for conversion.
Let us see your prayer in the writ petition.
Writ petition ta kothay ache?
Eta thakbe.
29, 293.
330.
This is an entirely different thing. You are saying that the classification as a water body is wrong. That is something else. To pray for conversion, you have to admit that it's a water body. And then only, because this says any person holding a land in East Kolkata Westlands may apply in such manner to the authority for change of character or mode of use of the land. Therefore, to have this, you must admit the mode of user to be water body.
Well,
but your writ petition is categorically contradictory to that. You are saying it's not a water body. It was wrongly classified as a water body.
My lord.
So that is contrary to what you are submitting. If you want to, then you have to admit that it is a water body and then seek conversion. Apply for
Not
conversion.
only my lord, agricultural land can also be converted, my lord. Because wetland includes, my lord, the agricultural land and other my lord.
You applied for conversion. You are not.
Well, I have represented. That has not been considered.
What was the representation?
I have represented, my lord.
Just give us the page number of the representation.
Representation. My lord, part 2, my lord.
Yes.
Page 274 onwards.
270 something is part 1.
270, part 2, my lord.
270.
274.
274. Up to 292 is in part 1 in our copy.
Part 2, volume 2.
Volume 2.
My lord, volume 2, pages 151 to 292. My copy is, my lord.
Which page are you relying on? Tell us.
274 starts, my lord. Is a, my lord,
yes, volume 2, right.
Long representation.
274. You are relying on 274.
No, I'm not only preparing relief portion, my lord.
So was the representation?
282. To allow my client to firstly, my lord, to cost whatever, but to allow my client to convert its purchased property to the status of industry commercial after fulfilling all formalities there. Very innocuous, my lord, because
you apply in a proper format. This is alternative. It cannot be treated to be an application for conversion. You are seeking quashing and in the same breath conversion.
But until, my lord,
contradictory.
Until, my lord, my land has been included in the, my lord, under the category of wetland by the statute, my lord,
but
by
in
notification.
The petition itself, you have challenged the prayer. See the prayer of the writ petition. You have challenged the conversion, the classification as a wetland.
293.
Where is the prayer of the writ petition?
293 থেকে শুরু হচ্ছে।
Where is the prayer of the writ petition?
Prayer of the writ petition are 326. 327, my lord, starts. Prayer C, my lord, I have stated that to allow me to, my lord, effect the conversion.
But these are contradictory prayers. One in the one breath you are.
Why, my lord, I have prayed
squashing. If it's squashed, then how can there?
Until, my lord, that has been excluded. But that has already been included. That's why, my lord, I pray for, my lord, recall of that order. Otherwise, my lord,
we'll say that nothing in the impugned order will not interfere, but we'll say nothing in the impugned order will preclude you from applying in proper format for conversion of this land under section 10.
My authority will consider. Lordship, kindly direct the authority is considered.
The present challenge has been preferred against an order passed by the learned single judge, whereby the petitioner's writ petition was dismissed. Full stop. The primary prayer in the writ petition was a challenge thrown to the classification of the petitioner's land, comma, which according to the petitioner was all along being recorded as agricultural land or danga, comma, was all on a sudden, comma, in the year 2006, comma, shown in the records as wetland. Full stop. Challenging the same, comma, a representation was given, comma, with an alternative prayer for conversion of the land from a wetland. Full stop. Next para. In the writ petition also, the primary relief sought was that was a challenge thrown to the Gazette notification dated March 31, 2006, whereby the petitioner's plot, comma, along with others, comma, was shown as a wetland. Full stop. Next para, the learned single judge proceeded on the premise that in view of the enactment of the East Kolkata Wetlands within bracket Conservation and Management bracket close Act, 2006, the petitioner's land was incorporated in Schedule Roman I thereof. Full stop. As such, it was observed that the challenge of the petitioner to the concerned notification was bad in law. Full stop. Learned counsel during arguments before us, submits that the petitioner would be content at least if the alternative prayer in the representation of the petitioner and the writ petition to the effect that the land may be converted from a wetland for commercial purposes is allowed, the petitioner, the appellant would not have any grievance. For the next para, on a careful perusal of the order, we find that the plinth of the prayer was a challenge being thrown to the concerned notification whereby the petitioner's land was classified as a wetland. Full stop. We agree with the observations of the learned single judge to the effect that in view of the enactment of the 2006 Act, the petitioner's plot was statutorily incorporated under the category of wetlands. Full stop. Nothing less than a challenge to the virus of the said statute or to the policy in principle, would entail the petitioner to have the said land classified as agricultural land. Full stop. Next para. Thus, we do not find any scope of interference. Full stop. However, it is made clear that nothing in the order impugned before us shall preclude the petitioner from applying in appropriate format for conversion of the land within the contemplation of Section 10 of the East Kolkata Wetlands within bracket Conservation and Management bracket close Act, 2006. Full stop. If such an application for conversion is filed, the concerned authorities shall consider the same as expeditiously as possible and decide on the same, if necessary, by giving an opportunity of hearing to the petitioner at the earliest, preferably within 1 month from the date of such application. No rest to cost, urgent certificate. And the FMA 1450 of 2025 is disposed of along with Can 1 of 2025 without interfering with the impugned order, but in the light of the above observations, no rest to cost.
May affidavit of service will not have.
Affidavit of service filed to be kept on record. Thank you. Thank you.
But I appear for the state in this matter, my lord. Before my learned senior friend, my lord, starts, I just want a few things. My lord, first is, my lord, the annexure markings, my lord, are not matching. My lord, so, my lord, can it be, my lord, resupplied? My lord, kindly, for example, kindly takes, my lord, paste the barcode. Barcode, paste the barcode. Kindly, 96 na, kindly, my lord, sees, just for by way of an example, kindly takes paragraph 23 of the stay application, page 16, versus, my lord, page 96. Kindly sees, my lord, para 23 of page 16 of the stay application.
Page 96.
Yes, P. My lord, P. And my lord, the description thereof at para 23.
Copy of the memorandum, 71.
My lord, this is, my lord, 17.123. At
yes, this tells.
My lord, this memo number is, my lord, KGP. 15 CFC something else, and my lord, this document is NIT number 1415.
In our copy itself, memo number 71. Rahul Mullah, date 17/1.
In the paragraph,
paragraph was the same.
But then the other collectively,
memo number KGP
is not here in page 96.
That by way of a memo number, the said tender was awarded to Lajan. By way of a memo being 71, the subject tender was awarded to Rahul.
Collectively, the other memo, my lord, is of January 31, my lord. That is not.
So both memos are supposed to be there.
Yes, yes.
So in the previous page, it's not there. Yes, the previous page KGP is there.
Previous page is okay. Well, that is not marked properly though. And my lord, the index was also not supplied in our copy. We have not been graced with that.
Index, do we have an index?
Index.
You also don't have
Even
an
in the writ petition, my lord, the index is not there. Any event,
No, this is an appeal.
my lord. This is my lord a order.
Here no index is necessary, and we don't have an index either.
Very well, my lord. The
Banerjee
other
will
matter is
act as the index.
my lord. My lord. The other, my lord.
Let us hear the appeal.
My lord,
Forget this.
My lord, some instructions are also awaited, my
Say
lord.
that should have been the first submission.
My lord, but then, my lord,
since this is the second submission, we won't permit you. We'll hear it.
and my lord, the my lord, writ petition itself is not maintainable, my lord. At the instance of a non-participant in the tender process, he has challenged the tender.
This is an appeal.
My lord,
let us hear him.
My lord, but my lord, the writ petition itself,
Section
my lord,
5
that
is there.
point
Section
particularly
5.
was not taken up in the writ petition. The other points of maintainability was raised.
No, there is a section 5.
One day did.
No, I'm not on the section 5, my lord.
No, we are on the section 5. What is the section 5? You can't
Section
find
5
it.
of
That's there is no section 5. No section 5.
My lord, there is no section 5 in my.
1 day delay oral prayer we have done. We have allowed one on for 3 days.
Only, my lord, let my learned friend submit, my lord, only on the point of maintainability, because, my lord,
It is not the appeal. How can it be?
my lord, even, my lord, the question of law, my lord, because, my lord,
Appeal is maintainable against a single judge's
my lord,
order.
the writ petition itself was not maintainable.
That's different. That's an argument in the appeal.
Very well,
So we'll have to hear the appeal on
very well, my lord. My lord, kindly, my lord, permits me to reply to him on another day, my lord. My lord, I'm awaiting some instructions, and my lord, junior is not there.
Thanda. On the oral prayer of the learned senior advocate appealing for the appellant, comma, we find sufficient justification on the ground of miscalculation of dates, comma, for the delay in preferring the appeal. Accordingly, such delay of 1 day in preferring the appeal is condoned. Accordingly, MAT 1522 of 2025 is taken on board. So at this juncture, learned counsel appealing for you are appealing for which authority?
State, my lord.
For the state seeks an adjournment for taking instructions. How soon can you come?
Any day, my lord, next week, subject to, my lord, my.
Which day?
Any day.
Accordingly, the matter is adjourned till November 24, 2025, Monday.
I'm extremely grateful, my lord.
Delay part is over. Now we'll hear the appeal.
Yes. In the meantime, let them not deal with the land. 3-4 days are left. There was an interim order in the writ. It got vacated because the writ was dismissed.
Don't do that.
Let them not deal with the land. In the meantime, sometimes it happens.
My lord, subject to, my lord, he is, my lord, challenging. After all, my lord, in the main submission I'll make, my lord, he is challenging a tender process.
If he has not done anything in the meantime, let him not do anything for the next
From today
till Monday.
Very.
Because we are granting you adjournment. So we are doing a favor. We expect a favor in their favor.
My lord, I'll just, my lord, in a brief nutshell, my lord, the land concerned.
We are helping you out. We are granting a stay of operation of the order for this period.
My lord, kindly see, my lord, there is an interdepartmental transfer which
since
has
a prima facie case has been made out for hearing the appeal on merits, comma, and in view of an adjournment being sought by the state, comma, we restrain the respondent authorities from giving effect to the impugned order and or the impugned tender process.
It's an order of dismissal. So, order in terms of prayer A.
No scope of interim order, my lord. This
Prayer A, page
interdepartmental
49.
transfer, my lord, 10 years more
Then
than
you
10
don't
years.
do anything. Don't do anything.
I will not. I will communicate that. So far as, my lord, these few days are concerned, I will not.
প্রথম থেকে করুন an adjournment is না সরি সেকশন 5 টা অ্যালো করেছি ওটা থাকবে যেটা বললাম ওরাল প্রেয়ার ওটা থাকবে on the prayer of learned counsel for the state comma the matter is adjourned till November 24 2025 full however comma learned counsel for the state undertakes that no steps shall be taken in terms of the tender which was impugned. Tender was impugned in the writ.
Yes, my lord. Non-grant of lease and tender, yes.
The tender which was impugned in the writ petition from which the present appeal arises till November 24, 2025. Next.
My lord, once in the earlier matter, I was for the state. I was in courtroom number 24, my lord. I could not come.
Earlier matter means which matter?
36 item number.
You have recorded extensive orders probably.
My lord, kindly.
If the order does not, if the order reflects that you are not there, how can it
This is that railway is the answering. That's why Lordship was pleased to adjourn the
yes.
matter for the day.
Yes.
36 railway is answering.
Din. আপনি স্লিপটা দিন। Next.
My lord, I am appearing for the appellant.
Yes, Ms. Zedahol. What is the matter?
My lord, impugned order is
Before my learned sister starts, my lord, here my learned sister will be relying on a fact that yes, one report was
Your sister-in-law, because she's in law. Yes.
Lord, Lordship, learned sister, she might be relying on a particular ground is that a report has been relied upon before the learned single bench.
Which was not given to her.
No, because
no opportunity has also been given to file
report is
it.
nothing.
Anticipated right.
No, report, no, this ground is there. Report is nothing, but it contains an agreement which was signed by her. So
that was the premise of the single
And
bench order.
on that
her
basis, my
document,
lord,
her
cost has
document,
been imposed upon me.
her document has been suppressed by her in her own petition. That is the ground of suppression. My today, my lord, that I have the extra copies of reports. That is the only thing. That is the only contents of the report. The agreement which is signed between her and the West Bengal. She has suppressed her own document.
They're not state of West Bengal.
I'm state of
So
West
it's your document also.
Yes, it is my
Equally.
document. So, my lord, extra copy of the report is not with me as of today. My lord, Lanet Junior has left the court. My lord, it is the entire custody report of the custody of the report is with her. My lord, kindly, my lord, make it not today, lordship.
Come back tomorrow. The report will be necessary.
Lordship,
we have
lordship.
to see whether that was German. If that was German, then cost might have been justified. Otherwise, not.
Lordship. That is only
Cost আছে তো 25.
tomorrow, my lord, tomorrow, lordship, kindly, lordship.
On the prayer of learned senior government advocate, the matter is adjourned for the day.
Lordship.
Come back to
Grateful to all.
Thank you.
Okay. Number 40.
I am for the appellant. Lord, it is my affidavit of service, my lord. My lord, we have.
What is the challenge against?
Because the writ order passed by Honorable.
Use the microphone, please. We can't hear you.
My lord, it is the order appellate being issued of the order dated 11/9/2025 passed in WPA 2.
No, what was the matter about?
My lord, it is a PW.
Your writ petition has been dismissed.
No, my lord. I am the respondent. An injunction was given over the land adjacent to me where I egress and egress. And the writ petitioner also has a part occupation occupied the said PPWD land.
What was the writ petition? What did the writ petitioner challenge?
My lord, the writ petitioner challenge about the possession.
About the what was the prayer in the writ petition?
My lord, in the said writ petition, prayer is to remove the said shop room.
Illegal encroachment.
Yes, my lord.
There was an allegation that you are illegally
No, my lord. All there was many shop, but
you are one of the shops.
Yes, my lord.
So what has been directed to be removed?
Yes, my lord.
You are in illegal occupation. You are removed. So
no,
what?
My lord, I am not in illegal occupation. I am my
injunction was granted against respondent number 7. You are respondent number 7.
Yes, my lord.
From raising any construction in front of the land of the writ petitioner.
My lord,
only that.
Don't do that. No, my lord. Writ petitioner's land is back of my land.
Don't make the construction. Oh, the writ petition itself has been disposed of.
Yes, my lord.
You are heard by the learned single.
No,
judge.
my lord.
You did not chose not to appear despite
my lord, someone has received by me after the hearing of the writ petition. I have served.
So there is no scope of staying the injunction order now.
Yes, my lord.
That would permit you to make construction.
Yes, my lord.
But you have served on whom? Who has received?
All of them, my lord.
How do you know that you are constructing on the rear?
My lord, I am not making any
You say you are making construction on the rear back portion.
My lord, the back portion is the writ petitioner's portion. And
if the back portion is the writ petitioner's portion, then the front portion you are making construction.
My lord, I have making the.
Your back is petitioner's front.
Yes, my lord.
that has been restrained, that you cannot construct in the front
Milord,
of the.
no construction of house, Milord. Only the wall, boundary wall.
So how's you are building a wall in front of his gate?
No, Milord. My
You
land,
become anarchally sort of thing.
no,
in the
Milord.
movie.
My land, Milord.
Your land injunction has been granted. Why should you interfere with this? Please place paragraph 6 onwards of the impugned order.
Milord, here, on careful consideration of the earlier entire material as placed before this court and after hearing the learned advocate of the contended parties, this court, while disposing the instant writ petition, direct the jurisdictional BLRO to make a field verification in respect of the disputed land. Milord, here the land is disputed. After serving period service of notice upon the writ petitioner and the private respondent number 7, and shall thereafter submit a demarcation report with the respondent number 4 authority within 30 working days from the date of communication of the server copy of this order. The respondent authority, on receipt of such demarcation report from the jurisdictional BLRO, shall cause service upon service of notice upon the writ petitioner and the private respondent number 7, and shall provide them copies of demarcation report as mentioned. The
Injunction has been granted. The authority has been directed to consider and decide the representation within 45 working days from the date of communication.
Yes,
that is yet to expire. During the period till passing of a reasoned order by the authority, you have been injuncted. Don't construct for that period only.
No construction is made, Milord.
Then you are not affected by the injunction.
Milord,
we don't find any illegality.
Milord, here my land and
whatever that will be decided, you will be given a hearing by the BL and LRO. That is the direction. Within 45 working days from the date of communication, from the receipt of demarcation report, jurisdictional BLRO will consider the representation upon giving you hearing and
decide. Notice
till then, don't make any injunction.
Till date, no notice has been served.
Complain to the learned single judge with a contempt application that your order is not being complied. We don't find any.
No, Milord. Here the injunction is affecting the entire area, Milord.
Only for this period till it is decided.
The demarcation process has not been started, and no notice has been given.
That is the
the
domain of the learned single judge.
My house, which was before the writ petitioner, is entirely without boundaries. When I am construction boundaries in my own land, not on the.
So despite service, you chose not to appear before the learned single judge. What can be done?
Milord, the service was not affected to me when it was.
Anyway, there is no illegality in this order. The present challenge has been preferred against an order passed by the learned single judge, whereby on a writ petition preferred by one of the private respondents, complaining of illegal encroachment in front of the writ petitioner's property, the learned single judge dispose of the said writ petition by directing the jurisdictional BL and LRO to obtain a report, a demarcation report. Directed the respondent number 4 stroke authority therein to obtain a demarcation report from the jurisdictional BL and LRO, and thereafter, upon giving opportunity of hearing to the writ petitioner as well as the respondent number 7 therein, within bracket present appellant, bracket closed, and stroke out their authorized representatives, to pass a reasoned order within 45 days from the date of receipt of the demarcation report. Which of next para, till passing of a reasoned order by the respondent number 4 authority, the respondent number 7 in the writ petition, that is the present appellant, was restrained by an order of injunction from raising any construction in front of the land of the writ petitioner, particulars of which had been mentioned in paragraph number 3 of the writ petition. So next para, learned counsel for the appellant submits that the appellant received notice of the writ petition subsequent to the order being passed. For that apart, it is contended that the appellant is not making any construction in front of the writ petitioner's property. Full stop. Next para, as such, it is argued that the injunction order passed against the present appellant was bad in law. Full stop. Furthermore, it is complained by the appellant that no notice of hearing has yet been received in terms of the order of the learned single judge. Full stop. Next para. Insofar as the last allegation is concerned, we find that in the event there is any grievance regarding the order or the timeline of the learned single judge's order not being complied with, it is always open to the appellant to approach the learned single judge with a contempt application or an application for implementation of the said order. Full stop. Insofar as the restraint order regarding raising construction in front of the land of the writ petitioner is concerned, since it is the appellant's own case that the appellant is not making any construction in front of the said property, the injunction cannot affect adversely the appellant in any manner, in any event. Full stop. Next para. Even otherwise, it is absolutely just and proper that during the pendency of the matter before the respondent number 4 authority, it would only be proper that no construction is created in front of the land of the writ petitioner, which would evidently jeopardize the entire exercise of adjudication by the respondent number 4 authority in the writ petition. First of thus, we do not find any illegality in the impugned order.
See page number 19 of the CRAN 1, my lord. Here it is very much clear that the said possession is back of the appellant.
Yes, then you are not, that you have said that you are not
রাস্তার সংলগ্ন পূর্ব পশ্চিমে 17
MAT 1626 of 2025 along with CAN 1 of 2025 are dismissed without an order as to cost. Full stop. However, it is expected that the concerned authority shall act in terms of the learned single judge and decide the matter as expeditiously as possible. Affidavit of service filed to be kept on record. Next. We have said that if you are not making construction on the front, this order does not affect you. Make construction wherever else. No other injunction has been passed. Back, side, left, right, above, make your construction. Only in front, don't make.
I am applying for the writ petitioner.
Probably you have observed that none appears for the state. Have we?
I'm for the writ petitioner, private respondents.
Even then. কিছু করিনি তো অবজার্ভ কিছু করিনি তো যে কেউ অ্যাপিয়ার করছে না very given them.
Grateful.
Thank you.
I am grateful.
Lordship, I am for the petition. Yes, Mr. Paul.
41. Lord, I beg to appear for the state.
Respondent.
My lord, led by Mr. Suman.
You are for the state respondents.
Led by Mr. Suman Sengupta. Please.
Very good. Sir, you are for the private respondent. Yes, Mr. Paul, what is
Lordship, this is not the private respondent. Here, my lord, two writ petitions. There are two writ ones. One filed by me, seeking certain relief.
Both were decided by the same order.
Same order. But one thing, pertinent question. Another thing, Lord, in my writ petition, they made an application for addition of party.
That was rejected.
That was rejected. But against that, no appeal preferred.
Mr. Paul's client made the application for addition.
Yes, I filed a writ petition. Which
Understood. There they made an application for getting added as a party.
That has been rejected. Against that, no appeal preferred.
But they have preferred an appeal against the main order.
We had preferred a main order. And two has been clubbed together. One appeal.
They filed a separate writ petition.
They filed a separate writ petition.
That is,
They filed a separate writ petition. I filed a writ petition.
They filed a different writ petition.
They filed a different writ
That was dismissed.
And both have been tagged together.
Yes, but the order is common.
Order is common, but one appeal.
Your writ petition was dismissed.
No, my writ petition allowed, I say.
And theirs is dismissed.
That is not specifically said, but that has been dismissed. Prayer has been dismissed.
But yes, it dismissed. Otherwise, why would they come up with it?
One appeal.
Let us hear Mr. Pal this.
One appeal, my lord.
Which one you have to choose your? I mean, which one are you challenging? Allowing their writ petition or?
No, Lordship, the order, impugned order, tagged both the matter. So I have challenged that, Lordship. Lordship, page 117. Two WPA 23065 আমাদের তো কোনটা ছিল? And second,
Not a suit, Mr. Rai. Not a suit. We will not be so technical. Single order passed.
Single
Both
order.
were clubbed. What's the difficulty? Yes, what is the on merits? Yes, was it?
Lordship, Lordship is a matter relating to easement right, Lordship.
Sir, you can take your seat. We'll just hear you and call. No seat.
The petitioner using the road since long, Lordship, and they claim that
They means you are a group of villagers.
Lordship, we are a group of villagers. They are using the roads since long, Lordship. And this is the second writ petition filed, Lordship. First writ petition, they have challenged. The Honorable Court directed the district magistrate to consider our representation and pass a reason order, Lordship. The district magistrate has passed an order.
No, what was the relief claimed? Your easement
Lordship,
right is being violated by whom?
By the private respondent here.
By Mr. Rai's client. He claims to be the owner of that property.
Some part of the portion, Lordship, not entire property, but Lordship, the Honorable Single Judge held that the entire property is
the owner of the property or demarcated?
Co-owner.
Then he has right over entire part.
Lordship, they have right, Lordship. It's a land, Lordship. He has proper land, Lordship. But the challenge was thrown to the order of the DM, Lordship. The DM, what DM held, that is the most important, Lordship. Lordship, first thing, Lordship, easement right, my humble submission as per my understanding. So, of course, it should be gone to the civil suit, Lordship.
That was what we were thinking.
Lordship, but both sides, I was
That
not
will be
there.
the first defense.
I was not, Lordship, they have filed also. And Lordship, the writ could entertain that. Twice it could entertain that, Lordship. And thereafter, Lordship, second writ petition challenging the DM order, that also entertained, Lordship. Lordship, kindly turn the first order.
You approach the DM under which provision? Under which provision of
In
law?
terms of High Court order. Earlier order, Lordship, page 110. First order, Lordship, which gives liberty to approach before the DM. 107, Lordship, at combination 110. 107, Lordship. They have filed this writ petition, Lordship. Private.
So there must have been some allegation of encroachment or something like that. Let us just see that. It was their application. So
Lordship, they are.
Lordship, I'm sorry to trouble him.
Then don't disturb.
No, not. I will not. He started with a word which is contrary to the word. My Lord is going on this way that he prayed for easement right. Kindly look to his prayer.
No, you'll get your
Where
chance.
said that he is praying for easement prayer or for which civil suit lies. It is not his prayer above.
Let him make a wrong submission. You are entitled to point out, Mr.
I never said
Sir,
that.
you are entitled to point out
I have
whatever wrong.
stated that both party has challenged the DM order, Lordship. But matter related to easement right.
I have stated easement
No,
right.
he is entitled to argue in his own way, Mr. Please don't disturb like that.
Lordship, 107, Lordship.
Yes, 107.
Lordship, third para. Learned counsel for the petition has taken this court to annex P6 to the writ petition, which is a letter issued on behalf of the district magistrate Uttar Dinajpur on 17 October 2022 to the subdivision officer Islampur, Uttar Dinajpur, requesting the letter to make inquiry and take necessary action pursuant to a petition filed by the present petitioner on 6 October 2020.
Your allegation was, their allegation was against the authorities who are trying to make a pathway.
Lordship, that we are obstructing their pathway. That is the thing, Lordship. And thereafter, Lordship,
So their allegation was that respondent authorities are trying to make a pathway through the land of the petitioner, Mrs. client,
Lordship,
without acquiring the same by due process of law. That was the allegation.
that is the allegation. And Lordship, thereafter, they have, the matter was decided to.
That was directed to be decided. So allegation was against the respondent authorities,
Lordship,
not against the villagers.
Lordship. Now, Lordship, page 117, the final order, the order on a challenge.
You are not a party there.
No. First edition, I was that party. No?
No.
We are not a party.
Very good. Second writ petition filed by them.
Both parties have filed this.
Second writ petition was against the DM's order.
DM's order. We have also agreed. They have also agreed against the
DM order is at
Lordship,
page
DM order
114.
page 2034. 234.
114 is something else.
Lordship, 114 not DM order, Lordship. 234.
What is 114 then?
Lordship, DM order, I think
both
twice it has been annexed.
What is the date of the order? Tell us, then we'll follow chronologically.
Lordship, this is the DM's order, Lordship.
Very well, follow from here. Yes.
Lordship.
You just
DM's order, Lordship. Received a copy, Lordship, first prelude, Lordship.
Yes.
Lordship, the second para, third. As per representation of the SDO, Islampur called him in the chamber of BDO G2 on 15/10/2024 and seek NOC for construction of a metal road across ILR plot number such and such, such and such, such and such, or Mouja such and such. On being asked by the undersigned whether there is any official document in support of his claim, the petitioner admitted that he was not provided with any written document which confirms that any such government project is being taken up or has already been taken up. But he has filed an appeal being such and WPA number such and such before the Honorable High Court, Calcutta, against the state authority in apprehension of grabbing of his land without requisition. As per written statement of SDO Islampur, the petitioner filed one petition for execution of the order passed by the learned RO for deletion of Borga under section 220B of WBLR Act 1953, which was affirmed by the appellate authority with an order passed on case number such and such. For this petitioner and the Borgadars concerned were called for hearing on 31st October 2023, such and such date. At the time, reports were called for from DMDC and BLNLRO concern. On meticulous scrutiny of those reports, it was revealed that there exists an earthen pathway across LR port number such and such, same part number, Lordship. Uttar Dinajpur held by the petitioner by LR Khutian number 550, and the same is being used by the villagers since long. During these proceedings, one public petition was also received to consider a proposal for construction of a metal road on the same pathway. Therefore, SDO Islampur called for a development meeting at the chamber of BDO Chakulia in public interest, where the petitioner was invited to discuss over the public petition. But he did not give any NOC for taking up any such scheme. As per report of SDO submitted during hearing of this proceeding, the land is lying vacant with a earthen pathway which is being used by the villagers since a long time. Also, it has been submitted that there is no plan to take us up a construction of any metal road from the end of the any government body, and hence there was no question of acquisition purchase of the said land schedule. As per report of the DMDC, there exists an earthen pathway over the plots in question which connect the main road with Uttar Rampur village, and it is being used by the villager for last 20 to 25 years. He also reiterated that there is no such project under any scheme to execute. As per report of the BLNLRO, the plots in question are recorded in the name of the petitioner, White LR Khutian number 550. As per physical inquiry, there exists an earthen pathway across the plots in question which is being used by the villagers of Uttar Rampur village. Again, on being asked by the undersigned whether he has any doubt, the petitioner being satisfied that he has now no complaint over this issue. Thus, the order dated such and such of molecule Kolkata passed in WPA number is duly complied and the representation of the petition is disposed of. So, Lordship, the two things are there, Lordship. First, they have stated that there is no project
recorded in their name, but earthen pathway is there.
Earthen pathway is there, and they are using for 20 to 25 years. Villagers are using.
So why did you challenge?
Lordship,
why did you challenge this?
Lordship,
it holds earthen pathway is there.
We have challenged.
They might have had some cause of action, but we'll come to that later.
We have challenged on the ground that there is no plan to construct a metal road. The submission, we have challenged that also, Lordship.
There is a plan, you say, to construct a metal
because road. Lordship, they have caused inspection, and there is no as such order comes from that inspection report that they are not planning to do that, or they are rejecting this.
No, there cannot be a negative report. If they have a plan, either they have a plan or they don't have a plan. They say there is no plan to take up any construction.
The inquiry was caused, Lordship.
But how can you have a cause of action on that? You have no locus standi on that.
Lordship, because
if the government has a plan to build a metal road on his land, he may be aggrieved.
We have submitted one representation, which was.
What can the DM do on your representation, Mr. Paul? You can approach a civil court and get a decree of court, as you rightly said. But DM could not, because DM, entire conspectus of DM was, you don't have a right at all. He made a complaint. His representation was considered. His complaint was, government authorities are trying to build a road over that.
Villagers made one petition, Lordship, that has been held. Villagers also submitted one representation, Lordship, that has been.
But that representation, under which provision of law can that be decided? Suppose his representation can be, because he's recorded as a Borgada.
Lordship,
his name, that recording has been upheld up to the appellate court as per this order.
Lordship,
he wanted an execution of that. That matter was referred. He said, I sought to execute, but I see that the government is trying to build a road over there. Government denied, we are not making a road. So his representation is decided in that. But you as villagers claim an independent right. We made a prayer before the DM. But DM does not have the locus standi to the jurisdiction to pass a decree.
Lordship, DM has
DM
not,
cannot say either way. It's
DM never entered into that matter, Lordship.
But DM doesn't have the locus standi, the jurisdiction to enter into any matter.
Lordship, the single just
what can the DM do at best?
I
Hold
got
that
your
there
Lordship
is a
point. Lordship, that is why just Lordship I first started. that
approach a
it's
civil court will
it's
give you
his
liberty. And
But Lordship, what's the single bench held? Lordship, can you turn page 117?
Your fault. You approached and
No,
invited
both-
something.
But Lordship, I was
Rightly done. Whatever done, rightly done.
I was not there. Lordship, page 117.
ভূতিনদার ক্লায়েন্টকে ওখানে ইমপ্লিট করে সিভিল স্যুট করতো, তাতে কাউন্টার ক্লেম থাকতো। দ্যাট ইজ অলরেডি বর্জনের উপর রিপোর্টিং রয়েছে। Yes.
Lordship, paragraph 4, Lordship. At the time of hearing, Mr. Roy, learned advocate appearing on behalf of the writ petition number 23065,
Yes.
that means Shubhendu Dubey. It is submitted by Mr. Roy that it is a specific case of the writ petitioner Shubhendu Dubey in WP number, that he is the absolute owner of the LR plot
Shubhendu
number.
what? Dubey.
Shubhendu Dubey. I have not committed any mistake right now. Such and such, Uttar Dinajpur, Chakulia, Uttar Dinajpur. It is further contended that it is the further case of the writ petitioner that the above mentioned plots of land are now recorded in the name of the writ petitioner. That is
Shubhendu Dubey is Mr. Rai's client.
Yes. And the said Shubhendu Dubey is in lawful occupation of the aforementioned plots of land. It is further argued by Mr. Ray that some undesirable person of the society who are the petitioner in WPA number 24582 of 2024 or their associates made an attempt to encroach the aforementioned plots of land of the writ petitioner Shubhendu Dubey, and they have also made an effort to create a pathway over the aforementioned land of the writ petitioner. Lordship, can you see that there is an allegation
Yes.
against
Against.
but they are not made party. You are not paid party, Lordship.
Apparently, they go beyond the DM's order.
Lordship.
Anyway, let us see. He'll have his right.
It is further argued that it is the further case of the writ petitioner that finding no other alternative, the writ petitioner approached various state authorities for ventilating his grievance, and since the grievance of the Shubhendu Dubey was not entertained, the said Shubhendu Dubey had approached the High Court by filing such and such, wherein a coordinate bench of this court by its order dated 22nd May 2024 directed the respondent of 4 authority to consider the representation of the writ petitioner in accordance with law. At this juncture, Mr. Roy took me to the order dated 18/6/2024 as passed by the respondent of 4 authority, a copy which has been annexed at page number such and such page. It is submitted by Mr. Roy that the respondent of 4 authority, while considering the representation of the writ petitioner in course of hearing, came to a specific finding that the above mentioned LR plot numbers are recorded in the name of the writ petitioner, and the writ petitioner Shubhendu Dubey is in settled possession of the same. It is further argued by Mr. Roy that by the same order dated 18/6/2004, the respondent of 4 authority most surprisingly came to a finding that there exists an urban pathway across the above mentioned land of the writ petitioner, which is being used by the villagers of Uttar Rampur as villagers. Same thing, Lordship. It is submitted by Mr. Roy such finding of the respondent number 4 authority is completely faulty inasmuch as at no material time of the writ petitioner above mentioned land was used as a pathway by the villagers. Lordship, she has challenged that the villagers never used the pathway.
Recording was challenged.
Lordship, that recording was challenged, Lordship. On the contrary, without making ourselves as a party. On the contrary, it is the case of the writ petitioner Shubhendu Dubey that after deletion of the name of Borgadar under section 20B of the West Bengal Land Reforms Act 1955, some co-villagers who were the writ petitioner in WPA number such and such and their associates forcefully entered into the aforementioned property of the writ petitioner and dumped huge quantity of mud to show that a portion of the aforementioned property is being used as a pathway. It is submitted by Mr. Roy that appellant reliefs may be given to the writ petitioner in terms of the pair made in the instant writ petition. In course of his submission, Mr. Rahabar, learned advocate appearing on with the writ petition number, our writ petition, Lordship, contended that the finding of the respondent for authority in WPA number 22 why this order dated such and such is absolutely faulty in as much as from the material placed before this court in WPA 2458 of 2024. It would reveal that there exists a village pathway over the above mentioned plot of land for a considerable length of time. In this submitted by Mr. Rahabar that the order dated 1860 as passed by the judicial investigating magistrate, that is in WPA number may be set aside. On being asked by this court, Mr. Rahabar, however, could not substantiate a filing any documents whatsoever as to how the writ petitioner in such and such have got a right of user of alleged pathway over the property of the writ petitioner. Lordship, user right, the court has entered into that. About the user right, Lordship. On being asked further by this court, Rahabar could not produce any documents of title of the writ petitioner in such and such over the property of Subhendu Dubey, nor he could produce anything to substantiate that the writ petitioner in WP number have even an easement right of pathway over the property of the writ petitioner in such and such Subhendu Dubey. In fact, in Sabra, there is no pleading to that effect. Lordship, the writ court insists us to enter into the easement right pattern. Learned advocates appearing on behalf of the respondent state and its instrumentally submit before this court that in absence of any
Yes, Mr. Pal, please.
it means that have even an easement right of the pathway failed to establish that even we have easement right over the pathway.
Produce no documents, nothing.
Lordship, easement right, not only documents, Lordship, it requires evidence also.
Evidence. But you invited the court to do this.
Lordship,
you invited the court.
We have not mentioned here that easement right. We have using this pathway. And the court has
in your writ petition, what was your prayer?
Writ petition, page 240. Lordship, 1 minute, Lordship. Next page. কত page? Lordship, page 21 onwards, Lordship, and prayer is 39. We have not prayed for or asked for any direction that we have that easement right.
No, but what was your locus standi to say this? The authority said they had no plan to make a metal road.
That is true, Lordship.
So how can you, even if you have an easement right, how can you be affected by this?
The submission I have made from the order,
of
Lordship.
The state, Mr. Pal, whether they have a plan.
Lordship, I fully agree. But Lordship,
writ petition was not maintainable.
Lordship, if Lordship go through this order, Lordship, then the petitioner, the appellant, was the necessary party. But they refused to add the party.
But you did not challenge that order.
No, Lordship, as because we have filed that petition, that has been entertained.
And that was taken up along with this. So therefore,
that is the thing. But Lordship, easement right.
No, you had your right because the purpose of addition of party is to ventilate your grievance.
Of course,
so you had that opportunity, you had ventilated.
We have given that. But and Lordship, we have not paid for easement right, Lordship. Easement right come from the court, Lordship. That even we have not produced any documents to prove our easement right. Lordship, my humble submission only not only documents, Lordship. Evidence is required to prove easement right also. This is my humble submission. Maybe I am wrong, Lordship. Lordship knows better than me in this subject, Lordship. And Lordship, next, learned of the respondent.
At the practical level, you know better than.
Submit before the court that it's in absence of any material irregularities on the order dated 8/6/2020 as passed by the judicial district magistrate, there is hardly scope.
Two things. One is this writ petition is not maintainable. Absolutely, these players are ridiculous. You cannot seek a mandamus upon the state to immediately sanction a scheme for constructing a metal road.
I have stated them.
So this is not maintainable. You may be aggrieved with the court, writ court going beyond its jurisdiction. We may at best, subject to hearing Mr. Roy, say that these findings would not be conclusively determining your rights because this was delivered by a writ court and these are tentative. You have a right to file a regular civil suit claiming your rights if you have any. That is one aspect of the matter. Secondly, now the 5 lakh is also another thing.
Lordship, that has been stated by
5 lakh will also consider because in your favor, subject to hearing Mr. Rai, because 5 lakh, because your writ petition might have been a bit frivolous because you asked for a direction on the state to sanction a plan for building a metal road. But that was not the ground on which cost was imposed. Cost was imposed on the ground that you have made out of flimsy ground, having no right, title, interest, or whatever in the property. But that probably could not be gone into by the writ court, whether you have a right, title, or interest.
That is my point.
Writ court should have dismissed your writ petition, saying that you don't have no locus standi. This writ petition is not maintainable because it's a policy of the state. That can be the best relief we can give to you, again subject to hearing them. And this mud, now Mr. Pal, whether mud or not, whatever, the DM order still remains, which says that they have been recorded as a Borgadar. They say that this order has been affirmed by up to the appellate authority. They seek an execution of that. Till they are recorded as a Borgadar, pathway or no pathway, mud has to be removed. We cannot interfere with this portion also.
Lordship has not interfered.
So let us hear, Mr.
There is no mud right now.
Because
Lordship only.
If you say that you have dumped the mud, then I mean,
no, Lordship.
Then 5 lakhs
Because
of the
they have mentioned that they have stated that the honorable single bench directed
mud to be removed.
Lordship, and so Lordship has not injuncted that portion, Lordship.
But that is to be recovered from you.
Lordship, that is why 5 lakhs, Lordship.
No, over and above.
Lordship, we have not
come to para 18. Of
Lordship, we have not termed that mud, Lordship. That is my sole contention. Because Lordship, when we are using the pathway, why we should dump the mud? Because it will obstruct us, Lordship. And Lordship, one thing, Lordship, the single bench, of course, Lordship, our locus standi will come, Lordship. The single bench observed that the entire property, the private respondents have the absolute right. This is not that, Lordship. We have annexed the map, Lordship, to show that some property Borgade is separate person. They have not challenged. They have not come to the road. 4 plots are there on the road, Lordship. Petitioner is absolutely one for one plot, and another plot there are several owners are there, land owners are there, and another plot Borgade is separate person. But the honorable single bench held all the plots belongs to the private respondent. Lordship, that has been, I have annexed that, Lordship, that chart, Lordship. Lordship, come what may, Lordship, what Lordship falls from Lordship. That is,
let us hear, Mr. Rai. Yes, Mr.
Before Lordship, the single judge has relied on a report of the police. My Lord, kindly take the trouble to see first. Why?
Which page?
It is a part of my application.
What is the page number? In there can
I think 268. Lordship kindly sees. Admittedly, my Lord, 2 writs were filed. Admitted position, all these documents were before a court for its adjudication.
Before a writ court.
Even then, writ court. Lordship kindly see, this is a part of the. And another thing, my Lord, I should refer.
Yes.
Another order, the 18/3/2025, 18th March, my Lord, passed in. Before that, my Lord, Lordship kindly.
Police report first.
Police report first.
Yes.
260. This particular document has been relied upon the single judge in adjudication.
Regarding mud.
Everything.
Everything. Very good.
Subject. Have you got it?
Yes.
Report regarding serious tension prevailing over lands disputed as.
Mr. Rai, instead of reading the entire thing, you can highlight the portions which you. First of all, police does not have the locus standi. Police is not a civil court. Police cannot decide there is a long-standing legal.
You know, what happened, my Lord? I am owning a plot. There were certain Borgadars. That Borga dispute protracted for 20 years.
You are recorded as a Borgadar.
No, I am the owner.
You are the owner.
I am the owner. Under me, there are certain Borgadars.
Yes.
In due process, I wanted eviction of the Borgadars. A process was going on for 15 years about. Through execution, names of the Borgadars were deleted. Now, admittedly, it is a Borga land. it is a land used for cultivation. Its process is going on for 15 years. Ultimately, when I got rid of the Borgadar by process of law, not that, up to appeal, all these things, reports are there. At no point of time, no authority could found that there is a pathway over which villagers are going on.
For the first time before the DM, this report came and
I would be showing to you, Lord, this is absolutely purpose report because contrary to the reports of the year, if a land is cultivable land, the question of raising any pathway over the same cannot arise because it is the finding of the authority. It is a cultivable land. There are Borgadars in due process. It has to be evicted. I have opted for it. I protected this litigation for 15 to 20 years. Then all on a sudden, I have overcome all these things because some persons saying that they are snake catchers, saying all these things, they are all for vested interest. Certainly, they entered into my land, created a pathway. I reported to the police. Then I reported to the DM. I reported to her because a person has a right to hold this property. It is a constitutional right. I will be showing the judgment of the Supreme Court said
300 days there.
Yes, 300 days there. And very recently, Supreme Court also passed an order. Yes, a person is not remediless. Not that in all the cases he had to approach the civil court. I had been to the DM. I had been to the SP. Then DM passed an order to hold an inquiry. This is not the police himself.
What was the relief you sought before the DM, Mr. Rai?
I sought before the DM.
Execution of that.
Two things. Number one, that I am the lawful owner. Lordship, kindly, I will show it to
No, the relief, what remedy would the DM give you?
I sought that without acquiring, without requisition, because you cannot include this land for the purpose of any pathway. If you want to do it, make a process of acquisition, requisition. Then I said that I have been invaded. I have been invaded by someone. Some persons. A mob entered. Lordship, kindly see, by political influence, that is recorded in the police report. That police report is the basis of DM's observation. DM asked the police to give a report. On the basis of this, that's why Milord Court has seen it. Then police has passed a report. That report.
DM took a report from the BLL.
DM took a report from the police. Through SP, it has been.
BLL.
BLL also. Subsequently, Milord, subsequently.
Yes.
Initiation, Milord, because of this report was, this is not that I made a complaint, police. This has been to the SP.
On the direction of the
DM. DM asked through SP, this report has been. This report clearly says that I have been.
Mud over your land.
Not only that, Milord. Present conflicts in the how I acquired land, all these things are there.
Police cannot have any say on that. Police is not an adjudicator.
Police can give a report.
Police report is not.
Police can report.
Legal dispute, police report.
No, I am not saying so. Legal dispute. When the authority, I sought for a relief before the authority, or authority asking the police to give a report, then police can give a report. Police on his own doesn't give a report.
But police report is not sacrosanct, does not.
I am not saying so.
Does not create any right.
I am saying so. Police report cannot be brushed aside. My side, if Lordship thinks police report is not sacrosanct, other way I can submit. Police report cannot be brushed out. Police is the authority. And that authorization of the police comes from the
authority under which law for doing what?
Any person.
That are law enforcement agency only.
No. They can give a report. I am not saying. They are not evicted.
BLLR report we can understand. BLLR is an authority under certain acts.
Lordship, suppose
BLLR is a revenue officer, Mr. Rai.
Revenue officer for the purpose of land. But when a person makes a complaint to the authority,
law and order situation, police can give a report.
Yes.
This is not in 144.
I am not asking for what I present situation. I lost a complaint to the DM. DM asked through SP asked the police to give a report.
Yes.
It is not that police has given on his own.
That we have repeated, we have understood, yes.
Then, Milord, Lordship, in the meantime, when the Page 269. I am skipping all these things. Background.
So
How?
269 present conflict you have read twice.
No, I have not read at all.
I have read twice. So you can highlight your portions.
Yes.
We have found two things in your favor squarely, apart from the other things. Some local people of Uttar Rampur, Bhattiarpara have forcibly started dumping mud over the suit plot of land for constructing a road for their walking. This has created a tension. This is one aspect. Second, next paragraph, police have inquired the matter locally and restrained the public from further entering into the said disputed land and dumping mud. So it's very clear, and ruling party's leaders is also there in the next, as you said.
Yes.
So therefore, these two, three things are there. Police has said land is recorded in your name. Local people have forcibly started dumping mud and to try to carve out a way for walking.
Yes.
And that police have inquired the matter locally and restrained the public from doing that. So this is evident from the police report that some miscreants are dumping mud over your property.
Yes.
Clear from this
Therefore,
report.
three things, my lord.
Accepted.
I am
Accepted.
owning a land.
Court rightly, the writ court rightly accepted this and directed removal of the mud also.
Yes.
Yes. But then, how could the court, writ court, Mr. Rai, hold that these people, these writ petitioners in the other writ petition, they are the people who dumped the mud? There is nothing of that sort in the police report, one. Secondly, for that, either a criminal inquiry or a civil inquiry should have been undertaken. So they cannot be imposed with a cost for removing the mud.
That's true.
That part. Second part is, which we are contemplating, you give your answers in your own way. Regarding your other part, your grievance, we agree with you. Regarding costs, 5 lakh, the premise was that they have been able to they have failed to prove their easement rights. Easement rights, Mr. Rai, cannot be.
Court not said.
You come.
Court not said so.
No.
Court
but,
said, my lord, before that, my lord, that's why I was trying to impress upon lordship to
Yes.
see the previous order dated 18th March 2025.
Yes.
Passed in analogous matter, my matter.
Yes.
By the coordinate bench, single bench.
Where is that? Justice Taparuddha Chakraborty.
A person should come to the writ court.
The Justice Taparuddha Chakraborty.
No. It is the order of Justice.
It's annexed here.
Aniruddha Rai. It's part of record. It should be over the.
Which part? Which page?
Page. It is not annexed.
In this appeal.
In the appeal. 18th March 2025. Not in original appeal. To analogous matter.
We don't have
Addition of party rejected. That order I want to rely upon.
Rely on it. We don't have a copy of that. That is what we are saying.
That's I have only one copy.
What was held by Justice Rai?
Justice Rai that he have no right. That has been dealt with by Justice Rai. Completely. What right they have got?
Mr. Rai, the writ court could not decide on their rights or your rights conclusively. Your rights we can appreciate from the records of rights. You have a right. That's on a different context. But whether they have an easement right or don't have an easement right, see para 20 of the impugned order, page 124. Please come there.
This part, Lordship kindly sees.
We will. But before that, since the writ petitioners in WPA, their writ petition, have approached this court for exercising high prerogative writ jurisdiction of this court on a flimsy ground having no right, title and interest over the property. Shubhendu De in such and such. This court imposes a cost of 5 lakh each. 5 lakh each upon each of the villagers, Mr. Rai. This is cruel. To say the least, 5 lakh each on the villagers because they claim easement right. And writ court holds that their ground is flimsy ground having no right, title, interest. That is the premise that they don't have right, title, interest. That's why it has been held to be flimsy, and one villager per head, each villager will pay 5 lakh cost. They'll have to sell the land for that, Mr. Rai. We'll set this aside. This portion will set aside. Removal of the mud will be there. They won't pay for that. The state machinery will pay for that because they failed to give you protection. Mud will be removed and you have your remedy otherwise. And we also will hold in your favor that this easement right, whatever, although writ court could not conclusively determine, similarly, the BLRO report, neither the BLRO report, this goes against Mr. Rai, so please, Mr. Pal, neither the BLRO report, nor the DM's findings, nor the writ court's findings could conclusively determine whether there is any pathway or anybody has any easement right over that. That is the subject matter domain of the civil court. If anybody has a grievance, one can go to the civil court and claim that right. But that will not have any effect on either your right or they are right or whoever else is right. Because DM does not have the authority to decide. You are aggrieved with that portion of the DM's order where it has been held that on the basis of the BLR report that there is a pathway. We'll say that is not conclusive against you. That is not conclusive. That finding is not conclusive. DM's observation does not operate against your right, whatever legal right you have.
No,
Because BLRO cannot decide whether there is a pathway or not.
no,
There is-
what is the fate of a person if a person
No,
has-
your rights remain.
No, Lordship kindly sees this position another angle. What is the position of a person if a person having a land, admittedly Borgadar was.
No, you have got your relief. You have got your relief. From the writ court, you have got your relief. Mud is being illegally dumped, that has been directed to be removed. And it has been held that the plot is recorded in your name. There, Mr. Paul has some problem that it entirely not in your name.
Entirely my name.
But
But
we won't go into that.
No, Lordship kindly sees. I have annexed the document.
We will not set that aside. We will not set that aside, Mr. Rai.
Lord, I have relied upon document. Document says I'm
We are not saying anything on that.
It is recorded in my
So
name.
therefore, all your remedies which have been given to you remain, but the cost imposed on them and these findings on easement and all, we'll say that the writ court could not conclusively determine easement right of either party.
And I am not asking for easement right.
They are asking for easement
Then
right,
his right cannot be
conclusively determined.
I have not prepared appeal.
So we are passing that order. We are
Lord.
disposing of the appeal, Mr. Rai.
Yes.
We are giving you the indication. We are both of you. Please just listen to us. What we'll do is we'll dispose of the appeal. Will not interfere with any other portion of the order. We'll say three things. One, that the writ court's finding on their having or not having any easement right, that is not conclusive, and it is open for any, including them, any party to go before a civil court to agitate such rights. These will not be conclusive determination of their rights. One. Secondly, removal of mud remains. They won't pay because it has not been conclusively proved before the writ court by any evidence whatsoever that these writ petitioners have dumped the mud. The mud will be removed. The state machinery will remove that because they have failed to provide protection to you, in whose name it is recorded. And this 5 lakh will definitely set aside.
No, 5 lakh.
5 lakh each villager.
5 lakh, my lord, so far my right, my lordship.
No, your rights remain. Whatever else is in the order remains. Because your right has been already declared by the DM himself. And one other thing in your favor, that the DM's recording of there being a pathway, that is not conclusive. That does not prove anything. That does not affect your rights, whatever legal rights you have, adversely. We'll say that also.
Other part will remain cost.
Everything else will remain. 2 cost portions will go. Conclusive nature of easementary right finding will go. And will also hold that the DM's finding that easement, that there is a pathway, that is not conclusive. That would not affect your legal interests in any manner.
Yes.
Because that was your grievance before the writ court.
Yes.
The present appeal has been preferred against, purportedly by certain villagers against an order passed by the learned single judge, whereby 2 writ petitions were disposed of simultaneously. Full stop. One of the writ petitions bearing WPA number 11772 of 2024 was filed by one Shubhendu Dubey, who is represented before us as one of the respondents in the appeal. Full stop. The other appeal was filed, the other writ petition was filed by the present appellants. Full stop. The genesis of both the writ petitions was an order dated June 18, 2024, passed by the district magistrate and collector Uttar Dinajpur, Karnojora. Full stop. Next para. The said Shubhendu Dubey had previously moved the writ court complaining that the representation given by the said Shubhendu Dubey was not being decided by the district magistrate. Full stop. The said Shubhendu Dubey apostrophe's name was recorded as the owner of the disputed plots of land. Full stop. Initially, there were Borgadars on the said land against whom eviction was obtained by Shubhendu Dubey. Full stop. However, despite the same, the said orders in favor of Shubhendu Dubey were not being implemented, giving rise to the representation by him to the district magistrate. Full stop. Next para. The writ court, initially by a learned single judge and thereafter by a division bench, directed the district magistrate to dispose of the representation, ultimately resulting in the order dated June 18, 2024. Full stop. The district magistrate, in the said order, relied on a report which had been obtained, on reports which were called for from one DMDC and BL and LRO concerned. Full stop. On scrutiny of the reports, the district magistrate held, inter alia, that there was a pathway on the concerned plots which was being used by the villagers since long. Full stop. Next para. However, the district magistrate also observed that contrary to the apprehensions of Shubhendu Dubey, there was no plan on the part of the governmental authorities to take up any construction of metal road over the concerned plots of land. Full stop. Next para. It was recorded by the district magistrate that as per the report of the BL and LRO, the plots in question were recorded in the name of the petitioner, that is Shubhendu Dubey. Full stop. Next para. The present appellants preferred the writ petition by claiming that it was the incumbent duty of the government authorities to sanction a plan for building sanction a scheme for taking steps to construct a metal road over the plots in question. Full stop. Next para. On the other hand, Shubhendu Dubey preferred his writ petition complaining of the observation and finding in the district magistrate's order to the effect that there exists a pathway which was used by the villagers for long. Full stop. Next para. While deciding the said writ petitions, during pendency of the writ petitions, the present appellants had taken out an application for addition of party in Shubhendu Dubey's writ petition, which was dismissed by a learned single judge. Full stop. Such order of dismissal, according to learned counsel for Shubhendu Dubey before us, was never challenged by the present appellants before any appellate court. Full stop. However, learned counsel for the appellant submits that since the appellant's writ petition was also taken up and clubbed together for hearing with Shubhendu Dubey's writ petition, no further appeal was preferred against the refusal to add the appellants as a party to Shubhendu Dubey's writ petition. Full stop. Next para. By the impugned order, the learned single judge came to arrived at several conclusions. Full stop. Inter alia, it was observed that no proof was produced from the end of the appellants, that is alleged local villagers of Uttar Rampur village, to establish that there exists an earthen pathway across the disputed plots of land and or that they have any easement rights over the said property. Full stop. In the same breath, the learned single judge observed that the respondent number 4 authority practically admitted the right, title, interest and settled possession of the said Shubhendu Dubey in respect of the LR plots in question. Full stop. Next para. While holding so, the learned single judge relied on a report filed by the local police authorities, before the district magistrate, from which it transpired that certain miscreants had dumped mud over the plots of land of Shubhendu Dubey for the purpose of using the same as a path. Full stop. Next para. On such premise, comma, the learned single judge directed the removal of such mud. Sorry. Not full stop. Not stopping there, comma, the learned single judge observed that the cost of such removal have to be recovered from the present appellants, comma, that is the local villagers. Full stop. Next para.
Lordship, cost to be required from the state.
Please come to page 124, para 18. Full stop. Next para. The learned single judge further observed that the present appellant had approached the writ court for exercising high prerogative writ jurisdiction on a flimsy ground, comma, having no right, title, and interest over the property of the writ petition. Writ petitioner Shubhendu Dubey in WPA 23065 of 2024, comma, for which the writ court imposed cost of rupees 5 lakh each upon the present appellants. Full stop. Half of the same was to be paid to Shubhendu Dubey, and the remaining portion was to be deposited to the office of the State Legal Services Authority. Full stop. Upon a careful consideration of the contentions of the parties and the materials on record, we find that the rights of Shubhendu Dubey as owner of the plots in question has been fairly established from the records of rights and other relevant material. Full stop. In fact, comma, the observation of the district magistrate that there is an earthen pathway over the said plots cannot have any conclusive bearing, comma, since the district magistrate is not a civil court, and the findings of the district magistrate in that regard on the basis of the BL and LRO report cannot have any adverse effect on the legal rights of Shubhendu Dubey, which the said Shubhendu Dubey otherwise has in law. Full stop. Next para. However, comma, insofar as the findings of the learned single judge in the impugned order regarding the lack of easement rights or other rights in respect of the plots of the present appellants, comma, we cannot but observe that it is beyond the jurisdiction of the writ court to come to any conclusive finding as to whether a person or a group of persons has or has not any right of easement. Full stop. Declaration of such right comes squarely within the domain of a competent civil court, comma, which upon taking evidence can decide such issue conclusively. Full stop. As such, comma, we hereby observe that the findings arrived at by the learned single judge in the impugned order regarding the lack of easement rights of the present appellants is not conclusive and or binding on any of the parties, and it will be open to the present appellants to approach a competent civil court for canvassing such rights, comma, if any, comma, before such court. Full stop. If such an approach is made, comma, the appellant shall not be prejudiced in any manner by any of the observations made in the order impugned herein. Full stop. Next para. Also, comma, as a natural corollary to the above observation of ours, comma, the imposition of costs of rupees 5 lakh per head on each of the local villagers, comma, who are the local appellants, comma, is disproportionate and not commensurate with the rights claimed by the said appellants. Full stop. In any event, comma, imposition of such a huge and prohibitory cost would negate, would deter villagers who are otherwise marginalized, comma, from seeking their legal remedies before a court of law. Full stop. That apart, comma, since we have already held that the writ court could not conclusively come to any finding as to whether the appellants had or had not easement rights or other right, title, or interest, comma, such findings of the writ court could not be the premise of imposition of costs on the appellants merely for filing the writ petition. Full stop. Next para. We could still have understood if the learned single judge had observed that the writ petition was frivolous since the relief sought against the state authorities was a matter of policy. Full stop. However, comma, the premise of the imposition of cost was solely that the appellants having no right, title, and interest over the property of the writ petitioner, comma, preferred the writ petition, comma, which was beyond the domain of the writ court to decide. Full stop. Accordingly, MAT 1671 of 2025 along with Can 1 of 2025 are disposed of, thereby setting aside the portion of the impugned judgment of the learned single judge dated September 16, 2025, passed in WPA 23065 of 2024 and WPA 24582 of 2024, comma, to the extent that the cost of removal of mud was directed to be recovered from the present appellants. Full stop. Instead, comma, the cost of removal of such mud shall be borne by the law enforcement agencies of the state, comma, which failed to give protection to Subhendu Dubey from such mud being deposited in the first place. Full stop. It is expected that such mud shall be removed at the earliest. Full stop. Next para. Moreover, comma, we modify the costs of rupees 5 lakh each upon the present appellants, that is the writ petitioners in WPA 24582 of 2024 as observed in the impugned order. Full stop. Next para. However, comma, it is made clear that the rest of the order is not interfered with on merits. Full stop. No orders to cost urgent settlement.
One thing is, Lordship, not on order, Lordship. Why, Lordship, you have stated that not the writ court has not given appropriately order passed that order, Lordship. Initially, first writ petition is preferred division bench or against the order that we have our prayer for adding party was refused. The division bench observed that, held that we are necessary party, so we have to add other party in the first writ petition. Even then, in second round of litigation, the learned single judge refused to add as a party.
No, but that was not the subject matter here.
No, Lordship, that is
because Mr. Pal, simply because you have not challenged the order of.
If you are added the party.
No, we have recorded that Mr. Rai has contended that you have not challenged the order of refusal of your addition of party here. And if you had challenged, that would be a good ground in that appeal. But you have not challenged, that remains.
That is true, Lordship.
Otherwise, you might have had a good case, but you did not prefer a challenge, so what can be?
Lordship, that is the non-application of mine, Lordship. That I am just canvassing the non-application. There is an order of the division bench. Even then, they refused to add my
cited and appeal preferred. 1 minute.
They have not done so.
Thank you.
Lordship, civil court will not influence by the reports and